Good afternoon, everyone. Hereby convene this meeting of the Government Administration and Elections Committee, and hereby recess this meeting of the Government Administration and Elections Committee while the respective caucuses are caucusing and there's meetings among the chairs and rankings. We will plan to be back in roughly 30 minutes or give you an update. Good afternoon, everyone. Thanks for sticking with us. We'll hereby reconvene this meeting of the Government Administration and Elections Committee just for everyone's safety purposes. I'll just ask you to note the location of the exits in this hearing room. There are two doors through which you enter the room. There are emergency exits and they're marked with exit signs. In this event of an emergency, please walk quickly to the nearest exit. After exiting the room, go straight and exit the building by the main entrance or follow the exit signs to one of the other exits. Please quickly exit the building and follow any instructions from the Capitol Police. Do not delay and do not return unless and until you are advised it is safe to do so. In the event of a lockdown announcement, please remain in the hearing room, stay away from the exit doors, and seek concealment behind the desks and chairs until an all clear announcement is heard. All right. Any remarks by the chairs? Seeing none. Rankings? You'll have plenty during the bills. Moving to item agenda Roman numeral 3, bills and resolutions for final action. First up on our agenda, we have item number 1, SJ 37, resolution proposing an amendment to the state constitution concerning environmental rights. This is a JF to the floor. Chair will entertain a motion.
So moved.
Second.
Moved by Senator Flexer, seconded by Representative Gauthier. Senator Flexer.
Thank you, Mr. Chair. Mr. Chair, the proposal before us today is a resolution that this committee has viewed several times in the past. It will allow the voters of Connecticut to consider an amendment to our state's constitution to protect environmental rights in our state. It will, I think, be a really important step for Connecticut to take to ensure that no matter what the makeup of the state legislature is, the makeup of the governor's office or other public offices, that people in Connecticut can be confident that their right to a clean, accessible environment will be protected with decisions that are made by the government. Mr. Chair, this committee, as I said before, has supported this measure, and I know that the movement in Connecticut in terms of folks who want to protect our environment and have Connecticut stand up and have the strongest protections we could have in place for our environment has grown in the time since this committee has started debating this resolution, and I'm grateful to the people in Connecticut who have been working to advance this resolution, and I'm hopeful that this committee will have a similar outcome today where we stand up and say that the people of Connecticut should have the opportunity to decide if environmental rights should be enshrined in our state's constitution, as so many other rights are enshrined in Connecticut's constitution. Thank you, Mr. Chair.
Thank you. Thank you, Madam Chair. Further remarks from the committee? Senator Sampson.
Thank you, Mr. Chairman. I appreciate Madam Chairman's description of the bill that's before us. Just want to say a quick word before I get started on debating the bill, which is I want to express my dissatisfaction publicly about today's agenda containing 52 items and the lack of time that was granted to the minority party to review this language. I do appreciate the chairs giving us a couple of additional hours today to take a look at this. But as you can see from looking at my desk, this is a lot of information to get through, and I just think it's a disservice to the people of Connecticut when we are not afforded enough time to go through these bills. I would say this very first bill that's on this agenda would warrant an entire legislative session itself worth of debate, and we are going to clearly limit that substantially if we are going to get through even a portion of this agenda today. And in my view, that is a direct result of what I would only describe as arrogance from the majority party. And I want to just couch that in the terms that I have great respect for my colleagues. And I just think that what's happened is over time, this majority has become so accustomed to business as usual and so comfortable in the way they operate with utter disregard for whether the minority has the chance to review information or they have the opportunity to have their voices heard or have their amendments properly considered, etc. That that's just a matter of course for them. I get along very well with the chairs, and I don't want to harm that relationship, but I will say that it is symptomatic of this entire Connecticut state government, and particularly this legislature, that very, very rarely is there real debate on the substance of these bills to the degree that I think people back home would expect and is certainly warranted. I'll get right into this first bill. I appreciate the chairman's comments about protecting the environment. I think everyone in the sound of my voice, certainly my colleagues around this room in both parties, all care about the environment. If you hear anything to the contrary, don't believe that. That's a bunch of nonsense. It's made for political division and to create factions that hate each other, frankly, for the benefit of politicians. What I come here to do every day is to debate policy for the benefit of the people of Connecticut. And sometimes the policy that's put in front of me is good, and sometimes it's not. It doesn't mean I don't care about certain people or certain issues. I certainly care about the environment. I grew up actually spending all my time outside and becoming super interested in the sciences, joined the Audubon Society, the National Wildlife Federation, spent many hours and days doing things outside, hiking, fishing, all of those things. The environment is unbelievably important to me, and it needs to be preserved for future generations to exist. There's no question about that. The question is about the bill that is in front of us, which is a wish list for certain advocates. And when the bill occurs, and you see that there are, or excuse me, when the vote occurs on the bill, and you see that there are a number of people yes, and there's a number of people no, you've got to realize that there's a reason for that. And it's not about who likes the environment and who doesn't. It's about who thinks this is the proper way to get where we're going, or has concerns about the language in the bill for other reasons. So I'm going to try and explain my concerns about this. The first thing is that this is a constitutional amendment. It's not just a bill. This is a constitutional amendment. This is a big deal to go ahead and make changes to our state constitution, just like making changes to the U.S. Constitution is a big deal. And we have a process for that. Process starts with a committee vote and ultimately a legislative vote. And then a third piece of that is the vote of the people of Connecticut. So there are a few steps and checks along the way, which is a good thing. There's actually a requirement in the legislature that a constitutional amendment has got to pass by a certain majority. I can't remember, is it 2/3 or 3/4, something like that, in one legislative session for it to advance to the people. And if that does not occur, then it has to be passed in two separate legislatures by a simple majority vote. Either way, I think that this is a controversial bill. It's been on our agenda in the past. We've debated it in previous years. And every year I'm handed the same bill, or at least substantially. I don't know if it's the exact same word for word, but nothing of any substance has changed, because the majority seems to like the language as it is and has not taken any of my suggestions. But this constitutional amendment would create something that sounds really good to the casual observer, which is to create a green amendment, to create an amendment that says that every citizen is guaranteed a right to clean and healthy air, water, soil, and ecosystems, and also a safe and stable climate. It goes on to say that the state must protect these rights equitably for all people. It says that the state must conserve, manage, protect, and maintain natural resources for present and future generations. And then it says the state may not allow for degradation of the environment if it is avoidable or leads to significant environmental harm. And it finally states that these rights are equivalent to all other inalienable constitutional rights, like the freedom of speech, the right to bear arms, and so forth, and may be directly invoked and enforced by the residents. That final part's important because it means that that right is self-executing and it's enforceable in a courtroom. all of that sounds very good to a layman until you realize what is being constructed here, which is a transfer of our current system of representation, where the citizens of Connecticut elect their representatives, their state senators and their House representatives to a state legislature, and of course to Congress as well. And those people are entrusted to make policy for the state of Connecticut. And that's what we're all sitting here for as representatives of our constituents back home, to make good decisions about what the policies of the state will be. And those are all policies that have to do with the things we mentioned: environmental policy, energy policy. Those things are debated. We have an energy committee. We have an environment committee. And the reason why we have those committees is so that the representatives of the people can come here and debate and vote on those policies and determine what the best outcomes are. And some of the conversations have to do with whether or not we're going to place a power plant someplace, or we're going to allow people to burn certain things, or the placement of some type of infrastructure and its impact on the environment. All those things are debated by the people's representatives. So every citizen in Connecticut has a voice in those decisions. Everybody gets a chance to say something. And anybody who wants me to do something or vote a certain way can contact me and say, hey, Rob, I want you to do this. This is this thing. I don't like this. Don't do that. Vote against it. Or no, this is a great idea. You all have that voice currently. The danger with this legislation before us is this takes away your voice. It replaces it in a way that gives you maybe a louder voice, but only a singular voice that will be replaced by a mechanism that takes away the ability of all of the representatives' collective representation of the people of Connecticut and puts it in the hands of a courtroom. And potentially one judge will ultimately be the decider on these policies. So instead of all of us coming up here and hearing from the various interested parties and talking to the neighbors or the people impacted on these policies about where the dump is going to go, for example, and making good decisions, representing the people back home and working together in concert, hearing all the voices and all the stakeholders and listening to the various advocacy organizations on all sides of these issues and making decisions like that, all that goes away in exchange for somebody making a claim, a bunch of lawyers making a lot of money, and a judge deciding for all of us. That's what this bill does in essence. We've debated this bill every year, and repeated to me is the same falsehood every time, which is that individuals cannot sue one another under this bill. The proponents contend that this bill only allows individuals to sue the government for redress on these environmental concerns. But that's not true. The bill itself says the claims may be directly invoked and enforced by the residents of the state. So that means any resident has the ability to bring a lawsuit. And the lawsuit can assert a violation of the constitutional right that is established. And I already described the language of the bill: equitably for all people. If I'm already stumbling over my words, it's going to be a long day. Let me just say. It also says that the courts have to treat this right equivalently to all other rights. And of course, we know that people bring claims against one another for other constitutional rights. People will argue over the Second Amendment because a business disallows someone from carrying a firearm in the business. Or there are arguments over speech and who should bake a cake for a gay couple getting married, etc. Those are all claims that are brought from one citizen against another citizen or a business or industry that are constitutionally protected rights. My concern about this bill is that not only are we replacing the representative system that incorporates everyone's voice in the decision-making process and really hears from all of the stakeholders, because anyone can come to the legislature or any one of us anytime if they're for or against any bit of legislation, and tell us why. I don't think a judge is going to have that same ability to collect that level of information. And I also don't think that they're going to operate in the same way. The courtroom is going to limit the parties to making the arguments that are acceptable based on the court case that's involved. And that judge is going to have their own internal bias on how they view this Green Amendment and the circumstances before the court. Anyway, that's my argument for why this bill does create constitutionally protected standing for individuals who are bringing these lawsuits. So private lawsuits will occur because of direct constitutional claims, civil actions that invoke constitutional rights. More examples: neighborhood pollution. Somebody doesn't like someone has a bonfire in their backyard. Construction activity, noise pollution, development in a neighborhood, things like that. What that means basically is that even if the government approved a certain amount of activity to place a dump somewhere, for example, that doesn't preclude the parties that are directly involved from being sued by individuals or to sue one another. And this effectively is going to make, as I keep mentioning, the court to be the final arbiter. So this brings us to the other concern I have about the bill, which is that not only are we shifting that, what I think is a significant way of determining policy and upending the system we have, that we elect people to go make these decisions for us as a representative republic, and instead we're going to replace that with a courtroom. But that means we're replacing representatives with a bunch of attorneys who have their own self-interests and the interest of their clients at stake, and not the sense of good policy and the accountability of the people that they represent as we do. But what makes it worse is the language in the bill. And I almost suspect that this bill is being driven by a few different factions. I think you have some very, very concerned environmentalists that are pushing this bill because they're very concerned about the future of our planet and making sure that we maintain the Earth as a place that is conducive for human beings for a long, long time into the future, as well as the flora and fauna that exists. And so am I. But I also think that there's another entity that's involved in this, and I have to just assume it's the trial lawyers that are going to stand to make a lot of money off of policy that is passed like this, because the language in here is basically a litigator's dream, in my view, because it's so unbelievably vague and subjective. Clean and healthy environment is not a statistical certainty. Someone's definition of a clean and healthy environment is completely and utterly subjective. You know, people that live in the slums of India probably do not think that, have the same definition of a clean environment. They'd probably be happy to have even a moderate increase in the quality of life that they have there. And again, I didn't mean to pick and choose anything. I just use an example, a place where there's a lot of poverty and poor conditions because they don't have the proper sewage or water treatment infrastructure like we have in America. The fact is that, you know, it's a relative and subjective term. I'll just leave it there. Safe and stable climate. And what does that even mean? I mean, our climate changes by the minute. It may rain this afternoon. That's what I'm hearing. Stable climate, does that mean, over a period of time, the temperature fluctuations or something that is measurable? None of that's in the bill. So how much is too much? What's unstable? Avoidable degradation. This is a real key component of this bill. This bill requires the state and the courts, rather, to act if they believe that there's degradation that is avoidable. Again, completely subjective. That's going to be a courtroom deciding what they consider to be avoidable, whether or not a certain amount of pollution runoff or smoke or something can be changed, the output of a manufacturing facility, etc. I'd also just kind of point out that our air quality in Connecticut is really not up to us. We tend to get the air that came from the west of us, and we've had legislation in this building in recent years about automobile pollution and so forth. At the end of the day, when there are entire nations that outnumber us in souls by the significant, what's the term for the, anyway, yeah, I can't figure out the word right now. It's starting to be one of those days already. Exponent. That's the word I was looking for. I had to go back to 7th grade math to go find exponents. But there you go. I mean, China is out there. They don't give one darn care at all about the environment. They're doing things we would never dream of. And of course, over here, we're doing crazy things like buying electric cars that are reliant on batteries that are destroying the environment in the way that they're mined in China. So people that are very environmentally minded are also making decisions that are not making sense from an environmental standpoint. And it's very difficult to wrap your head around all of it because not everybody understands all of the different ways things occur in this world. But I can tell you that the people that drafted this bill knew what they were doing. They knew they were drafting a bill that contains things like significant environmental harm. What's significant? How much pollution is too much pollution? It doesn't say 4 parts per million in this bill. It says significant. So that'll be litigated. Court will decide what's significant. And you know what happens when the court decides? The court will set a precedent. And that precedent will be relied on by other courts or ignored by other courts until you end up have a patchwork of different decisions where people can't agree on all of these things. That is why we have a legislature. That is why we live in America where we have representative government, so we can choose people who represent the collective voice of the people to come and make these decisions. And we're ultimately accountable back to those people, too, that we actually have to get elected by doing a good job. If we do things that damage the environment, guess what? People back home are like, what are you doing? We're going to throw you out, put somebody else in to protect the environment. And these elections occur regularly for different levels of government, and they are very effective. And you can look back through history and find examples of people that have been elected to public office who have lost elections because they made bad decisions about the environment. So judges will ultimately decide what is clean, what is healthy, what is avoidable, what is significant. Safe and stable climate. I'll just come back to that for a second. Think about all the things that might be affected by this notion of a safe and stable climate. Energy policy, building development, transportation infrastructure, agricultural, industrial activity, housing construction. All of that is going to be contingent on the court's determination of what a safe and stable environment is. I bet you if we went around this room and we started asking people one-on-one privately to describe that, we're going to get a different answer from every single person. In fact, we have people who differ wildly on basic questions about climate change, for example. Is climate change real? How much climate change is attributed to man's impact on the world? I mean, these are things that people are debating over. There's no settled science as much as anyone would like you to believe there is. There are differences of opinions. As many scientists as we could get on the subject, we're going to have that same number of opinions. And instead of having a representative government that allows lawmakers to weigh this information and use their collective ability as a group who represents a multitude of people with different views to come to conclusions that benefit everyone, we're going to put this in the hands of one person. And that could be the one person that has the entirely opposite view than you do. Not only that, even if the situation doesn't come to fruition where the judge in the court finds for or against some particular claim in a way that you agree or disagree with, this can also be used as a delaying tactic. This can be used as a mechanism to stop the placement of some sort of infrastructure or a natural gas pipeline or God knows what. Because now you have created a mechanism where individual citizens can start suing the government and suing each other over and over about every last little potential violation of what someone's interpretation of clean and healthy is, or what is stable, or what's the significant environmental harm. That is a very low burden. In fact, it's so subjective that I would say that you could file a claim about anything. You could claim that your neighbor is polluting your air because they have a bonfire in their backyard. That could be a legitimate claim. And then a court could actually decide that they're right and prohibit people from being able to have a backyard fire pit. That's a real possibility from a bill like this. The proponents of this legislation like to talk about how this has been enacted in other states in recent years and nothing big has happened. But that's not exactly accurate or true. First off, the bill in this instance is not necessarily the same bill that passed in those other states. I hear people say this all the time. Well, they passed the same bill in California. I'm like, is it the same bill or is it the same subject? I don't know what the bills in the other states say. I don't know if they put parts per million in their determination of what we have as subjective in our bill. But I can tell you that there is a very great magnitude of lawsuits that are pending in places like Pennsylvania and Montana, where these policies have been implemented or resurrected in recent years. In 2021, New York adopted it, and litigation began almost immediately. People suing over landfill permits, water contamination, industrial operations. So there are lawsuits happening, pending, being decided, that are creating a patchwork of policy. If this legislation becomes the law in the state of Connecticut, it's going to affect permitting decisions here. Every environmental permit becomes vulnerable effectively to a constitutional challenge. Every infrastructure project is now subject to a potential constitutional challenge. Even local zoning boards, if they try and make a decision about where to place or to approve some sort of development. State policy we've already talked about. So there's a lot more to talk about here. And as I started, there's 52 items on our agenda, which I reminded the chairs, by the way, that even if we spent 5 minutes on every bill, it's nearly 5 hours, not including the time it takes to vote. And I've spent about 20 minutes talking on this one bill, and I will tell you it's nowhere near enough. This is a policy that will have far-reaching and long-lasting impacts. It should not be done arbitrarily at the last minute with very little notice and among a stack of other incredibly important policy decisions that this legislature is being asked to face. Before I go, I just want to say a couple other quick points that I didn't get into, but are worthy of further conversation and debate. And if this bill does make it to the Senate floor at some point, because it is a Senate resolution, I'll certainly expand more on these things, but there's the future generations clause in this bill, which is a whole other thing. You talk about subjective. this whole idea that now not only are we talking about what's happening in the here and now, but we also have got to factor in the court's ability to predict what may happen as a result of any particular claim. And obviously affecting people that aren't even born yet. There's also the fund diversion clause. The amendment prohibits diversion of funds supporting protection of the state's natural resources. So this would basically say that if there's money that the state uses for some protection of natural resources, they can't use it for some other purpose. And that's a very simplistic and childlike way of looking at the world, I think. I mean, who cares as long as the result is the same or better? We find new ways to do things all the time. But to say that you cannot change anything, to me, is short-sighted, and it does not open the door for new solutions. So, to summarize, this bill's a lawyer's dream. It's written in completely subjective language, and even if it was perfect, even if it set very, very objective parameters that we agreed to, it still replaces the representation principle of our American system of government with a judge's decision after listening to lawyers probably who are not necessarily going to be matched in their ability or compensation argue a case before them. And we will all live with the decisions that they make. For those reasons, Madam Chairman, Mr. Chairman, I will be a no today. Thank you.
Thank you, Senator. Further question or comment from the committee? Seeing none, Mr. Clerk, would you please call the roll?
This is a roll. This is a roll call vote on SJ 37, a resolution proposing an amendment to the state constitution concerning environmental rights. The motion is to JF to the floor. Senator Flexen. Rep. Blumenthal.
Yes.
Senator Honig.
Honig votes yes.
Representative Morin-Bello.
Yes.
Representative Osborne.
Yes.
Senator Sampson.
Sampson is no.
Representative Mastro Francesco.
No.
Representative Bronco. Representative Carpino. Representative Fonsello. Representative Gauthier.
Yes.
Representative Haddad.
Yes.
Representative Hoxa.
No.
Representative Johnson. Representative Menapace.
Yes.
Representative Rosario. Representative Santiago.
Yes.
Representative Shannon.
Shannon votes yes.
Senator Winfield.
Thank you, Mr. Clerk. And votes will be held open until at least the end of the meeting. And we will set a time if necessary later thereafter. Next up is item number 3 on our agenda, House Bill 5001, an act concerning absentee voting for all and various other reforms to the administration of elections. The chair, this is a JFS to the floor of LCO number 3490. The chair will entertain a motion.
So moved.
Moved by Senator Flexer, seconded by Representative Morin-Bello. 36 states and the District of Columbia have enacted some form of absentee voting for all, otherwise known as no excuse absentee voting, which is a system for voting where anyone who is eligible to vote may vote at their convenience by absentee or mail, as the case may be. Historically, Connecticut has had one of the most restrictive absentee voting systems in the country, allowing absentee voting only under 6 specific circumstances for specific voters that do not cover the exigencies of modern life. They probably didn't cover the exigencies of life before then either. In any event, the committee promulgated and passed and sent to the people of Connecticut a constitutional amendment to allow absentee voting for all in this state. In 2004, that ballot measure was overwhelmingly approved by the voters via ballot referendum. And here today, and through this bill, we will finally implement that vision of absentee voting for all, allowing every person who is eligible to vote at their convenience, safely, securely, and accessibly by mail or at home or by absentee. The JFS language for this bill modifies the bill in the following ways. First of all, it incorporates the Secretary of State's recommendations for absentee voting into this bill. Those include the curing mechanisms. It includes the pre-processing mechanisms. It includes tracking measures and permanent absentee voting measures. The bill overall removes the restrictions on voting absentee. It changes us from a 2-envelope system to a single envelope system with a privacy sleeve. It makes certain conforming changes and technical changes about when a ballot is received to account for the new system. It allows for the development of enhanced ballot tracking software by the Secretary of the State. It provides certain additional election worker protections. It allows the Attorney General and the Secretary to obtain certain legal measures and it eliminated a provision in the original bill that would have allowed certain forms of internet voting. Further question or comment from the committee? Representative Mastrofrancesco.
Thank you, Mr. Chairman. Yes, a constitutional amendment was changed to allow for no excuse absentee voting, which I'm okay with, not really having an excuse to have to vote. But I think when the question went out to voters, it was very vague, and I don't think they really understood what really goes behind it. I believe the voters in this state felt that, yeah, why do I need an excuse to get an absentee ballot? And I think that's what the presumption was, not realizing that what it did, it gave the legislature the authority to make sweeping changes to the process of obtaining an absentee ballot. While some of the items in this bill I think are not bad, there's some items in this bill that I have a lot of concerns on. Believe it or not, this bill is 83 pages. We just got it this morning. There was substitute language. And my staff and all my colleagues haven't really had a chance to really go through it in detail, which I think is really important. You're talking about a big bill. It's a priority bill for the Democrats. And I feel that it's their #1 bill. And I feel that it's incumbent upon us to make sure that the voters of the state and our constituents know everything that's in this bill before we go to pass it. So I'm going to ask the chairman if it's okay. If we can kind of go through each section of this bill so our constituents really understand what's going on. And if I'm looking at this correctly, in Section 1, what you are doing here is just removing the language that puts requirements in there to obtain an absentee ballot. Is that correct? Through you.
To you, Representative, yes.
Okay, so Section 1, we are conforming to the constitutional change that was made. Instead of saying sickness, work, and so forth, that's in our statutes, we are changing that and just removing it. Is that correct? The way I'm reading it, right?
Yes. To you, Representative, it removes all the reasons one must currently have to obtain an absentee ballot and allows anyone who is otherwise eligible to vote to obtain an absentee ballot. To you.
Thank you. And then on the next page in section 2, what does that actually do on section 2? What does it have to do with changing the reasons to vote?
To you, it changes the affirmation that is currently on the inner envelope of our absentee ballot sets. And currently, the voter must affirm that they meet one of the 6 reasons one can obtain an absentee ballot under our statutes. Because they are no longer required to meet one of those 6 reasons, the affirmation will change and simply be an affirmation that that they are eligible to vote in the relevant election and eligible to vote in that municipality. To you.
Thank you. This has to do with the return envelope. I'm just curious, as I was just thinking about it, it's not really necessary that these statutes are changed. Am I correct, Mr. Chairman? I know the Constitution, you're trying to get it to conform with what the voters requested, but it doesn't really have to be changed because the question on the ballot for the Constitution is, shall the legislature provide for no excuse absentee voting? And they said yes. So that Constitution can stay there, and we technically don't have to change any of this language because it said, shall the legislature provide? And we are providing.
To you, Representative, I guess I'm not sure if I'm understanding your question perfectly, but my understanding, and I think the lawyer's understanding of the constitutional amendment, is that it took the reasons why we must get an absentee ballot, which were in the Constitution previously, and then it directed the legislature to provide a system of absentee voting. We were not mandatorily directed a particular system. We were directed to implement the Constitution's demand for absentee voting without excuse, if that makes sense. So we have to pass legislation in order to enact what is now in the Constitution.
So the question on the ballot was, shall the legislature provide for no excuse absentee balloting? It doesn't say that they had to remove any conditions for requiring to get a ballot. They just have to provide. Am I understanding that correctly?
To you, Representative, the constitutional provision does not actually state what the rules of absentee voting will be in the state. Those are determined by statute. The constitutional amendment directed that the legislature be enabled to provide for a system of absentee voting not bound by the previous constitutional strictures. To you.
Okay, thank you for the clarification. I'm also looking at section 2, and it's talking about the envelope on the outside. The envelope says official absentee ballot. Is that different than what they currently were using?
To you, Representative, this accounts for the fact that we are going from a 2-envelope system to a 1-envelope with a privacy sleeve system. So the relevant information will appear on a different envelope. And that system change is because the number 1 form of voter rejection or rejected votes in elections is failure to properly not complete the ballot itself, but to complete the procedure of the multiple envelopes. And so most of the states that have absentee voting for all do use a system where it's a single envelope, usually with a privacy sleeve, because that reduces the number of votes that are rejected. To you.
Thank you. Will this have a privacy sleeve? I heard a lot of complaints for early voting that the envelope on the outside, you had to print your name, you had to sign it, and that people would actually can actually open it and see who you're voting for because your name is on it. So I did get a lot of complaints on that. Will this solve that problem? Will there be a privacy sleeve? And explain a little bit about that privacy sleeve and how that works for you.
To you, Representative, yes, it's our intent to have a system that requires a privacy sleeve, and we have consulted with the Secretary of the State's office on that, and we spoke with her about it in the public hearing. That privacy sleeve is essentially a folded piece of paper that goes around the ballot itself. It's not a separate envelope, but it blocks anyone from being able to view how the vote was cast. We heard during the public hearing from the town clerks and the registrars that when they're actually processing these ballots, it's not very realistic generally for most cases that they would actually view the ballot because they're just processing them kind of like they're shucking oysters. But nonetheless, we believe that this mechanism is an important one, not only to actually protect the privacy of the voter, but also to ensure the voters trust that their privacy is protected. So yes, it is our intent to incorporate this into the system. To you.
Thank you. And is that privacy sleeve, you mentioned something about, wrapping it around the ballot. Is that something that obviously the voter would have to do, or is it like a sheer sleeve that you put the ballot in to protect it that way?
The voter would be provided the sleeve. The voter would place the ballot in the sleeve, then the sleeved ballot in the envelope, and then send it in to you.
Thank you for that clarification. Also on lines, I'm looking at lines 101 through 111. It talks a little bit about the Department of Corrections. What is the change there in that section?
To you, last session we passed legislation to assist voters who are in the custody of DOC in completing absentee ballots and being able to vote. There are certain requirements for any moderator or clerk who are handling absentee ballots, and they involve providing the address and telephone number of the individual. Those are not feasible for the DOC employees who may be assisting voters, and as a result, they will use for those data the address and telephone number of the facility itself, because they're not separately a clerk at a town hall or what have you. So that is the accommodation that's being changed here. To you.
Thank you. You mentioned something in your response about the Department of Corrections assisting them. In which way? Is it just with the address portion of it, or are they assisting them in other ways? If you can clarify that for me.
To you, Representative, the DOC employees will be performing the role of an intermediary just to get the ballot to the individual who's in custody. And because they have been in the process of handling the absentee ballot set and getting it to the person in custody and then sending it back, that that chain of custody has to be maintained under our laws, and they already would have to provide that chain of custody. This is just specifying the exact manner in which they must provide the information to you.
Thank you. And how is that different than the current manner of which they are voting now? Because we have people that in prison that are eligible to vote. How does this differ from the current process?
To you, that part of the process is not changing. It's just literally what they have to put on the sheet to maintain the chain of custody.
Okay. Thank you. Let's see. If you can give me a minute here. We just got this bill this morning, and I'm still actually reading it. I guess on lines 212 in that section there. Let me see what section this is. Well, it starts on lines 203. Talks about the mailing envelope. I guess on lines 213 to 216, if you can just kind of explain that to me. It says, any voting information as be prescribed by Secretary of State, provided no such voting information shall promote the success or defeat of any candidate. What is that referring to? And that is new, I'm assuming, so through you.
To you, Representative, the restriction is new. The information that it applies to is not. So under existing law, the Secretary may include in a absentee ballot set relevant information about the measures to be voted on. This restriction would prevent anything partisan or otherwise urging the support or defeat of any measure or candidate in that absentee ballot set. So it's a it's a restriction to prevent the secretary or anyone else from putting anything partisan or electioneering into that absentee ballot set.
Okay, thank you. This would be also, this is obviously for the towns as well, correct?
Yes.
Okay.
To you, yes.
Yeah. And has there been a problem in the past with towns sending out ballots, like the town clerks, where they're promoting certain candidates in there that requires this, that this came about through you?
To you, I'm not aware of anything like that actually happening in recent past, but it was certainly something we wanted to avoid.
Okay. Thank you. And I obviously actually agree with that. On lines 217 through 220, it's talking about a unique ballot identification number. And we're removing a part where it had the serial number on the outer part. What is the difference in that process for you?
To you, Representative, the difference is really one of technicality here. The Secretary is planning to introduce enhanced tracking systems, and the ballot identification number is simply essentially a different term of art to describe what was functionally what functionally is a serial number, a ballot that is specifically identified by number and linked with the voter who requested it. It will perform the same function. It's just a different term of art, technically,
Okay.
for the system that will be used too.
Thank you for that clarification. And then on lines 258 through 263, it talks about the absentee ballot by electronic means. What does that mean? That's new in here. That's new language in here. 258 through 263. I guess if the applicant requests such manner of issuance for, are they talking about sending a ballot electronically through you?
To you, Representative, this addresses current law where there are certain forms of voters, principally military and other overseas voters, who can receive essentially a ballot by email. There is a physical ballot involved at the end of the day, but because of the time it takes to mail something overseas or through the military mail system, what happens is the voter is emailed a ballot, emails it back, and ultimately the physical ballot will be returned. But the current law allows for that system where the ballot is emailed for these specific voters who are overseas and overseas military voters. And so this just codifies and clarifies the existing practice and law. And this is required, by the way, under federal law.
Okay, so current law right now, when you're overseas or in the military, you get a ballot, a paper ballot. You also get it electronically, and they fill it out electronically, send it back, but then also send in the paper ballot? Am I understanding that correctly through you?
You're emailed a ballot, you fill it out physically, scan it, send it, email it back, and then you also mail back the actual ballot to you.
Okay, so that is the current process right now. And when they do that, do they match it up? Are they matched up? Are they put aside, I would say, and counted only if they get the original back to you?
To you, Representative, I do not actually know that off the top of my head, but this bill does not affect that one way or another. This just maintains the current practice.
Okay.
And this language is just clarifying in a different section what is already occurring as directed and required by federal law.
Okay. I'm really curious about that, how they match that up. Maybe we'll know that before it comes to the floor. There's a heads up.
I'm sure we can
I'll
get
be
you an answer
asking
on
you.
that.
Okay. I guess on lines 308 through 322, what are they talking about there? That's new language. And again, I apologize. We just got this bill a few hours ago. It's 83 pages. We haven't had a chance to go through all of it. So I'm not sure what that's talking about there.
To you, Representative, under our current law, individuals are allowed, or parties or other entities are allowed to send absentee ballot applications to voters. I know this has been a point of some contention on this committee and elsewhere. This provision would require that anyone who does so includes a disclaimer as to how it was paid for. So much the same way that under our current law, if you are putting up an advertisement for a candidate or a referendum or what have you, it has to say paid for by this committee, you know, Smith 2026. If a candidate or a committee or an individual is distributing absentee ballots or doing a mailing, what have you, they also have to include in the packet that they're sending who the committee is, who it's being paid for, that same disclaimer.
So this is the same for someone who is going out, getting absentee ballot applications, sending them out. They just have to include something in the envelope you're saying that says who it was paid for now. They're not manipulating the application itself, putting a sticker on that or anything. Can they do something like that for you?
Correct. They would not be manipulating the application itself, but rather including in the mailing the disclaimer to you.
Okay, thank you. And then also you're putting in here, they have to put an explanation of the various ways an absentee ballot may be returned. As we know, only the person, or obviously if you're sick, a family member, excuse me, can return that ballot. What specifically are they going to be explained on different ways to return the ballot? Are the laws going to be put in there on who can touch the ballot and so forth through you?
To you, Representative, yes, that is the intent.
Okay. Let's see here. Okay, yeah, on lines, I guess a little explanation on what they're referring to. On lines 356 to 362, it's talking about the clerk has to provide the applicant an additional envelope pre-addressed. Is that for the return of the ballot? I'm assuming that's what it is through you?
To you, yes.
And to you, wasn't that always the process anyway? What's different from this as to what the current process is through you?
To you, Representative, it has always been the process as required by the Help America Vote Act, which is federal law. This is just inserting that same principle, which we've always been following, into and codifying it in our state law as well, to you.
And has the envelope, it's always been a prepaid envelope, bulk or whatever, to you? Because I don't know if that's new in here.
To you, yes.
Okay. So on lines 394 to 397, the ballot will be counted, obviously, if it's signed by the applicant, or absentee ballot shall be deemed cast. If it's not signed, what happens to that?
To you, there are other provisions in this law that would direct the elections officials to make efforts to contact the voter to indicate that their ballot has not been signed and therefore will not be counted unless it is cured, and allowing the voter to cure the ballot. To you.
Thank you. And the curing, how much time do they have?
To you, Representative, the legislation directs as soon as reasonably possible and no more than 24 hours.
Thank you. And if the ballot is, so once the election is over with, the time and the votes have been counted, they would not be able to count any additional ballots if it was cured. Is that correct?
To you, excuse me, to you, Representative, that is correct. This legislation directs that no absentee votes may be cured after the closing of the polls. So 8 p.m. on election night, the polls close, and that's the deadline for absentee votes to be cured. To you.
Okay, thank you. And then on lines 470 to 473, they're talking about the clerk. They have to make a record of the ballots coming in. Am I understanding that correctly? Of all the returned envelopes, and that are not signed on this. It says on which the applicant did not sign the statement. Are they? Is this addressing them to keep a record of that? I guess is what I'm trying to find out.
To you, Representative, yes.
Okay, thank you. I guess on page 17, lines 500 to 532, there's a lot of new information in here. Can you give me a high-level explanation of what all of this is doing to you?
To you, Representative, yes. So this is the curing procedure that I just described, a little bit out of order, but basically it says that if the envelope, or excuse me, if the ballot is not signed, or the return of envelope is not signed properly, that the municipal clerk shall use their best effort to contact the affected voter so that they can cure the ballot and have it counted to you.
Thank you. I'm sure we'll have more questions on that as we go forward. I guess now I'm going to section 9, and this section I actually have a lot of concerns about, and I think we talked to the Secretary of State. This is about an absentee ballot, them requesting permanent absentee ballot status. So can you explain that to me and explain now, this is currently law, we have people that are disabled, they have permanent absentee ballot status, correct? And we already do that. What I'm understanding on this particular law is this is expanding this to everyone if they choose to. Can you give me an explanation of actually how that works to you?
To you, Representative, you've summarized it well. Under our current law, we have a permanent absentee voter list for people with disabilities. Now that under this legislation, if it would pass, all voters would be able to vote by absentee. This procedure would also allow them to anyone who wished to go on that permanent absentee voter list. Now, the quote permanent element of that is somewhat overstated. It's essentially a 2-year permanent absentee voter list, at which point every 2 years it's checked whether the individual still is living at that address, and whether they would like to make any change to whether they're on the permanent absentee voter list to you. So,
Thank you. So are they notified, or does the Secretary of State's office reach out to these people individually to find out if they're still at that address, or do they wait for the process of if a ballot comes back, not at this address, and then they're updating it? If it's supposed to be every 2 years, how do you renew it, I guess? If it's only a 2-year process, how does that work?
to you, Representative, the system would provide that if any absentee ballot is returned as non-deliverable, if they submit a change of address form, the registrar of the voters of the municipality in which such elector previously resided receives any information or data under the existing system where they send out the mailings to check that you still live at the address, that you're not living there anymore. So if that's returned as non-deliverable, or someone else returns it and says this person doesn't live here anymore. If the Secretary of the State receives any information indicating the person has moved, or the person has been placed on the inactive registry list compiled under current law.
Okay, thank you. So when you say it's every 2 years, it's not like you're renewing in a simple term, a membership every 2 years. It's automatic. The only way that you come off of this permanent absentee ballot list is if either you move, a piece of mail comes back, you notify your town that you no longer wish to be on this list for permanent absentee ballot. Is that correct?
Or somebody tells them you're dead.
Yeah, or you pass away. Yeah.
To you, you're correct that the person does not have to apply anew every 2 years, but it's essentially checked every 2 years because under other laws, the registrars are required to send out these mailings for the purpose of maintaining the statewide voter list and maintaining the accuracy of those rolls. They send out these mailings. You have to return if you're not. They have to be returned if the person is no longer living there. And so, if any part of the voter list system receives information that the person no longer lives there or has moved out of state, then they're taken off the list.
Okay, thank you. Very concerning to me on this. This is the problem. And when people voted for no excuse absentee voting, this is the whole part where it says, when you see language that says, "Will shall the legislature provide," this is it. This is it right here. And this is why you have to be very careful when you're doing constitutional changes like that, and when you're approving something, it says, "Shall the legislature provide," because it's only a one-party legislature here in Connecticut. That part to me is really concerning, because the next part says that, and I'm assuming it's the same as the previous where you're overseas, that these ballots may be issued electronically. Is that correct to you, Mr. Chairman, on line 684, 685? Or am I reading that wrong?
To you, Representative, I believe when you request an overseas ballot, you have to request it separately through a separate system. So I don't think that this would apply to that.
I'm looking on line 684 and 685, and it appears that it does. Like they could have it electronically, which is really concerning.
To you, Representative, yes, you are correct. I was looking at a different part of the statute. They may be issued by electronic means if they are requested through such means. To you.
Right. That to me is a big red flag. Big red flag. And I think we heard some testimony, if I'm not mistaken, of how this could absolutely be a problem. I mean, there's so many issues with the internet today, electronically, whether it's secure, it could be tapped into. This is a big red flag for me right here. These lines right here. That's a problem. I think what we're heading to is all mail-in ballots. I believe at some point the goal of this legislature is just to email or mail everybody that is an eligible voter in the state of Connecticut a ballot. And how they return it, whether it's electronically or by mail, that's the problem. The problem is that we don't have any processes in place to check. We don't have any real checks and balances in place in the state of Connecticut to check these ballots. That's where my biggest concern is. And as far as electronically, I mean, that's a whole nother topic. Line 708 through 722, can you give me an overview of what that is talking about there to you? There's a lot of lines of new text in there.
To you, Representative, that's the process I described previously about how someone can be removed from the permanent absentee ballot status list. Again, whenever the absentee ballot is returned as undeliverable, or there's a change of address, or some other form of information reaches some part of the election system indicating that the person no longer lives there. To you.
Thank you. Is there anything in this new bill that requires the Secretary of State in all the towns to clean up their voter rolls? That seems to be a big problem in many towns and across the state. I remember during one of the 2020 election, thousands and thousands of applications came back because they were undelivered. And I don't know if those voter rolls were ever cleaned up. Is there anything in here that addresses that to you?
To you, Representative, nothing that in this bill particularly that addresses that issue. I do know more broadly that that absentee ballot application mailing in 2020 did help clean up the voter rolls because some of them were undeliverable. And we did institute two systems of cross-checking with two different databases to clean up the voter rolls in our 2023 legislation. That has helped the Secretary's office. They're directed to do those cross-checks every year. Those have also helped to maintain and check the voter rolls. To you.
Okay, thank you. So going back to the permanent absentee ballot status for the general public, am I to understand in this legislation that the Secretary of State is going to have a public awareness campaign or mailing to let people know that they have the option of signing on to that? Do we have any idea? I'm looking at the language on line 723 to 731 of how that is actually going to work to you.
To you, Representative, they would be directed by this legislation to develop and conduct a statewide public awareness mailing regarding the changes in the law that we're enacting now, if we should enact them, including the availability of permanent absentee ballot status to you.
Thank you. And to you, Mr. Chairman, do we know what the cost is associated to that? Is this a one-off, a one-time campaign that the Secretary of State is trying to accomplish? When will she do it? Do you have any idea of the cost to you?
To Representative, this is a one-time cost. It would be immediately or as soon as practicable after the effective date of this section. And the cost is not delineated as it currently stands to you.
Okay, thank you. Yeah, I mean, listen, to anybody listening to this and you went out and you voted for no excuse absentee ballot, did you think we were going to come to a day when you just want to vote without an excuse? No problem. That we would be sitting here with a bill of 83 pages of how to do that, and with all these other changes in it. So when they talk about no excuse absentee voting for all, I don't think the voters, I don't believe in my mind that they thought it was going to be like this. There's so much in this bill. It's not that simple. Okay. Can you talk a little bit, you mentioned to me earlier about ballot tracking. How does that work? What was that language? I think you said there was something in there new about ballot tracking. I'm trying to find it here.
To you, Representative, in Section 8, the bill directs the Secretary of the State to develop and install integrated ballot tracking software with the statewide centralized voter registration system, otherwise known as CVRS, to enable electors to track when their ballot has been received by the clerk, accepted by the clerk, when the ballot has been mailed, or excuse me, when the application has been accepted, received by the clerk, when the ballot has been mailed, when the ballot has been delivered to the voter, when the voter has delivered the ballot to the municipal clerk, and whether that ballot has been accepted, and lastly, whether and when it requires curing, according to the procedures that we discussed previously. So this would be a system that allows the voter to track both the application and the ballot as it goes through the system, and also the municipal clerk to track it, so everyone knows where the ballot or the application is throughout the process. To you.
Okay, thank you. And when we going back to the permanent absentee ballot that you can maintain, when would someone receive that ballot? At the same time that they're available to mail out, or because it's electronically? Is it earlier, later? To you.
To you, for the permanent absentee voting list, it would be the same as any other ballot. The electronic means only applies to military and overseas voters. To you.
Okay. And someone applying for the permanent absentee ballot, what type of identification or verification are they required to submit when they apply for that to you? That they are the person that's actually requesting the ballot to you?
To you, there is no separate procedure for going on the permanent absentee voting list. The existing procedures around registration and seeking an absentee ballot would apply to you.
So basically, anyone could go online when this takes place, and I just want to be mailed. You're basically asking to be mailed a ballot electronically, if you choose to. And that you are going to vote by absentee ballot electronically, or whether you could, I'm assuming that in that particular case, if you want it electronically, do you have to file it back electronically, or do you print it out, fill it out, and then mail it back? To you.
To you, just as we discussed before, you would print it out, fill it out, scan it, email it back, and then also mail back the ballot to you.
And does that ballot have a unique ID on it, a unique identification number on it? I'm going to assume it does to you.
To you, Representative, yes.
Thank you. And when they send that ballot back, is there a certain envelope that they have to send it in, or is it just sent in a regular envelope? If they're getting it electronically, I can't imagine that they're going to be given an envelope. How does that work to you?
To you, Representative, my understanding is that it would be a regular envelope.
Thank you. And to you, and I get, listen, all this works for our veterans that are overseas and our military, which is fine, but you know, you're talking about every resident in the state of Connecticut. Anybody who's a eligible voter can certainly do that. So this is the problem with this whole entire bill. I can see where it's going. We have a lot of issues with it. There's a couple of other things. There's so much stuff in this new bill. There was another bill that we had that I understand that this substitute language incorporated into this original bill. What was in that original bill that was added into this one? Was that the Secretary of State's bill?
To you, Representative, yes, it was SB 491, the Secretary's recommendations for absentee voting, except for any internet voting procedures. And also another bill that we have heard in this committee and tried to pass many times bipartisanly, the risk limiting audits bill implementation is also contained in this language to you. That's in sections 45 to 57.
Thank you. Is there anything in this bill that talks about the solicitation of applications, or is that a separate bill, or is that also included in this bill to you?
To you, Representative, that is a separate bill.
Okay.
There is an additional requirement for anyone who's distributing applications that they have to include the disclaimer I described previously, but there is no restriction on who can provide them here
Okay.
or solicit them.
So question. So in another bill that I saw, it removes solicitors, right? People from soliciting applications for ballots, like campaigns and so forth, and only allows the Secretary of State and the town clerk to do that. Correct? Okay. Now this particular bill is saying that if you send out a mailing of applications, you need to put a disclaimer on who's paying for it. It's kind of insinuating in this particular bill that anybody can send out applications for absentee ballots. Follow me? Like, the only people that would be doing it would either be the town clerk or the Secretary of State's office. So what's the disclaimer? It sounds like the disclaimer in this bill is directed towards political operatives or campaigns and so forth. To you.
To you, yes. There is a separate bill that would eliminate them. This bill requires them to include a disclaimer. If the other bill passed, then that section of this bill would become a nullity to you.
Would that other bill have to be changed
To you,
for the
no.
effective date or anything to remove this section of the bill?
To you, I don't believe so.
You don't believe so?
It would just, there'd be no reason for anyone to actually have to comply with the section of this bill then.
Okay, so we're not on that bill yet, but the other bill would just allow the town clerks and the Secretary of State to send out applications for ballots. There was also in this bill, the original bill that I read, about them, the counting of the ballots on election day. I believe that was in this bill. Is that also in here where you're just allowing the towns to process the absentee ballots a little bit earlier as opposed to waiting? Can you explain that a little bit to you?
To you, Representative, yes. So they would be allowed to pre-process the ballots to essentially shuck them so that they're ready to be counted. They are not allowed to be counted until Election Day. And the pre-processing would allow the curing that we described previously, but no counting may take place before Election Day. To you.
Okay, thank you. And a couple more things. You mentioned something about election workers' protection. If you can maybe allude to that a little bit. What section is that in this new bill?
To you, Representative, Section 33 contains those protections. 34 and 30. One sec. So, excuse me, 31 and 33 contain those protections. 33 modifies the definition of election worker to ensure that assistant municipal clerks are included. 31 includes additional workers, types of election workers under the current protections for election workers, if that makes sense. So we currently have certain protections that we passed into law to protect election workers, and this expands the definition of those election workers to ensure that head moderators, central counting moderators, and absentee ballot counters appointed pursuant to law shall also be included as election officials. Assistant municipal clerks are also included, etc. to you.
Okay, thank you. So we're just increasing who is eligible for protection, I guess. What is that protection? What is it that they're eligible for to you?
To you, those protections are not in this bill, but there are a number of protections against threats or harassment or attacks or improper orders, essentially.
Thank you. And are those from the public, just from people going to vote?
From anyone who would interfere with an election worker, to you.
Okay. And then you mentioned something in your opening as well about the Attorney General and the Secretary of State having being able to obtain legal measures. What was that referred to in what section?
To you, Representative, in Section 35, the bill provides that the Attorney General may seek preliminary or permanent injunctive, declaratory, or other appropriate equitable relief to prevent or redress interference in connection with any election for any measure where there is alleged or claimed interference. To you.
Can you give me an example of that? Because when I read this, I think of, well, the federal government has requested that our voter rolls are turned over to them. Would they consider that interfering in our elections, and would that prevent the Secretary of State from handing over that information based on the language here?
To you, Representative, no, that would already be covered under existing law. The Secretary is already prevented from handing over that information, and if the federal government sought it through legal compulsion, the Attorney General would represent the Secretary in court. This is for the actual interference with an election itself. So I guess probably the number one hypothetical I could imagine is perhaps if there are individuals or government officials who are actively preventing someone from voting or wrongly attempting to administer an election. This would allow the Attorney General to go to court, functionally on the Secretary's behalf, to seek a court order saying this illegal action is happening and it must stop. To you.
Okay, thank you. And if you could just refer to lines 1720 and 1729, what are you talking about there? That's new language. I'm just curious what that is referring to. Again, this is all for no excuse absentee ballot. Not like, okay, I should be able to request a ballot without having an excuse. This is what we get. How many lines?
To you, Representative, this provision is simply actually a conforming change to reflect that we now have new tabulators in the state. So we have two sets of tabulators. Some are regular speed, some are high speed. And so this is if there's essentially a recount.
Okay.
The absentee ballots may be counted with the tabulators, or if the moderator requests, a high-speed tabulator.
Okay, thank you. And then on section 41, if you can just, that's a new section. If you can just kind of go over, what does that mean? It's talking about I guess if you're not quite of age to vote, you're just 17, you can vote by, is that what it means, vote by absentee ballot? It's because you're turning 18 the day of election or just right at that time?
To you, Representative, yes. So this was discussed during the hearing. It says that if you have not yet turned 18, but you would otherwise be eligible to vote by election day, you may vote absentee as long as you will be eligible on election day. So essentially it allows young people who are not yet 18, but will be 18 on election day or by election day to vote absentee.
Thank you. And they would also have the opportunity to be on the permanent absentee ballot list as well, to you?
To you, Representative, there's nothing prohibiting them from going on the permanent absentee ballot list. To you.
Thank you. There's a lot in here, and I still have to go through it. Like I said, we just got this. I'm going to just want another question. You mentioned in your opening about the elimination of the internet portion of this, and I don't see that at all. If anything, I think I referred to that section where you can, the permanent absentee ballot, you can vote by internet. Was that what you were referring to you?
To you, Representative, no. So under existing law, and this is federal law that is, it's the Help America Vote Act, and it demands that we provide for this electronic means, the email means, for overseas and military absentee voters. There was previously a section in the bill, in the previous version of the bill, it was section 28, that would have allowed the secretary to essentially implement a system of electronic voting if such system were ever certified by the appropriate body. That section was removed.
Okay. Thank you.
We received a number of concerns from various parties, and actually I think one of the strengths of our system is that we have physical ballots. Everybody votes by physical ballot. At the end of the day, there is always a paper ballot that we can go back to
Right.
and say this person voted and during an investigation or a canvass, and so that it will be maintained to you.
Okay, thank you. I don't have any further questions. I still have to go through this bill. I'm sure by the time it gets to the floor, I'll have a ton more questions for you to go through it again. And there's some decent things in here, but there's a lot of things in here that I'm very concerned about. It's just not as simple as you don't need an excuse to request an absentee ballot. There's a lot of changes in here. But I don't see anything really significant, at least in this particular bill, that's really going to put more security around fraud and abuse in our elections like we've seen. I wish it had more of that in there. But I'll continue to go through this, and I'm sure my colleagues probably have some questions as well. Thank you, Mr. Chairman, for now.
Thank you, Representative. Further question or comment from the committee? Representative Hoxa.
Thank you, Mr. Chairman. A few questions and I guess some opining as well at some point. I'm trying to find the section, through you, Mr. Chairman, I'm trying to find the section of the bill. Give me 1 second here. Okay, I guess I'll just use the page number.
Page number is fine.
Okay. Page number 19 of 83. Second and third paragraph down. If I am reading this correctly, it seems to say that Section F, absentee ballots timely received by the municipal clerk after 11 o'clock a.m. of such last day before an election, primary or referendum, shall be sorted into voting districts by the clerk and retained by the clerk separately until delivered to the registrars of voters for checking. I'd hate to ask such an open-ended question, but can you sort of decipher that? I'm having trouble picturing in my head what that looks like. Could you explain what that means?
To you, Representative. So this is part of the pre-processing procedure to speed up the count at the end of the day. these ballots that are received before 11 a.m. would just be separated into voting districts. So, if it's a municipal election, it'd be, whatever municipal districts there are. If it's a statewide election, whatever legislative districts they are, so that they're able to be counted more quickly at the end of the day to you.
Thank you, Mr. Chair. So it says, it specifically mentions municipal elections here, but would that sort of same system apply to state level elections as well, through you, Mr. Chair?
To you, Representative, yes.
Thank you, Mr. Chairman. And so 11 a.m. of the last day before an election. So elections are always on a Tuesday. First Tuesday after the first Monday of the month here in the state of Connecticut. And not all elections are like that. Some, I think some municipalities do elections on different days. But so my question is, 11 o'clock of such last day before an election. So 11 a.m. is the absolute last hour in which an absentee ballot can be received by a clerk or or sent out to be received by the clerk, through you, Mr. Chair.
To you, Representative, I believe you read that correctly, yes.
So time stamped by 11 a.m. or received by the clerk by 11 a.m. through you, Mr. Chair.
To you, Representative, I believe the clerks are supposed to be stamping them as they receive them. So it would be when they're received before 11 a.m. to you.
Thank you, Mr. Chair. That clarifies it. Okay. Okay. Skipping over to page. Well, actually, this one I know by section. Section 35, which I believe is.
To you, that's starting on line 1561, page 50 of the bill.
Page 50, thank you. I had it down by section, and I just can't seem to find them anymore. Page 50, okay. All right, perfect. Yep, I have it marked down. So, through you, Mr. Chairman, this section of the bill, right after section 35, where it says section 35, second paragraph down, item number B, the Attorney General may seek preliminary or permanent injunctive, declaratory, or other appropriate equitable relief to prevent or redress interference in connection with any election for presidential electors, a senator in Congress, or representative in Congress by bringing a complaint to any judge of the Supreme Court in which the Attorney General shall set out the claimed interference. So electors in this case, would they be different for president than for Senate or representative? Through you, Mr. Chair.
To you, Representative, so the electors referred to here are presidential electors. So technically, when we elect a president, we don't actually elect a president. We, under our very specific system in the U.S. Constitution, we actually elect electors who then elect the president. It is customary, and many states legally require those electors to vote for who they were elected to vote for. But long story short, this is referring to presidential electors, and then the long and short of it is, yes, these are presidential electors, and then electors who are just voters for Congress, or excuse me, the electors only refer to the presidential electors, and then it refers to elections of senators or representatives in Congress. To you.
Thank you, Mr. Chairman. Yes, I think I know what you're getting at, and I do ask the question in good faith because, yes, I am aware that when voting for president, we are essentially voting for president, but through the voting to basically convey to our electors, whoever those people may be, depending on the outcome of the election, to then vote for that person which won the popular vote in the state we're voting in. I know that sounds very complicated, but it's really not. So essentially, but when it comes to Congress and Senate, as far as I know, there aren't any electors apart from the voters themselves, and it's just I feel like it should make that distinction unless I'm incorrect. Through you, Madam Chair.
Thank you, Representative. I'm not, are you just asking for additional clarity around the use of the term electors in this section versus the general concept of who an elector is as used in the same way as you would use the term voter?
Yes,
Yeah.
specifically when it applies to House and Senate.
Yeah, so I mean, I think this, as Representative Blumenthal said, you know, the reason for the different use of that word here is because of the very specific way we choose electors who then, in concurrence with our federal constitution, choose the president of the United States. And so we could look to see if there could be some clarity on this language, but I doubt that there can be because of that very specific way the presidential elections work.
Thank you, Madam Chair. So just to get this straight, this bill is not calling for the state of Connecticut in sort of a roundabout way to create this new layer of representation between the voters and who the voters voted to elect by creating an additional set of electors when it comes to a House or Senate seat. Through you.
That's correct. This section is just referencing the existing additional layer that we have and we've always had in this country when it comes to the election of the president and the vice president.
Thank you, Madam Chair. Moving on, but within the same section of this bill, Section 35. I haven't read the whole bill. This is JFS language, substitute language, so we didn't really get much time to read over the whole bill and all the new and additional language that was added to the bill. But one thing that immediately stood out was the fact that the Attorney General plays potentially a big role in some of these situations that can arise. And I just don't understand why GAE is basically, writing legislation to give an additional power to the Attorney General. Would that not be something more so in the purview of the Judiciary Committee? Through you, Madam Chair.
Thank you, Representative, for the question. This committee, as you know, is charged with overseeing all statutes concerning elections, and so the reference here to the Attorney General, I would say, is very clearly appropriate in terms of debate for this committee, because this is empowering the Attorney General to act on the enforcement of existing election statutes, and that's clearly within the cognizance of GAE as a member of the Judiciary Committee, as I think a few of us are. Certainly there are things that the Attorney General is charged with doing in that particular role that do fall within the cognizance of the Judiciary Committee, but there are a variety of areas that the Attorney General's office acts upon that are in the cognizance of many committees, and this specifically is in the cognizance of the GAE Committee because it is with regard to the enforcement of election statutes.
Thank you, Madam Chair. I appreciate that. And through you, so essentially, should this bill pass out of committee today, it would not need to be referred to Judiciary? Through you.
Now that I can't say for certain. I would argue that this particular section that we're talking about would not be a reason for it to be referred to Judiciary, but that's a decision that's not made by necessarily the members of this committee. There are other sections of this bill that may require this bill to be reviewed by the Judiciary Committee.
Thank you, Madam Chair. I appreciate that answer. And through you, just a couple more things here. So the point of this legislation is to, I love looking at the titles of bills because they ought to tell us what the bill is about. And this one says, an act concerning absentee voting for all and various other reforms to the administration of elections. So the Attorney General, getting back to the Attorney General, they are playing a role in this bill. They're being given a new sort of task within their purview, or maybe even with, outside their purview, but we are now creating it within their purview, to further the cause, an act concerning absentee voting for all and various other reforms to the administration of elections. So to further that cause. Now, if whatever scenario or situation would come up, after the passage of this bill that would call for or trigger the involvement of the Attorney General, that thing that would trigger the involvement of the Attorney General, should that happen now, before the passage of this bill, you are saying that such situation the Attorney General currently does not have an ability to act in his legal capacity in such a situation. Through you, Madam Chair.
To you, Representative, I actually am not saying that. I would say that this section provides additional clarity in the context of this brand new policy that the state of Connecticut is embarking upon with the expanded use of absentee ballots. But I don't think this bill speaks to the existing authority that the Attorney General has to act in election matters.
Thank you, Madam Chair. So if I understood that correctly, it is certainly possible that something arises where, according to the spirit of this bill, voting, the administration of elections, as written in the title of this bill, is being hindered by some force, entity, person, whatever, and the Attorney General still can, as a duly elected official, whose role is spelled out in our Constitution, hence why that office is called a constitutional office, could still petition the courts and take a case that may arise from now until this bill is passed, that essentially deals with what this bill is trying to address, but before it's passed. Through you, Madam Chair.
Representative, I'm not sure I heard the question at the end of your statement. I apologize.
No, it's okay. Thank you. Okay, so essentially, the Attorney General, whatever this bill hopes to accomplish as far as giving the Attorney General additional purview in election matters, that is not to say that right now, before the passage of this bill, the Attorney General can't still go after anything that may have violated whatever this bill looks to protect. Hope that clears it up a little bit more. Through you.
It does slightly, and I appreciate the rephrasing of your statement and question. I don't think that I don't know that I would use the phrase "go after." I think that the Attorney General role in Connecticut is a little bit different than in other places. So I don't think that the language that we have before us is limiting in any way the existing authority that the Attorney General has, but it is putting forward new abilities of the Attorney General to act, and it's done specifically within the context of the pretty large policy change that is here before us today with regard to the use and the processing of absentee ballots.
Thank you, Madam Chair. I think that answers that. With that, I don't have any more questions, but I will just say that, I do think that, a bill of this size deserves a little more due diligence on everybody's part, especially our part as, the side of the equation that hasn't fully read the bill yet. I would just, be hesitant to jump into supporting legislation that is, a stack that is this thick and whose numbers go into the triple digits, whose pages I think go into triple digits, if, maybe not. But it's still a lot of paper here and a lot of information to digest. And specifically when you're talking about cross collaborating with other branches of government, and giving them, codifying new powers to them. I'm generally I'm not against that. I'm not for that. It's just something that I feel I would need to, read through and kind of digest for longer than, the couple hours we've been in this committee meeting. I'm not a fast reader, and I'd like to read things out loud, which would have been awkward had I done that during this committee. Not because I like the sound of my voice, but because it just helps me focus on what I'm trying to read. I think a lot of us have that problem. This isn't something that I think I'm going to support today. I do like a lot of this bill. I do like a lot of sections of this bill. I do believe in election reform and a cleaning up of the process. And I'll just share a quick anecdote of one thing that I wish was in this bill, because it's such an easy thing to do, and it's such a practical thing to do, regardless of which side of the aisle you're on. But a few years ago when I was first running, there was an address on the street in my district where I knocked on that individual's door, and the person that answered the door was not the person that was on my walk sheet of individuals that were registered to that address to vote. And I went through the whole list, and that individual, the young lady, standing across from me, was none of these individuals. And there was 5 people that were registered to vote at that address, and none of them lived there anymore. And the individual that was speaking to me was none of these people. So now I'm not saying that that's, a big, it is a big deal, but I'm not saying that that is necessarily evidence of any wrongdoing. That is just a sort of a clerical, thing in the domain of the clerks and the registrars to clean up such voter rolls, so that that sort of situation cannot be weaponized politically and cannot be used as fodder for potential election fraud. From what I've heard from my colleagues and from our lawyers who have read a little bit more of this bill than I was able to, it doesn't seem like there's anything to address that issue that this side of the aisle cares deeply about. And I would love for this to be a bipartisan bill, and I would love to support it. And 80% of this seems like good stuff. I just wish that we had more time to read the section that included the cross collaboration with the Attorney General's office, and I wish that we had some say in some of the other sections of this bill, and that we had some of our philosophical priorities included in a massive, almost aircraft carrier election reform bill. And one of those things is a cleaning up of the voter rolls. And I feel very strongly about that because, like I said, that's just one little anecdote that I've experienced, but I'm sure all of us have experienced something like that before. And it just makes you wonder, like, why do we have to have a system where that is the case? Because it makes it difficult for the person, for the resident, because they want to vote, right? And maybe they're registered somewhere else, and they don't remember whether they re-registered or not at the new residence, and they go to vote, and lo and behold, they find out, oh, I'm not registered to vote here, at least. So in an age where we have the capacities and the capabilities for these things to be sort of fixed in real time, I think that should be a part of major election bills moving forward. And a little disappointed that I don't see any of that stuff, but I think I've said what I needed to say, and I appreciate your answers on some of my questions here, and thank you for your time.
Thank you, Representative. Thank you for your conversation. And I'll just say, if this gives you any comfort, that most of this bill is the underlying 5001 and Senate Bill 491, which was another bill that's on our agenda today. And we've talked a little bit about some of the changes with regard to the pilot around accessibility of voting being via the internet, that being taken out. So I understand the points that you've made, and I know that I get frustrated when there's a bill on the floor in the chamber that I haven't had much time to digest. So I take your comments with goodwill, and hopefully we can continue the conversations amongst all the members as we move forward with this legislation. Representative Carpino.
Thank you, ma'am. We've heard a little bit today, and I was just hoping I'd get some clarification on some of the points that I heard. Does this bill, and I'm not sure which chair to direct this to, so I will ask it generally. Does this bill at all impact the online voting for our servicemen and women, and if so, how?
That's a good question. It does not. It maintains the existing federal provisions with regard to access to voting for people who are serving in the military. There was a proposal in Senate Bill 491 that would have contemplated a change to that, an expansion, but we're taking that out. So right now, the existing process that's in place is what would stay in place.
And thank you for clarifying that that process is unchanged with the language that we have in front of us. There was also some conversation about the pre-processing of ballots on election day. How would that process change from what it is currently pursuant to this language? I'd
We're
love to
debating
hear
over
from
here
either
who
of
should
you.
answer, yeah.
So I'll try to trace through this to you, Representative. So there is the 11 o'clock. Well, first of all, there's the pre-processing of the taking them out of the envelope so that they can be cured before Election Day that can take place under this bill. There is the 11 o'clock sorting that would take place, and the pre-11 o'clock sorting. And I think all the other provisions just designate how the ballots should travel between the town clerk's office and the registrar. So those are really the two pre-processing measures that we would see to you.
And thank you very much. And just to be clear, when you say sorting, sir, do you mind just clarifying?
They're being sorted into voting district. And one addition I wanted to add was that this bill moves up from 8 p.m. on election day to 4 p.m. on election day, the start time for the counting of absentee ballots.
Could you just repeat that number, sir?
From 8 p.m. to 4 p.m.
Thank you. In a town or in a municipality with only a single voting district, how will the new sorting rules apply through you or to you, sir?
To you, Representative, they wouldn't change anything if there's only one voting district.
Thank you. And I appreciate, as an aside, the privacy sleeves. That has been an issue I've experienced firsthand, so I appreciate that that's in here, particularly with local elections with very few individuals exercising their right to vote via absentee, so I appreciate that. I actually supported the concept of absentee ballots. I voted to put it out to our voters and understand the significant majority for which supported that concept. And I came in this morning because a few minutes before 6, when I saw all 50 plus bills on the agenda, I started reading them. And the JF language as it was presented was something I was willing to support, at least for committee process. While I didn't agree with everything in it, I did agree enough with the spirit of what was in there to be able to vote to move it along and continue the conversation. But we're talking about a fundamental right of our democracy. I am not comfortable going through 83 very detailed pages either. We're making major changes here. In the spirit of trying to get this right, I am happy to have conversations as this continues. I think it's a disservice when you have 50 plus bills with duplicative provisions in them walking in and mixing and matching. This is like a buffet of sorts, which is not how it should be. You should understand what's on your plate when you walk in. I'll continue the conversation. I appreciate what we're trying to do. I actually support what we're trying to do, but I'm not comfortable with this in any way, shape, or form, and I'm not going to go back and tell my constituents that I made a spur of the moment decision on something as crucial as voting. So I'd love to continue the conversations, but I'm not voting for this today.
Thank you, Representative, and we'd be glad to continue the conversation as well. Further question or comment from the committee, Senator Sampson.
Thank you very much, Mr. Chairman. Back in 2014, I think it was, there was a ballot question that was put before the people of Connecticut that asked them if they were okay with expanding voting to include voting that was not in person for every voter, and they voted that down, which is telling. And in 2022, this body, this committee, in fact, most of the same people, and this legislature also put a new question to the voters after debating whether or not that was a prudent idea in this committee. And that question was, shall the Constitution of the state be amended to permit the General Assembly to allow each elector to vote by absentee ballot? I said at the time, and I still think it's interesting, that they changed the question on purpose because they wanted a different answer, and making it less obvious that we were expanding not in-person voting, I think is how they ultimately ended up getting a affirmative result. I'd also point out that when the question was asked, it was already the law. Shall the Constitution of the state be amended to permit the General Assembly to allow each elector to vote by absentee ballot? What for? Every voter was allowed to vote by absentee ballot, even at that time, assuming they were in correlation to the requirements that are in our state constitution. And as a matter of fact, that was long after 2020, when the Secretary of the State and the governor of the state of Connecticut during the pandemic decided to redefine one of the words in our Constitution and our statute, sickness, to allow them to send ballot applications to every voter across the state of Connecticut, effectively creating no excuse absentee voting for all at that time. When I complained about it, the legislature actually came back and redefined the word sickness in the legislative statute as a way to justify what they had already done. So we already have no excuse absentee voting because there is a Supreme Court case in Connecticut, there is a statute that redefines sickness, and effectively it says now that, unlike it used to be, which was if you had sickness as an individual, you could be excused from in-person voting and vote by absentee. It's now defined as just sickness. In other words, your sickness, someone else's sickness. Sickness existed once in the past. It may exist again in the future. Someone else may be sick somewhere, someday, sometime, somehow. But sickness itself as a word is justification. So everyone already has no excuse absentee voting in Connecticut. So this is in somewhat of an unnecessary process. I think what's really more interesting about it is that when the voters were asked that question on November 8th of 2022, shall the Constitution of the state be amended to permit the General Assembly to allow each elector to vote by absentee ballot? I think what they should have put on the ballot was, shall the Constitution be amended to permit the General Assembly to create an 83-page omnibus bill to completely change our absentee ballot voting process while failing to provide input to the minority party representatives or proper time to review such aforementioned bill and debate it, and fail to provide for any necessary protections to maintain voter integrity. I think that if that question was on the ballot, people would have answered differently. But that's what we have today. We have an 83-page bill to implement what already existed in practice, if not in the letter of the law. I think it's very interesting. Like some of my colleagues have already mentioned, I've never been against no excuse absentee voting. I've said over and over again that I think people should be allowed every possible mechanism to vote, and it should be as easy as possible. However, I've also said, every time I said that, the problem is that the majority party in this state wants to do the access part, but they never want to do the part that goes with it to make sure that it's a legitimate process that results in proper election integrity. And every time we've debated this, including ever since 2014, if I remember correctly, the minority party, whether it was me or someone else, has offered numerous amendments to bring us in line with other states that have similar policies. It is always pointed out by the majority, lots of states have mail-in voting. Yes, they do. And those states that have mail-in voting also have laws that secure the election process. They have voter ID, they have photo identification, they have signature verification throughout the process where they identify the voter at the time they register and they can track them through the entire process. They make sure that their mail-in voting systems work. Not Connecticut. All you got to do is turn on the evening news and catch Wanda from Bridgeport to know that our system doesn't have any of these protections. Nationally, the Republicans in Congress are trying to pass the Save America Act, which is really nothing more than photo identification requirements for voting. But even though people in both parties, independent voters, overwhelmingly support photo identification, it's something like 80 to 90% of voters think it's a good idea, and that includes the people that are supposedly the victims of some terrible Republican voter suppression scheme, the minority voters that live in urban areas. They're for it too. And they're for it for the same reason, which is that everybody values their vote. And your vote only matters if it actually matters. And if there are people that are able to vote that shouldn't be able to vote, or to vote multiple times, or for cheating to exist, or for Wanda to stuff a drop box in Bridgeport, as long as that's going on, everyone else is having their vote diminished. The value of their vote means less. Worse than that, people do not trust our system. I don't trust our system. I think that the people that work in our local elections are fabulous human beings. They work hard. I know a lot of them in the towns that I represent. They put in long hours. They take it so unbelievably seriously that what they're doing is important, that they have to screen for accuracy at every turn. The problem is that they're operating within a system that doesn't have the right protections. Most of the things that could cause a fraudulent vote to occur happen outside their control. They happen in the sense that absentee voting opens the door for things to occur that doesn't happen with in-person voting. And don't take my word for it. I mean, first off, it is obvious that in-person voting is always going to be more secure than mail-in voting. If the person's standing in front of you voting, chances are they're a legitimate voter. At least you know they're a legitimate human being, right? A debate I had in the Senate a number of years ago, I remember Senator Martin Looney, the most powerful member of the majority party in the legislature to this day. He got up and made comments on the floor, and I will share them at some future point when we debate this bill again, as I have in the past, where he made it very, very abundantly clear that sometimes you just never know who's actually casting an absentee vote. And he said that in defense of expanding early voting, of course. But he still said it. And he said it because it's true. Now, that doesn't mean we shouldn't be doing it. It's just that the people that came before us, frankly, I think they were smarter. They came before us, and they were very, very concerned about making sure that our votes count and that there's no funny business going on. So they said, you know what? We're going to require in-person voting for almost everybody, but we will make the necessary exceptions for people in the military, people that are sick, people that are out of town. It's actually somewhat expansive already. It is only because there is an electoral advantage perceived by certain members of the political establishment that we want to expand expand absentee voting to be no excuse absentee voting. But as I said, I'm okay with it as long as you put in the protections. Because like everyone else, I want people to participate in our election process. I want people to participate in politics. I want people to show up at our town meetings. I want people to come here to our public hearings. I want people to testify. I want them to tell us what they think. Our system only works when the public is informed and they're involved in our decision making. And I'm afraid the question that was put on the ballot in 2022 purposely misled the people. And we may have not got the result that they would have chosen if they had known everything that was happening today. And if every member of the voting public in 2022 that voted on that fateful constitutional amendment was privy to this conversation we are having right now here today, I can promise you that result would not have come out the same way. I looked at the underlying bill, and like Representative Carpino, I wouldn't say I was leaning towards voting for it because it still omits the most significant provisions that I think belong in such a proposal, which I'm going to get to in a minute. But at least it was a kind of a clean bill that succeeded in implementing the expansion that is implied in the constitutional question, even though the constitutional question, as I said, doesn't actually do that. All it did was restate what the current law was. When you ask somebody, should we make it illegal to run stop signs as a constitutional question, then people say yes. No surprise, that was the law. People were eligible to vote by absentee ballot, and they are now. And this bill doesn't really change any of that, except for the fact that it allows an open door to expand into so many other different areas, to create so many other schemes and mechanisms that will result in a massive expansion in the way people are able to vote in the state. There's talk of, and on the same agenda, by the way, I think those points were very, very well made by my colleagues, that we have an agenda with 52 items on it, and a lot of them are election related. Some of them are in direct contradiction to the policy that is in the bill before us. So I'm like, which one is going to supersede when they both pass? What's going to happen? Some things expand upon things that happen in other sections. It's really kind of a mess. It's a smorgasbord, not even really a buffet. What I would like to do is highlight what is missing. And that is the election integrity pieces that belong in our laws and have belonged there for a great many years. I've been offering these amendments time in and time again, and I've always been frustrated by the fact that they fail on party lines. One thing I point out almost every time we have a debate on significant election legislation is that this is one area where we ought to find agreement before we proceed. I mean, we can debate anything. We can argue over policy on almost any topic that there is in this building, and legitimately so. And there are elections that have consequences and put certain people in office and certain majorities in power for periods of time, and that's all well and good. But elections are a little bit different. Elections are the rules of the game. That is the game that we all have to agree to. It's like you can't have one party, and I used this example just recently, but you can't have one party in power to say, well, I know we were playing normal baseball before, but we're going to change the rules now so that this team gets to have 6 outs per inning and the other team still has 3 outs. That's kind of messing with the game. That's changing the basic element of fairness that I think is required. And if we cannot agree on the process by which people are elected, and if the minority party feels like the majority party is using their majority to change the rules about something as basic about that, about where we're going to determine who is actually elected, that is not what should happen in a republic. Frankly, I would caution the majority party in that sense to say that is really not a road to go down. History tells us that when we have political factions, if you read in the Federalist Papers, you understand all about different factions and why they exist and how they intermingle. One of the most important things you need to remember is that you got to respect the factions in a republic. If you don't respect the factions, you get rebellion. You get other toxic things to occur. And I'm not trying to invoke a rebellion today. I'm just suggesting that putting bills on agendas with substitute language at the last minute, doing things far out of bounds of what is expected, telling the voters you're going to implement something that's already the law, and then coming up with a 80-something page bill with hundreds of dozens of sections that do lots of other things beyond what was suggested. This creates a sense that the majority is overreaching. And without going too far down that road, I'll just suggest that there's been a lot of things that have happened in this legislative session that I think indicate that one-party rule is problematic at times. So with that, Mr. Chairman, I'm going to offer a couple of amendments to see if we can improve this bill. And I want to just remind you of something. Every time that we have debated no excuse absentee voting in the past, in this chamber and on the floor of the Senate, every time I have offered these amendments, and every time the response I've gotten from the two chairs of this committee is, not now, Senator, not now. We're doing the constitutional amendment. When we actually pass that and we do the policy, you will be included in the process. You'll get to be a part of how we make the law for actual no excuse vote, absentee voting. Well, I'm here to tell you, no one's come to me. This committee doesn't even screen bills with the ranking members. We find out what's on the agenda at 5:55 p.m. at the statutory deadline, and then we get language after that fact that is something different. And while I opened by saying that I do appreciate the chairs and they're very nice people and they're very accommodating, they still take every advantage. And there's no reason for that. In this legislature, the GAE committee is going to pass 4 or 5 bills, probably at best this session. But yet, we have 50-something bills on this agenda. There's still a meeting potentially for Monday. We've already passed a number of bills already. What's it all for? Is it to waste our time? Is it to distract people? Is it to show certain people out in the world, look, we're trying? So here is our chance. Here is our chance. I want to be involved. I want to make sure that I have the chance to offer my ideas to be part of this package so that the people that I represent, 100-something thousand people back in the 16th district, 5 glorious towns, Wolcott, Prospect, Southington, Cheshire, and Waterbury. Those people that live there, they have their voice heard. That's what I'm doing here. I have a lot of colleagues that serve in districts as Republicans, and they would like their voices heard too, and I know they agree with me on some of these things. So is the majority prepared to say, well, because we control most of the things, and maybe we have a slim majority of individuals across Connecticut that agree with us, we will discount the views of everybody else? That's the choice that is on the table today, ladies and gentlemen. So with that, Mr. Chairman, I don't know if the amendments have been handed out already. They have. I would like to start by making a motion to approve amendment item number 7, which I will describe very briefly. And it's basically an amendment that would say that there shall be no more unsolicited distribution of unsolicited absentee ballot applications.
Second.
Thank you. And when the vote is taken, I would like it to take it by roll, but I want to just finish what I was saying about what this is for. People listening, if you're not understanding what this amendment is about, let me just describe it very briefly. One of the problems with having absentee ballot voting is not that people are given the opportunity to vote without an excuse by absentee. That is perfectly fine. I think that's great. However, what it does is it opens a door. It opens a door to have people working on their own behalf, on behalf of candidates, on different political parties, to try and engage you in getting your ballot application in front of you signed and returned, and ultimately a ballot signed and returned. This opens another door, which is for people that work in mysterious ways, like in the city of Bridgeport, to come up with maybe some ballots and ballot applications that are not so legitimate. It also opens the door for chaos, as we saw in 2020 during the pandemic, when the Secretary of State mailed absentee ballot applications to everyone on our state voter rolls. And I don't remember the exact number. I used to know the exact number. It was a crazy number, though. It was like in the tens of thousands, might be in the hundreds of thousands of actual ballot applications that were returned in the mail. Not only does that cost a lot of taxpayer money to mail those all out, but think about how many were returned in the mail, indicating that the voter rolls were so way out of whack that they were just sending out absentee ballot applications to people who had moved, who had died, duplicates, you name it. And I had so many people contacting me saying that they were receiving ballot applications to their mailbox that didn't belong to them. They had lived in their homes for 15 or 20 years, and yet they're still getting ballot applications addressed to mysterious names of people that don't live there. This happened. It's well documented. I still have the stacks of envelopes that people handed to me. Nothing has been done about that. Every year, the Secretary of State is got an opportunity to address our voter rolls. It's in statute already, but it exists as a may. That's something that ought to be addressed. And I believe that our voter rolls are still extremely out of whack. And what this does open the door to is our state government or municipal governments going out of their way to mail ballot applications to every person on the voter rolls. And that means a lot of people who are not legitimate voters are going to receive these. And I will just say a quick aside without becoming a conspiracy theorist, which is that in 2020, when these ballot applications were sent to all of the addresses across the state, just ask yourself how many of them might have been misused. Ballot application comes to an address, it's for a person you don't know, but it's an opportunity to fill it out, send it back, and ultimately a ballot to come and send it back. Or maybe it's coming for your elderly parents who are not able to process it on their own, or it's coming for your child that's away in school or something like that. Do we really think that nobody abused that process? Do we think that no votes occurred that shouldn't have? Again, I don't want to say that this is some sort of grand conspiracy and tens of thousands of votes were stolen or misused, but there were some. I don't know if it was 1 or 10 or 100, but there were some. And that election, coincidentally, there was a state representative election in the town of Southington where I overlapped, decided by 1 vote. Gets one thinking about what's going on. So my amendment, once again, since I've been blabbing and folks may have forgotten, is to prohibit the unsolicited mailing of absentee ballot applications. Still allows anyone to be eligible, still allows anyone to ask. I think we should make it as easy to ask as possible. You can do it by phone, you can do it online, you can stop in the town hall. I don't mind if we make it even easier. I don't care if you come up with a phone application to do it. But the difference is, let the person actually ask for their absentee ballot. Do not send them out en masse. As I believe we've already moved adoption, and I do believe I have a second, and I've asked for a roll call vote. Thank you, Madam Chairman.
Thank you, Senator. Further comment or question on the amendment? Representative Hoxha.
Thank you, Mr. Chairman. I just wanted to take the opportunity to underscore what Senator Sampson said. Prior to his calling for his amendment, we were discussing the underlying bill, and I had brought up an example that I shared with this committee and those of you watching at home of a situation very similar to what Senator Sampson just described, and his comments dovetailed perfectly with what I had, or segued perfectly with what I was describing before. And it really is an important concept to understand for us as a committee to understand, and for voters to understand, and for everybody to really just have a good grasp on what this means. So when you're sending absentee ballots en masse, absentee ballot applications en masse, I want to be as accurate as possible with my characterization of these things. What you're doing is you have now created a vehicle or a tool by which to have a plausible sort of reason to approach an address where an absentee ballot application was delivered to. And as we know, with many examples throughout history, for various things, when a bad actor is equipped with a position of authority, a badge of authority, some sort of symbol of authority, and that person is also you combine that with bad intentions, you can get away with a lot. You can do a lot of damage. There have been cases where people posing as officials, maybe they actually were in some capacity, but essentially abusing that title to manipulate and sway a person's vote during this window between an absentee ballot application and when the absentee ballot gets ultimately sent back after being delivered. And there's been multiple cases of this that have happened even here in Connecticut in major cities where operatives are posing as officials or people that are there to help these individuals, and they target the most vulnerable in our society, and they say, this is how you fill it out, and this is who you're going to vote for, and these are the reasons why, and that's a ballot harvesting at its worst, and is actually illegal, but it's so hard to prove and to catch in the act that it rarely ever gets brought to the courts, brought to justice. There have been instances where election violations have been brought to justice, as we've seen with what's been going on in Bridgeport over the last few years and everything. But if it can happen, it's like Murphy's Law. If it can happen, it will happen. And I know that's sort of can seem like a bit of a drastic approach or standard to put on this subject, but it truly is. But it's not, because we're talking about elections, and that's what we as a country have fought for, is free and fair elections. Like, that's why we separated from the British, was to govern our own affairs. And if the citizens can't do that, can't feel that their government has a good grasp on, has good control over the how elections are conducted, then we lose faith in all our other institutions. And Senator Sampson's amendment, I think, goes a long way to work in the direction of bringing back faith and a sense of trust to the people for their in regards to their government and the various processes that government carries out, including elections. Because the moment you remove that tool of absentee ballot applications being sent out en masse, you have removed essentially the material to start the fire. As Senator Sampson said, if somebody wants an absentee ballot and requests it, that's totally fine. But if somebody doesn't, and you want to send it to them anyway, the average person is going to wonder why. Why? What's the motivation to that? that individual did not ask for that absentee ballot application. And if they want one, I'm all for running campaigns on how to better educate people. If they want one, there's a very simple process to go through to get one. But without that person requesting one, what are we doing? Why are we trying to pass laws to allow for, and I know that's not what we're passing today, but that's what the current law is. And adding this amendment takes that away from the current law, which is so destructive. Because again, why do we have that in our law to begin with? Something that enables bad actors to carry out their bad actions. There's no reason. There's absolutely no reason why somebody should be getting an absentee ballot application without requesting one. It just opens up the door to election fraud. There's so many different ways that you could commit election fraud with what currently stands as law right now. So many different ways, and I've highlighted a few. And I was talking about the instance where I ran when I was first running, and there was someone that I met at the door who was not any one of the individuals that was on my walk app. And that person, if they were bad intention, they could order 5 absentee ballot applications, fill them all out, send them back, get 5 absentee ballots, fill them all out for their candidate, send them back, and I would bet you that person would probably never get caught. It would never be prosecuted. It really needs to be very drastic. Violations really need to be very drastic and very out in the open and very egregious for this state to prosecute election crimes. And I think that's the direction that we need to be heading in, is better enforcement and removing the ammunition or the fuel that can start this fire. And I think this amendment is a really, really good step in that direction. And I think, if nothing else, what it does is it makes this bill more bipartisan. And it gives the committee a chance to show that it can be a committee that recognizes some of the good ideas of the minority party. So with that said, I urge my colleagues to vote for it. I don't know how it'll ultimately, I'm not too confident that it's going to pass, but for those reasons, I please urge you to consider it. It's really not that big of an ask in relation to the bill as a whole, but it certainly it could certainly alleviate a very big problem. Thank you.
Thank you, Representative. Further comment from the committee on the amendment. Representative Mastrofrancesco.
Thank you, Mr. Chairman. This amendment before us is a really good amendment, and it really should be bipartisan. Now, I suspect, if I could do an impersonation, I would, that our good co-chair over here is going to tell everybody on your side of the aisle to not support this amendment, because we already have a bill on this agenda that does that, or starts the process anyway. That's what my guess would be. We'll see what happens. You got to do better than that. But this is important. This is one of the things, this is one of the reasons why there's so much voter fraud in absentee ballots. This will stop it right in its tracks. If you want one, you should be able to request it yourself. There's no need for anybody to go out there to circulate applications for absentee ballots. It's a good amendment. This would truly show bipartisanship and a step in the right direction. I've always said on this one committee that if there's one issue that should be bipartisan, it's elections, because it affects everybody. And it should always be. But for some reason, it's not. And it shouldn't be that way. It's truly is unfortunate. We should work together to make it good, to make it the process fair, and that our constituents and the people of the state have true trust in our elections. And we don't have that today. And we have to do something to start the process. This amendment is perfect. But I'm assuming it won't pass, and we'll hear that we already have this bill on the agenda. But you know what? We can put it together, because that bill that was on the agenda that had at least it started the process was gutted, and everything on that other bill was put into another bill and that was just kind of left alone. There was no reason that that information could not have been put into 5001. It was done like that for a reason. We have bills on here that are identical. House bills are identical to Senate bills. There's no reason for it. So I would urge my colleagues to support the amendment. Thank you, Mr. Chairman.
Thank you, Representative. Further question or comment on the amendment? Seeing none, I will just say that I, as the good representative predicted, I'm going to urge my colleagues to vote against this amendment. This amendment is, in fact, far more expansive than the other bill that we're considering on this agenda today, which would take certain measures to prevent circulators from being involved in the process, but would not prevent mailings as would be prohibited by this amendment. Unsolicited mailings, excuse me. I actually think that there are situations where mailings of absentee ballots are helpful, and the pandemic was one of them. They were helpful not only for enhancing access to absentee voting in a crisis situation, but also for cleaning our voter rolls, because those ballots that were collected and were returned allowed people to be removed from the voter rolls and those voter rolls to be cleaned by the Secretary of State and the town registrars. And additionally, one of the things we've seen that is a problem is sometimes when there are in-person circulators. And sometimes mass mailings of absentee ballots can be helpful from removing those sorts of people from the process, or allowing a broader swath of people to gain access to absentee voting, as absentee voting for all does generally. And that increases deterrence against any misconduct, because you can never be sure that the person who you may be tempted to impersonate vote would not already be voted. And so, although I respect the, I guess, the intuitions and the intent of this amendment, I think it actually, first of all, is overbroad, and second of all, could actually work at cross purposes from the expressed intent. And for all those reasons, I urge my colleagues to reject it. And if there's no further question or comment, will the clerk please call the roll on the amendment?
A motion has been made and seconded for amendment number 7 on HB 5001. Senator Flexer. No. Senator Blumenthal.
No.
Senator Honig.
Senator Honig votes no.
Representative Morinbello.
No.
Representative Osborne.
No.
Senator Sampson.
Sampson is yes.
Representative Mastro Francesco.
Yes.
Representative Bronco. Yes. Representative Carpino. Representative Fonsello.
Yes.
Representative Gauthier.
No.
Representative Haddad.
Representative Haddad votes no.
Representative Hoeksa.
Yes.
Representative Johnson.
Representative Johnson votes no.
Representative Menapace.
In the negative.
Representative Rosario. Representative Santiago.
No.
Representative Shannon.
Shannon votes no.
Senator Winfield.
Senator Winfield in the negative.
Thank you, Mr. Clerk. Is there further question or comment on the bill before us?
Oh, yeah, no, we got a vote tally.
Oh, yes, sir. Sorry. Excuse me. Mr. Clerk, would you please announce the tally on the amendment?
Yes, sir. We have 6 in the yeas, 12 nays, 1 absent.
Thank you, Mr. Clerk. The amendment fails. So close. Sorry about that. A little rusty here. All right. Senator Sampson still has the floor. Senator Sampson.
Thank you very much, Mr. Chairman. That was highly disappointing, even though it was expected and predictable, and sadly so. I got so many political things to say that I know I'm not allowed to say, so I'm going to keep those to myself. However, I think that we very clearly stated the problem with mailing out a mass number of absentee ballot applications as long as our voter rolls are not kept up. And they are not kept up. There's evidence of that reappears regularly. There are businesses that use the voter rolls to do mailings, and they get countless items returned in the mail because the people they're mailing to actually don't live there. And I don't want to cast aspersions on every local government, town clerk, registrar, etc., because I know some places do a very good job. They're actually scanning the obituaries. They're actually monitoring things. When they mail something out and it gets returned in the mail, they follow up. They go through a process. The problem is that there's no real mandatory process on a state level. There is no proper references to compare things with. The Heritage Foundation puts out a scorecard that shows which states are doing what to preserve the integrity of elections. And our score is in the pits. And the reason why it is because almost all the things that other states are actively doing to preserve their election integrity are ignored in the state. And they're ignored for overtly political purposes because they affect populations based on race or geography. And I got to tell you, it doesn't make any sense because people, American citizens who have the right to vote, they really do value that vote. Doesn't matter who they are. And they want to preserve the integrity of elections into the future. And people aren't happy. I will tell you, the people that are most upset about what they're witnessing when they turn on the news and they watch what's happening in Bridgeport, for example, with the number of videos and surveillance footage and the court cases and, redo mayoral elections that the taxpayers have to pay for, et cetera. You know who's most upset about that? The people who live in Bridgeport. They're more upset about it than I am. That's those people and their votes that are not being accurately counted towards a result. I want to just also point out that the good chairman mentioned that this amendment might have been at cross purposes with the intent because the mass mailing of absentee ballot applications helps clean the voter rolls. I'm happy to say that is no way to clean the voter rolls, okay? That is like trying to get some dirt off the fender of your car by driving it into a bridge. You do not try and fix the voter rolls by sending out a bunch of erroneous ballot applications. That's what I'm trying to do here, is I'm trying to stop election fraud. I'm trying to stop even the possibility of election fraud, and I'm trying to do it without denying anyone a single thing. Everyone under my proposed amendment would have still maintained their right to vote by absentee without an excuse. I'm even happy to expand that further if necessary. The only difference is that I expect somebody who is going to vote by absentee to ask for their own ballot. There's a provision in this bill, by the way, that is an absolutely scary provision. As close as I was to possibly supporting the underlying proposal, the one thing that was really stood out to me when I got the substitute language is the permanent absentee provision. And we had the Secretary of State in this committee at a public hearing just a few days ago telling us that she is chomping at the bit to have some money from the state government to go out and send a mailing to everyone to tell them, hey, look, guess what? Not only can you vote by absentee, you can also sign up to go on the permanent list. Now, that might work very well for people that want to go on the permanent list who are legitimate voters who want to, but what an open door for crooks. Oh, man, You don't have to just scam to get an absentee ballot application sent to a fictional person or somebody who's not going to get it, that you can intercept it. You don't have to do it every year. You can just do it once. And now it's built in, it's baked into the process. Guess what? Them ballot applications are coming every year now. Oh, actually, it's ballots. It's not just ballot applications. That means ballots are actually going out automatically. I hope the press is paying close attention to this. I know that they try and do a good job, and it's hard to digest all of this stuff, just like it's hard for us to digest it. And it's not easy to talk about in a short few-minute conversation because it does get wonky. You start digging around in these bills, and you're like, oh, what's this? Oh, what's that for? Oh, my God, why are they doing that? And that's how I feel. So because I am concerned about the voter rolls legitimately, and I would like them to be cleaned up. By the way, I just want to point out that our voter rolls being a mess is only a problem under the legislation that we have here. Under my proposed view and the amendment that just failed on party lines, it wouldn't be a problem at all. Because in those cases, it's only people who are actually asking who are being checked by the town clerk. And then they're sent their ballot application and ultimately their ballot. But if you open the door to sending them to the voter rolls in the current condition, what a mess. And those voter rolls are constantly ever changing under the best of circumstances. People move. I mean, how many people, when they decide they're going to move, are like, oh yeah, I got to call the town clerk and tell them I moved and I'm no longer registered. And they're not going to do that. So the town clerk may be relying on some returned mail a year later. Maybe their ballot is getting returned in the mail because they don't live there anymore and they were in that permanent absentee ballot system. What happens when that ballot goes to the new person that lives in that house? So what I would like to do, Mr. Chairman, is offer another amendment. And this one, everyone should have in front of them. This one is identified as amendment number 4. And this would simply update our current statute that references the Secretary of State being in charge of maintaining our voter rolls, the list of names and addresses of eligible voters in the state who are active registered voters, and changes this to a mandate for that office. It says, very simple, after the last section of the bill, this is an add-on amendment, folks, notwithstanding any provision of the general statutes, the Secretary of State shall annually audit and update the voter rolls. That is all we're doing here. For the people listening, I want you to understand just how simple an amendment this is. I'm not trying to undo anything. I'm not changing the bill. I'm not erasing anything. All I'm attempting to do here is add one sentence into our laws, a requirement that the Secretary of State once a year audit and update our voter rolls. I think if we put that on a ballot, we'd succeed very easily. Let's see what happens when we actually vote on it. It's a very simple question. A yes means yes, you believe the Secretary of State should audit our voter rolls at least annually. And a no vote means, I guess, you're fine with the voter rolls being a mess. I move adoption, Mr. Chairman, and I'd like a roll call vote.
There is a motion from Senator Sampson, a second from Representative Carpino. Is there comment or question on the amendment? Further? Representative Manapayas.
Sorry, Senator Sampson, I was just wondering if you had any idea what the fiscal note for this would be.
Through you, Mr. Chairman, I do not know.
Okay, thank you.
Thank you, Representative. Further question or comment on the amendment? I will just say that while I respect and appreciate the spirit in which the amendment is offered, there's two issues as I see it with this amendment. One is that it is vague. It does not specify how the checks should be conducted, and that could leave a lot of interpretation open as to whether the Secretary were sufficiently fulfilling this duty, or were perhaps doing things based on this duty that were not expected or anticipated or desired. And another issue is that we have actually directed previously specific methods by which the secretary must actually fulfill this mandate. In 2024, we passed a bill that mandated that the Secretary of the State shall at least annually cause a search to be made of the computer voter registration records to identify electors who may be registered in more than one town or registered more than once in the same town. We also provided for additional checks that are similar to these through a cross-reference from input information from a list compiled from the jury administrator, so that it's cross-checked with the jury lists. So I am happy to continue a conversation about how we can continue to have our Secretary of the State's office conduct such maintenance of the voter rolls and keeping them up to date. But at this point, I urge my colleagues to reject this amendment. Further question or comment on the amendment? Seeing none, Mr. Clerk, will you please call the roll on the amendment?
Motion has been made and seconded for amendment number 4 on HB 5001. Senator Flexer.
No.
Representative Blumenthal.
No.
Senator Honig.
Senator Honig votes no.
Representative Morambello.
No.
Representative Osborne.
No.
Senator Sampson.
Sampson is yes.
Representative Mastro Francesco.
Master Francesco votes yes.
Representative Bronco. Yes. Representative Carpino. Carpino votes yes. Representative Fonsello.
Yes.
Representative Gauthier.
No.
Representative Haddad.
Representative Haddad votes no.
Representative Hoxha.
Hoxha votes yes.
Representative Johnson.
Representative Johnson votes no.
Representative Menapace.
No.
Representative Rosario. Representative Santiago.
No.
Representative Shannon. Senator Winfield.
Winfield in the negative.
Mr. Clerk, when you're ready, would you please announce the tally on the amendment?
Tally is 6 yeas, 11 nays, 2 absent.
Thank you, Mr. Clerk. The amendment fails. Senator Sampson, you have the floor.
Thank you very much, Mr. Chairman. Again, disappointed but not surprised. And this is kind of how it goes in this committee, which is that there's always a party line vote on an effort by the minority to put some sense back into the policy agenda that the majority has provided to us. It's almost like we've never had a good idea, not even one time. It's amazing. And it's somewhat remarkable, and I have to tell you, unbelievably frustrating. But I hope the people of Connecticut are watching. I think that this year things have changed a little bit. I've sensed it a little bit that there's more folks monitoring what is happening in their state government than ever before. And I think that's a good thing, because I think that it's really easy to vote against the will of the people when very few people are watching. But when they're actually paying attention, it gets a little harder to do. I've got a couple more amendments, and I think they're going to get increasingly more difficult to say no to. So I'll just throw that out there. Following up on the subject of audits and unsolicited or mailed ballot applications and the voter rolls, you know, there is a process that we could engage in right now that might help clean up the voter rolls, which we don't do. Every year I put an amendment or a bill forward, which has not been heard. But that shouldn't be a reason to discount it. It's not the kind of thing that needs a full-blown public hearing for people to understand. It is a very simple and straightforward concept. And I know that my conversations with municipal employees that run elections have been favorable. So I would like to offer, Mr. Chairman, another amendment. This one is identified as Amendment 2 in the package that was provided. And it says, after the last section, add the following and renumber the sections. Notwithstanding any provision of the general statutes, so this is another add-on to the end, doesn't change anything else, it's just, do you think this singular thing is a good idea? The Secretary of State shall conduct audits of absentee ballot applications and absentee ballots after each election to ensure that voters live at the address where such absentee ballot applications was sent and from where such absentee ballot vote was cast. I move adoption, and I'd like a roll call vote.
Second.
And a brief explanation is very simple. So if someone votes by absentee ballot and the mailings, either for the application or the ballot itself, or a registration document is returned to the Secretary of State after that election or in the process of that election, the Secretary of State would now be required to actually audit those to make sure that those folks were actually real people and that they were legitimate voters who cast those ballots. I think it's a very straightforward thing because it seems pretty odd to me that if someone casts a ballot and then ultimately they cannot be found, it makes you wonder whether that ballot was ever actually valid to begin with. So I think this is a very straightforward and simple amendment that we ought to adopt. And I encourage my colleagues in both parties to consider whether or not it's a good idea to try and do the littlest, the smallest effort of creating a process to clean this up. That's all I have, Mr. Chairman.
Thank you, Senator. The amendment is moved by Senator Sampson, seconded by Representative Master Francesco. Are there any questions or comment on the amendment? Seeing none. I will just urge my colleagues to vote against this amendment. This amendment does not indicate how the audits should be conducted, and as a result, would be vague. There is a provision in this bill to conduct risk-limiting audits with a specified procedure, which has been a bipartisan bill that we've all supported in the past, and I think would go significant ways to continuing to instill confidence in our elections and public trust. So I think that is a good step forward in that regard. I think there are other measures perhaps we could undertake to increase or strengthen those audits, but I think we should discuss those with the Secretary before doing so. And as a result, I urge my colleagues to reject this amendment. Mr. Clerk, would you please call the roll on the amendment?
Motion has been made and seconded for amendment number 2 on HB 5001. Senator Flexer.
No.
Representative Blumenthal.
No.
Senator Honig.
Senator Honig votes no.
Representative Morambello.
No.
Representative Osborne.
No.
Senator Sampson.
Sampson is yes.
Representative Master Francesco.
Yes.
Representative Bronco. Yes. Representative Carpino. Yes. Representative Fonsello.
Yes.
Representative Gauthier.
No.
Representative Haddad.
Representative Haddad votes no.
Representative Hoxha.
Yes.
Representative Johnson.
Representative Johnson votes no.
Representative Menapace.
No.
Representative Rosario. Representative Santiago.
No.
Representative Shannon.
Shannon votes no.
And
Was it your
Senator
testimony?
Senator Winfield in the negative.
Thank you, Mr. Clerk. And when you're ready, would you please announce the tally?
Tally is 6 yeas, 12 nays, 1 absent.
Thank you, Mr. Clerk. The amendment fails. Senator Sampson, you have the floor.
Thank you very much, Mr. Chairman. I guess audits are not okay either. How about the concept of signature or voter verification? You know, in previous debates like this on this subject matter, I have suggested that One of the problems we have with absentee or mail-in voting in Connecticut is that other states that use this process actually use a verification process to identify a voter at the time of registration. Back in the day, they used to just simply call it signature verification, although there's a lot of different ways to do it. But their earliest form was simply that when you signed up to register to vote, they would capture your signature. And some states actually captured your signature digitally to kind of get a nice exact version of it. And then when you voted by mail, you would of course have to sign that ballot, and that would be processed through a system that would match the signatures to say whether it was a 50% match or a 90% match and so forth. And the way that works in states that used it is what they would do is they would just automatically approve anything better than an 80% match, for example, allotting for the fact that some people's signature may change or decline over time. But then they would allow people that did not meet the 80% as a way to come in person or through some other mechanism cure those votes. It's a very effective system which happens to weed out anyone who's not actually truly the person who was supposed to be submitting that ballot. And I think it's very effective. So I've offered the amendment for signature verification in the past, but I'm not going to do that today because we've been doing a little bit of research and finding out that other states have evolved signature verification into more of an art form that has less to do with signatures and has more to do with a unique identifier that they associate with someone's identification. And I think it's a superior process. So I've drafted an amendment that I will offer in a moment that essentially makes a requirement that the state, the Secretary of State develops a program to implement a signature verification or unique identifier system like other states have to verify the integrity of mail-in ballots. If we're serious about expanding all of this mail-in voting, why aren't we doing something to make sure that we're matching up the integrity that belongs with it so people can trust that it's real? I move adoption of the amendment before me, which is kind of a lot to read, but I'll just summarize it to say that Secretary of State shall develop and implement a process by which electors shall receive a unique identifier for purposes of voting when registering to vote, and town clerks, registrars of voters, moderators, absentee ballot counters, and other election officials serving at polling places or central locations designated for the counting of absentee ballots as applicable shall verify each voter's identity by way of such voter's unique identifier upon the envelope of a returned absentee ballot, etc. We can certainly talk about any of the additional language that is in the amendment, but that's the idea. I move adoption, and I'd like a roll call vote.
So moved.
Amendment is moved by Senator Sampson, seconded by Representative Masfrancesco. Is there further question or comment on the amendment? We'll just say, seeing none, that well, I think we are very much willing to work on these sorts of programs as they continue to be developed. We heard from the Secretary that there is no program that she would adopt at this point, and that signature verification is actually a technology that many states are going away from because it actually has been shown to be unreliable in the sense that people's signatures change. There is improper or imprecise uptake on what these signatures actually look like, and it's somewhat subjective in terms of what a match is. And for all these reasons, that system has kind of fallen by the wayside. The system that we're putting in place today does have a scannable barcode for every ballot. It does have a unique identification number for every ballot so that these ballots can be tracked exhaustively throughout the system. And so I think as these systems are developed, as we have appropriations and the Secretary's best evidence on practicability, I think we are very interested in continuing to look at and potentially adopt in the future new mechanisms to do this. But as of yet, we do not have any that the Secretary has told us are practicable, and for all those reasons, I urge that the amendment be rejected. Just for the record, this is amendment number 8. Senator Sampson for the second time.
Thank you very much. Mr. Chairman, I appreciate you giving me an opportunity just to clarify. There was an amendment number 1 circulated that I have not called. That was specific to signature verification. This is a related amendment, but this is not signature verification. So the comments regarding signature verification are not important. I just alluded to the development of that process over time, beginning with signature verification and culminating in this unique identifier system, which I think is used in many, many states very effectively. Thank you.
Thank you, Senator. Seeing no further question or comment, Mr. Clerk, please call the vote on the amendment.
Motion has been made and seconded for amendment number 8, HB 5001. Senator Flexer.
No.
Representative Blumenthal. No. Senator Honig.
Senator Honig votes no.
Representative Morambello.
No.
Representative Osborne.
No.
Senator Sampson.
Sampson is yes.
Representative Mastro Francesco.
Yes.
Representative Bronco. Representative Carpino. Yes. Representative Fonsello.
Yes.
Representative Gauthier.
No.
Representative Haddad.
Representative Haddad votes no.
Representative Hoxha.
Yes.
Representative Johnson.
Representative Johnson votes no.
Representative Menapace.
No.
Representative Rosario. Representative Santiago.
No.
Representative Shannon.
No.
Senator Winfield.
Senator Winfield in the negative.
The tally is 6-12-1.
Thank you, Mr. Clerk. The amendment fails. Senator Sampson.
Thank you very much, Mr. Chairman. Again, another party line vote. I hope that folks are paying very close attention to the scorecard here about each effort to improve the integrity of our elections and who is voting in which way. And that leads me to something that I think it's been in the news a lot lately. You know, folks talking about the Save America Act, for example, which I know is a much larger policy document than simply just photo identification for voting. But that's what I'm here to talk about, which is that it's, in my mind, inexcusable not to have photo ID for voting, knowing full well that it is very popular with voters across the spectrum, and even among Democrats, it is widely popular. And this is a mechanism that is a no-brainer. You can't get on a plane. You can't cash a check. You can't buy certain medication over the counter at CVS unless you got a driver's license, right? I'm sorry, you can't. Oh, you can't shovel snow in New York. That's right. Yeah, our new mayor of New York required you to have photo ID to take on the job of becoming a snow shoveler. At any rate, the bottom line is photo identification is something that nearly every person does possess. It is a way that our state actually uses to make sure they're talking to the person they're talking to. When they pull someone over who's driving, what do they ask you for? Your driver's license. Why do they do that? Because they want to know who it is. And it has become the most substantial way of identifying individuals. And I have news for anyone who's listening. Elections are pointless unless you know who's actually voting. If you had a room full of people and you didn't say that, you know, hey, person A can't, you know, you're limited to one vote, person A. This is the problem we have, is that we do not have the proper protocols and protections in place. And this is the most basic of all of them, simply requiring photo identification. Now, I suspect we will hear from the majority, as they have said numerous times in the past when I've offered this amendment, that this is an attempt to suppress the vote, particularly in urban areas. That's all baloney. Nobody believes that. And my amendment not only allows for photo ID in the form of a driver's license, but it also allows for photo ID in the form of a state ID, so you don't need to be a licensed driver. And on top of that, it actually allows for folks to become eligible to have a state ID issued to them for free. And before I'm asked about a fiscal note, I don't think it's much. It's only going to apply to a few people who are not eligible financially to get one on their own. And I think it's money well spent. And when I say that, it means something, actually, because I'm the kind of guy who does not want to spend a lot of taxpayers' money. But this is an area where I think we can do better by making such an expenditure. Mr. Chairman, I move adoption of this very straightforward amendment. I won't read it. I'll just say it requires valid photo identification, which clearly displays such elector's name and residential address. And it does say that the DMV shall waive the fee associated with obtaining, for voting purposes, a motor vehicle license, identity card, or other government-issued form of photo identification without the means to pay for such fee. And it also provides a provision that says the state's public library shall provide a free photocopy of any elector's valid photo ID for purposes of voting by absentee ballot, which such fee shall be reimbursable by the state. So the excuses are out the window. There's no more excuses. Everyone should have a valid photo ID to vote in our elections. That is not a form of voter suppression. What is voter suppression is having the loose rules that we have that imply to many, many voters that their vote doesn't count, so they stay home. That's a form of voter suppression that's actually happening. The number of people that tell me that they're not voting because they don't trust our elections and they don't believe that the results are real, it's staggering. Now, I don't think our elections are that bad. There's certainly some element of fraud. But the number of people that are concerned to the point where they have just thrown their hands up and said, I'm not participating anymore, this committee right now has a chance to help fix that. That is incumbent upon us to do so, to make the situation better, to restore faith in our election process. This is a widely popular proposal. And I'm going to do everything I can to publicize this vote after the fact, to make sure people know how the people on this committee voted about this particular proposal, because they deserve to know. Because the people of Connecticut deserve photo ID for elections. Thank you, Mr. Chairman.
Amendment number 5 has been moved by Senator Sampson, seconded by Representative Master Francesco. There will be a roll call vote. Further comment on the bill? Okay. Yeah. Representative Morinville.
May I ask a question to the proponent of the bill? How would somebody who is unable to leave their home fulfill the requirements of photocopying their driver's license? I mean, plenty of people don't have copy machines in their homes, or printers, I guess, either.
Representative, I'm assuming you're asking the proponent of the amendment?
I am asking the proponent of the amendment through you, Mr. Chair.
Thank you, Representative.
Thank you very much, Mr. Chairman, and I appreciate the question. The amendment takes into consideration that folks might not have the means to afford or be able to obtain a photo ID from the motor vehicles. So we are waiving the fee, and we're also allowing for public libraries to provide a free photocopy of the valid photo identification. I am aware that the question is a little more specific, but in my experience, I know that folks do obtain state-issued photo IDs remotely through the efforts of social workers and other types of individuals who work for the state, who go out on site, meet a person in a nursing home or at their residence, collect the necessary information, and return to motor vehicles with that information. Through you.
Thank you, Senator. Representative?
May I just follow up? So through you, my question was more in regard not to obtaining your driver's license or a photo ID, but once you have it and you're elderly or you're homebound and you get your absentee ballot application and now you're ready to mail it in, how do you mail in a copy of that, I guess was my question. I understand that libraries will do it for free. That's wonderful if you're able to get out to the library, in which case you may be able to get out to early vote too. So I guess my question was more to how do people unable to get out of the house get a copy of their license to include in their absentee ballot through you, Mr. Chair?
Senator Sampson.
Thank you very much, Mr. Chairman, and I appreciate the question. I don't know that I have a specific answer. I think that in the vast majority of cases, you're going to have a family member who is capable of going out and making that copy of the ID for the individual. Again, there are social workers. I would volunteer to do it for any but one of my constituents. Certainly, if that was a impediment to being able to vote for one of my constituents, I would gladly go out to their home and help them procure a photocopy of their ID. I think that there's so few people connected with that question, and I do believe that every person does count, and we should find a way to manage that situation. But I don't think that that very, very specific instance that will affect a very small number of people should stand in the way of passing this legislation, because I do believe we can account for those people very, very easily as well.
Thank you, Senator. Further questions from the representative? Representative Master-Francesco.
Thank you, Mr. Chairman. I can tell you from the time that I have been on this committee, we have been trying to push for photo ID, I don't know, since I've been on here, 2019, 5 or 6 years. And we keep hearing excuses of why we can't do it, why it will disenfranchise voters, which is a ridiculous argument. When people say that, it actually, it's actually an insult to the people that they're, the people in the community that they're talking about. Because believe it or not, our voters in the state are pretty smart. They know how to get an ID. And when I hear the questions about, well, who's going to pay for it, you got to be kidding me. The state could pay for it. And for the record, just in case the question comes up, what's the fiscal note on this, is that we don't get a fiscal note until something's passed out of committee. That's the process. And maybe our freshmen and the committee don't really know that, but that's the process, and that's what happens. It's like with any other bill. We'll find out what it costs. But you know what? This state wastes so much money on other things. I think we could afford to give people a state ID so they can vote. And in reference to the question about how are they going to get their photo to vote with the library and so forth, listen, we make accommodations for people. It's not a problem. We want everybody to vote. We want everybody to, but we want it to be a legitimate vote. And we should accommodate those people, no problem. So I urge my colleagues to support this amendment for the, how many times, Senator, have we put this amendment in? And I'm sure it'll be amended. We'll put it in again on the floor. But it's common sense. You know, 80% of the people in this country agree with some sort of identification to vote. Even the Democrats on the other side of the aisle agree with it. It's just common sense. I'd urge my colleagues to support it. Thank you, Mr. Chairman.
Thank you, Representative. Further question or comment from the committee? I will just say for a couple reasons that I urge my colleagues to reject this amendment. One is the questions asked by the good vice chair, which I think illustrated some of the obstacles that some people may have to obtaining a photocopy of an absentee, excuse me, of identification to submit with their absentee ballot. One of the things we've been trying to do on this committee is make it more convenient and easier for people to vote. Every time the government sets up roadblocks to people's right to vote and they're not able to vote as a result, it's a great offense to the right. I will say that I think members of this committee agree with Representative Master-Francesco's indication that most people agree that there should be some form of identification to vote. And indeed, Connecticut does have identification required to vote. It just doesn't happen to be certain photo identification. And so there have been data assembled by various organizations about how these sorts of provisions would affect individuals' right to vote. Depending on the organization and the study, They indicate that somewhere between 7 and 9% of voters could be disenfranchised by such a measure. And that's maybe because they don't have photo identification at all, but it may be just that their photo identification is out of date. They may have moved, so their address is no longer operative on their current identification. They may look different than their photo. There may be some other indication or reason why they would be disenfranchised by such a measure. And creating such a roadblock to people and disenfranchising people in that way, I think would be the opposite of what we're trying to do with this bill. And for all those reasons, I urge my colleagues to reject this amendment. Seeing no further question or comment, Mr. Clerk, would you please call the roll on this amendment?
Motion has been made and seconded for amendment number 5 for HB 5001. Senator Flexer.
No.
Representative Blumenthal.
No.
Senator Honig.
Senator Honig votes no.
Representative Morambello.
No.
Representative Osborne.
No.
Senator Sampson.
Sampson is yes.
Representative Messer Francesco.
Master Francesco votes yes.
Representative Bronco. Yes. Representative Carpino. Yes. Representative Fonsello.
Yes.
Representative Gauthier.
No.
Representative Haddad.
Representative Haddad votes no.
Representative Hoeksa.
Yes.
Representative Johnson.
Representative Johnson votes no.
Representative Menapace.
No.
Representative Rosario. Representative Santiago.
No.
Representative Shannon.
No.
Senator Winfield.
Senator Winfield, in the negative.
6-12 to 1, sir.
Thank you, Mr. Clerk. The amendment fails. Senator Sampson.
Thank you again, Mr. Chairman. Again, disappointed, not surprised. A party line vote defeating a amendment request to create a requirement for photo identification being necessary to vote in the state of Connecticut, including provisions to provide that photo ID for free to those who need it. It's very disappointing knowing that the people across this great country and across our state, including people in all political parties, overwhelmingly support it. I appreciate the chairman's comments about disenfranchisement, etc. The whole idea that my colleagues would try and suggest that somehow because myself and other Republicans are supporting a photo ID requirement that we're somehow disenfranchising anyone is so absurd it shocks the senses. And the argument about the random 1 in a million individual who is unable to leave their home to get out to vote, we can accommodate a circumstance like that very easily. I said so. That person would not end up being disenfranchised at the end of the day. Anyone who's in that kind of circumstance, they're receiving some sort of help or treatment. They have family members. There's some other mechanism. I would defy anyone to point that person out to me and say, there's the person right there you're disenfranchising. And guess what? If you pointed them out to me, I would go take care of photocopying their license for them personally. So the idea that somehow we're the folks that are trying to disenfranchise people is absurd. The people that are being disenfranchised are every voter that is a valid voter in the state of Connecticut, because they're being denied the knowledge that their vote fully matters and is not being diluted by fraud. That's who's being disenfranchised. And I got news for my colleagues. The people of Connecticut already understand that. Maybe the information doesn't get to them all the time about what's actually happening here and what's being voted on so that they can make informed decisions. But that's changing. And people are going to become aware more and more about the votes that are taking place here and who stands for what. I'd also correct the chairman when he suggests that we do require photo identification for voting. The law in Connecticut is, well, he said photo identification, and then he said photo identification in some cases. And both those statements are true, except that I want to just add one caveat to that, which is that you can vote in the state of Connecticut without any identification at all. You're required to have identification to vote in Connecticut, but not photo identification to vote in person, which means you can bring an envelope that has that's addressed to you. Allegedly, that's proving that's you, right? It's absurd. And under some circumstances, you do need a copy of your driver's license to actually vote absentee, which is a good thing. It's already in place for some circumstances. I think it's for new absentee voters in some cases. So what I'm doing here is not a stretch. I guess when that passed, that wasn't an inconvenience to the person that was stuck at home. Just when I offer it. But there is a situation when people are same-day registration voters. Somebody in Connecticut can walk up to the polls on Election Day, and as long as they were in line at 8 o'clock, it could be 9 p.m. at night in New Haven, and they can say, no, I got no ID, I got no nothing, I want to vote. And guess what? They can vote in Connecticut. They simply have to sign an affidavit that suggests that they're John Smith. And I just moved to New Haven yesterday. That's why I'm not on the voter rolls. Sorry, Mr. Town Clerk, Mr. Register. It's a terrible policy. I didn't support it when it occurred to begin with. Anyone who wants to be part of our election process, I think they know it's out there, and they can take some personal responsibility to become a part of that election process by registering. We make it so easy. Same-day registration is just a mechanism to muck up the process and create potential for problems. And I wasn't going to offer this amendment, but since the good chairman brought up the fact that you need ID to vote, and I know that's not true in the case of same-day voters, same-day registration voters, I have an amendment. This one, much like the other one, would audit those people. Because the process right now is John Smith shows up in New Haven and says, I want to vote, but Mr. Smith, you're not on the voter rolls. Well, yeah, I just moved to town, but can you please let me vote? Okay, sign this affidavit. We'll put your ballot through the machine. And then at some point in the future, after that vote has been counted, the election's done, the person who was elected is in office, at some point in the future, that town will register that voter. They'll actually put them through the process, and they will create them and put them on the voter rolls. And then when they do, they'll send a confirmation letter to that person. Now, guess what happens next? Either that letter is gone forever and it never comes back. John Smith was probably a real guy. Thank heavens. But sometimes those get returned back to the town. And it makes you wonder, well, who the heck was that John Smith character or came in to vote at the last minute on that day? You know that I have been trying to get a bill passed in this committee for years to audit those returned envelopes for same-day voter registrations. And you know what? Never gets heard, never gets a vote. But it's a situation. In Connecticut, you can vote without any identification at all, photo or otherwise, and we don't even bother to audit the process if those registrations are returned later. We should change that. We should change that. And we have an opportunity right now. It's a simple vote. Again, notwithstanding anything in the other bill, not changing anything, just adding a single sentence. Is it a good idea that we should be doing this? Ladies and gentlemen, the Secretary of State shall conduct audits of same-day registration ballots after each election. And no, it doesn't specify the mechanism for how it's done. That all can be filled in later. The good chairman knows that. That is an excuse. And if there was a desire to amend this to state the requirements, I'm open to it. We can amend my amendment right here and right now. It's a very simple question. Should we be auditing people that same-day register and their envelope for their registration forms comes back in the mail? Yeah, we should. Anyone with common sense knows that. Watch how people vote. I move adoption, and I like a roll call vote.
So moved.
Amendment 6 is moved by Senator Sampson, seconded by Representative Master Francesco. Or was this 3?
It's Amendment 3.
Amendment 3. Excuse me, correction. Amendment 3, moved by Senator Sampson, seconded by Representative Master Francesco. Further question or comment from the committee? Okay. Seeing no question or comment, I will urge my colleagues to vote no on this amendment. We're happy to continue a conversation on whether and how this could be enacted, but as it stands, it doesn't designate how it would be, and we don't know whether from the Secretary it is practicable, and as a result, I've urged my colleagues to vote no. I would also note that part of the provisions of what we're enacting here would specify that certain individuals who are doing same-day registration would need to have, if they don't have identification, they would need to have someone else swear under oath that they are who they say they are and that they're a resident of the district. And so, with all that being said, I would urge my colleagues to reject this amendment. Mr. Clerk, will you please call the roll on the amendment?
Motion has been made and seconded for amendment number 3 for HB 5001. Senator Flexer. No. Representative Blumenthal. No. Senator Honig.
Senator Honig votes no.
Representative Morambello.
No.
Representative Osborne.
No.
Senator Sampson.
Sampson is yes.
Representative Messer Francesco.
Yes.
Representative Bronco. Yes. Representative Carpino.
Yes.
Representative Fonsello.
Yes.
Representative Gauthier.
No.
Representative Haddad.
Representative Haddad votes no.
Representative Hoxha.
Yes.
Representative Johnson.
Representative Johnson votes no.
Representative Menapace.
In the negative.
Representative Rosario. Representative Santiago.
No.
Representative Shannon.
No.
Senator Winfield.
Senator Winfield, in the negative.
6-12 to 1, sir.
Thank you, Mr. Clerk. The amendment fails. Senator Sampson.
Thank you very much, Mr. Chairman. Again, disappointed. Another very simple provision that we could have added to our omnibus bill. I mean, it was never about how, oh, gee, the bill's too long, we can't add anything to it. I was adding a sentence to this 83-page monstrosity. But no, can't do that. Too much of a good thing, I guess. So I'm going to offer one more amendment, Mr. Chairman. And this one has to do with the provision that I noticed appears on the bottom line, line 723, on page 23 of the bill, which sets up a mechanism by which the Secretary of the State shall develop and conduct a statewide public awareness mailing, beginning as soon as practicable after the effective date of this section, to educate the public regarding changes to the absentee voting process and the availability of permanent absentee ballot status.
That's insane.
I wonder what the fiscal note is for that. Anyway, they're going to spend a lot of taxpayer money to send out mail to everybody in the state going, hey, by the way, we know you know how to vote, but you have this new thing, you can sign up for permanent absentee voting. And I have no objection to an awareness campaign. In fact, if I had my way, I would do this bill with the First Amendment I offered intact, that would have eliminated any of the mailings at all, and just put out a very, very significant public awareness campaign so that people would know that they have the ability to request an absentee ballot. To me, that's a far more cost-effective solution for the people of Connecticut. The taxpayers don't have to buy a stamp for every single person, including the people that have moved or don't exist at all. It's just a public awareness campaign that tells people what their opportunities are to vote. To me, that makes much more sense. And it doesn't create an opportunity for the Secretary of State to promote herself, because she is, in fact, a elected official. And again, this is a policy that would outlast this current Secretary of State, so I'm not casting aspersions specifically to our current Secretary of State, but any Secretary of State in the future would also have the ability to go ahead and use this language to put out a lot of mail about the voting opportunities that exist with their, smiling face and their name and title on it, and probably would coincide with the election, I would imagine. So I have some concerns about that, and that might have something to do with some things that have happened in the past. But either way, this is a very good policy proposal that I've got ready. This is amendment number 6. I don't think it's the sixth one we've done, but this one is entitled amendment number 6. And this amendment would say that the Secretary of State shall not use the name, image, or likeness of any candidate for public office or any elected public official, including the Secretary, in any public awareness campaign developed and conducted by the Secretary of the State for purposes of educating the public in matters relating to elections or voting during the 90-day period immediately prior to a primary election. Basically, this is a very straightforward amendment that would prohibit the mailing that is the part of the public awareness campaign from including the likeness of people that are very likely to also be candidates as well as the current office holders. I move adoption, Mr. Chairman, and I would like a roll call vote.
The amendment is moved by Senator Sampson, seconded by Representative Mastrofrancesco. There will be a roll call vote. This is Amendment 6. Is there further comment or question on the amendment? Representative Mastrofrancesco.
Thank you, Mr. Chairman. Mr. Chairman, this is really a common sense amendment. I was thinking, you know, when you're during an election time, the Secretary of State sending out maybe a campaign awareness of what, I guess that's what you're calling it. No elected official's name or face should be in that advertisement. That makes sense. To me, that's a conflict of interest. I believe I saw, I think it was in this bill, that when you're sending out an application for an absentee ballot, you're not allowed to put campaign materials in there. This would actually, this makes sense. It actually goes with that. The Secretary of State, as much respect that I have for her, when you're in the middle of a campaign, you shouldn't be putting mailers out or promotions, promoting yourself. I think we saw this on a national level. Somebody spent a lot of money and they no longer have a job. I think people know what I'm talking about. I agree with that. Money shouldn't be spent, and it shouldn't be spent here in Connecticut, regardless of what party you are. It makes a lot of sense. So I would urge my colleagues to do the right thing and vote for this amendment. Thank you.
Thank you, Representative. Further comment or question from the committee? Seeing none, I think I agree in principle with some of this amendment, or at least the thrust of it, which is that we shouldn't have publicly paid for mailings displaying a candidate for an election going out in proximity to the election. And I think we could actually work something out in this vein. I don't think this language does it, but I think I can commit, and I think the co-chairs can commit to continuing to discuss this. I urge my colleagues to reject this amendment today, but I do think the spirit of it is already in the bill with regard to the provision that Representative Mastrofrancesco identified, and I think that we can probably find some sort of measure in the future that may prevent the proximity of having we can prevent having publicly paid for mailings with a candidate on them being sent out in proximity to the election. With that, I urge my colleagues to reject the amendment. And Mr. Clerk, will you please call the roll on the amendment?
Motion has been made and seconded for amendment number 6, HB 5001. Senator Flexer.
No.
Representative Blumenthal.
No.
Senator Honig.
Senator Honig votes no.
Representative Morambello.
No.
Representative Osborne.
No.
Senator Sampson.
Sampson is yes.
Representative Mastrofrancesco.
Yes.
Representative Bronco. Yes. Representative Carpino.
Yes.
Representative Fonsello.
Yes.
Representative Gauthier.
No.
Representative Haddad.
Representative Haddad votes no.
Representative Hoxha.
Yes.
Representative Johnson.
Representative Johnson votes no.
Representative Menapace.
No.
Representative Rosario. Representative Santiago.
No.
Representative Shannon.
No.
Senator Winfield.
Senator Winfield, in a negative.
Tallies 6-12-1, sir.
Thank you, Mr. Clerk. The amendment fails. Senator Sampson.
Thank you very much. Mr. Chairman, I'm glad we were able to finish with the amendments. I'm very disappointed that, I don't know how many there were, 7 or 8 total, that every one of them came down on a party line. As I mentioned a couple of times throughout, it's expected, but it's so disappointing. You know, I know that the chairs are sincere when they indicate that they appreciate the thrust of an amendment or something like that, but at the end of the day, they're not happening. You know, it's been years, and we don't have photo ID. We don't have a voter verification process. There's other amendments that I've offered in the past, and we'll certainly see if this bill continues on to the floor, and it no doubt will. We'll talk about increasing penalties for people that commit voter fraud. We'll talk about different ways that our voter file ought to be verified for its integrity. We're gonna talk about all of that because we need to. What needs to happen beyond me offering these amendments, however, is a real discussion about the policy and how it's going to affect Connecticut, and hopefully some bipartisanship in the way we agree to handle our election laws, which, as I mentioned earlier, are the rules of the game that we are choosing our elected officials by. There is no reason for these votes to be partisan votes. There really isn't. We can disagree on a lot of things, but when we're disagreeing about the rules that decide our elections, it should be concerning to people across the state. I don't really have a lot more to add to our conversation. I'll say for the record that I did my absolute level best to understand this 83-page, 56-section monstrosity between the time that I got it at 10 a.m. and then had to come speak about it in front of you folks only a couple of hours afterwards, along with the other 51 bills on our agenda. But I don't know every letter of it. I can only imagine the things that I did not find in the process, since anyone who's ever looked at legislation will realize that it is not so apparent when we're constantly referring back to different statutes, and maybe a simple comma or a bracket here or there can make a world of difference, just like a change from a may to a shall or vice versa. But what I do know is that this bill represents the desire of the majority to expand their voting practices that have benefited them electorally in the past, with little regard to the actual quality policy that you would put in place if you wanted to ensure accurate and honest elections. And that's the battle and the choice that people are going to have to weigh in coming elections, is who's standing for policies that benefit them electorally, and who's standing for policy that benefits the people they represent. And with that, Mr. Chairman, I'll just simply state that I will not vote for this today, but I will hope that you and your co-chairman take the time to sit down with myself and my colleagues and address some of the concerns that you have indicated that you have a basic agreement with, so that we can incorporate them in this policy ultimately when it becomes law in the state of Connecticut for the betterment of the people that live here. Thank you.
Thank you, Senator. Further question or comment from the committee on the bill? Seeing none, Mr. Clerk, will you please call the roll on HB 5001?
Motion has been made and seconded to JFS to the floor, HB 5001 with LCO 3490. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Senator Honig,
Senator Honig votes yes.
Representative Morambello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sampson is no.
Representative Mastro Francesco,
Master Francesco votes no.
Representative Bronco, Representative Carpino, Representative Fonsello,
No.
Representative Gauthier,
Yes.
Representative Haddad,
Haddad votes yes.
Representative Hoxha,
Hoxa votes no.
Representative Johnson,
Representative Johnson votes yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Yes.
Representative Shannon,
Yes.
Senator Winfield.
Winfield in the affirmative.
Tally is 12-6-1, sir.
Thank you, Mr. Clerk, and the votes will remain open, as I said previously, until at least the end of the meeting or a time that we designate later. Next up is item number 5 on our agenda, House Bill 5533, an act concerning protection of election administration processes, election sites, election workers, and electors. The clerk, this is a JFS to the floor of LCO 3500. The clerk will entertain a motion. Or the clerk will also entertain a motion, but the chair will entertain a motion.
So moved. Second.
Moved by Senator Flexer, seconded by Representative Morin-Bello. This bill would institute a number of protections for our elections and voters in our elections. It would prevent those given law enforcement or detainment power from being within 200 feet of an election site unless authorized under the bill, which contains a number of exceptions, including the permission or request of the moderator or the Secretary of the State, exigent circumstances necessary to protect a serious risk to life or property. It contains certain mass prohibitions within 250 feet of an election site. It prevents and prohibits the possessing of a firearm or deadly weapon within 250 feet of an election site with a number of exceptions. It prohibits tampering with a tabulator or tabulator part, tampering with an absentee ballot drop box. It also modifies certain penalties for harassing or improperly influencing election workers, expands the existing election worker protections to assistant municipal clerks. It gives the Attorney General to file certain complaints with the State Supreme Court regarding certain election interference claims, and expands when the Attorney General may investigate certain civil rights claims. Is there further question or comment on this bill? Senator Sampson.
Thank you very much, Mr. Chairman. I understand that this is a kind of a two-part bill. The second part of this bill we've seen before, the part restricting private gun ownership and the carrying of a firearm within 250 feet of a polling place. But I will come back to that after we address the first part of the bill, which seems wholly political to me. We've never seen this bill before. It seems like it was created out of the atmosphere that is surrounding the national political discourse having to do with ICE agents in various jurisdictions across our country. I'm not aware of any problem in the state of Connecticut that has to do with federal agents appearing at polling locations. And I would presume that if they are there, they are there to do a job. Mr. Chairman, can you cite an example of something that has occurred or what a potential circumstance might be that would warrant the Section 1 of this bill through you?
To you, Senator, no such action has actually happened, but our laws currently prohibit law enforcement agents at the polls without their presence being requested by the moderator for the reason of preventing anyone from being deterred from voting and also to establish trust in the election and prevent any aspect of potential intimidation or misuse of law enforcement in that manner. This would expand that to the 250-foot zone. There have been comments by the President of the United States indicating that he would like to nationalize elections, take over elections. Certain allies of the President have urged him to use law enforcement in that manner and send them to election sites. Certainly, if he does not do so, and there is no such action, then this bill will become unnecessary, and that is our desire. We don't want that to happen, and there's certainly no reason for it to happen. This bill is a precaution to deter any such misconduct, and as a result, we have promulgated it. And it's a response to the very real fear that exists of such action being taken. I can speak for myself. I've received numerous contacts, postcards, letters, emails on this issue. and Connecticut can take action on it, and we are. To you.
Thank you very much, Mr. Chairman. I honestly do not know how to react. I mean, this sounds like a Facebook conversation that I'm in right now, not something that is legitimately before a legislative committee in our state legislature. I hear this same kind of rhetoric on a day-to-day basis on the evening news coming from politicians of all stripes at all different levels of government, but we tend to leave that outside the building. Mr. Chairman, you know, I don't think that there's anyone who legitimately believes that the President of the United States is going to become a dictator and decide that we're going to put armed troops at the polls to make sure they vote him in for a third term or something like that. That is bizarre. And if there are people out there that believe that, they only believe it for one reason, and that is because there are people spreading the same exact kind of rhetoric and commentary that we just heard. Because it's not true. And I'll just tell you, as a loyal Republican voter and supporter my whole life, one of the things that defines our party is our desire to stand up against government and authoritarianism. I mean, that's what makes America America, is the fact that we rebelled against a authoritarian dictatorship in the form of King George, and I carry that badge of honor personally. Anybody else decides they want to become a king in America, I'm going to be the first guy trying to stop them. It's very ironic the way the majority behaves in this legislature, that they would be concerned about authoritarianism coming from the President of the United States. The way this committee is run, the way the bill agendas are assembled, the way the minority is limited to access and ability to debate, the way the leadership of the legislature engages in emergency certification, limiting public hearings, threatening people's microphones. That's authoritarianism. Not the president making offhanded jokes about nationalizing elections or whatever that no one takes seriously, and the people in his own party, I guarantee you, would be the first ones to say no. You can count on that from me. As the chairman mentioned, this hasn't happened because it's not going to happen. But let's just talk about it seriously, even though it's really hard to do, frankly, because it's a bit of a joke. Wouldn't a federal law enforcement official who is on duty investigating whatever they're investigating have the right to be at the polls based on the notion of common sense and the ability to do their job? Through you, Mr. Chairman.
To Senator, I can't speak to the notion of common sense in a legislative committee, but as a legal matter, the answer is no. The law currently prohibits law enforcement agents of any stripe from being at the polls unless they have the permission of the moderator, and that is for good reason. And we don't need to have law enforcement actions happening at the polls without the permission of the relevant election authorities, absent exigent circumstances. And so that's why that's the current law. This would merely expand that to a 250-foot zone with a number of exceptions, as I discussed, and are laid out in the bill. To you.
Thank you very much, Mr. Chairman. Certainly want to talk about that range of 250 feet. I think it definitely creates some additional problems. But this is a state law you're referring to, not a federal law. And there are cases where the federal government has supremacy, and one of those circumstances happens to be the reason why this bill's here, which is all about ICE agents. I mean, the federal government has supremacy on the notion of prosecuting and illegal immigration and protecting our borders. So presumably, if there was an ICE agent at the polls investigating someone that they suspect is in the country illegally, a criminal alien, for example, I believe that they would have the right to proceed. Can you tell me why that wouldn't be the case? Through you, Mr. Chairman.
To you, Senator, the federal law enforcement are subject to the laws, including the state laws of wherever they are operating in all their activities. The exception to that, and the exception to this statute, or excuse me, this bill, as the Section 1 lays out, is if they have a judicial warrant allowing them to do so. And this bill contains that provision. In order to do so, all they would need to do is actually have a specific probable cause developed based on facts for the reason for being there. And they just have to go to a court and get an order or a warrant allowing them to do so. Our police do it every day. In fact, they can't actually, they can't enact any arrests unless they see a crime happening in front of them without such a warrant. And so there is no reason why ICE or any other agency would need to use or need to engage in such activities in the vicinity of the polls. If they got a warrant, they would be allowed to. So there's no reason for them to do it without a warrant. I would also note that there are federal prohibitions on certain personnel that are included in this bill being at the polls as well, and this would incorporate by reference those provisions into our state law. As a general matter, federal officials, including federal law enforcement, are subject to state law that is generally applicable to you.
I appreciate the lawyerly answer, Mr. Chairman, but it's not factually or substantively correct. The fact of the matter is that immigration officials operating at the request of the federal government, they do not need a judicial warrant to apprehend someone who's in the country illegally, particularly a violent criminal alien. And saying that they need one doesn't make it so. Also, while anyone is subject to Connecticut statute, whether they're a federal law enforcement agent or not, there are other conflicting laws. For example, just because the state of Connecticut tries to consider itself to be a sanctuary state and dictate to numerous state and municipal officials, police officers, and so on, what they can and cannot do with respect to federal law doesn't mean that they can't get themselves in a lot of trouble with the federal government. Our Constitution matters, Mr. Chairman, and our system of laws and justice very clearly lays out that one of the areas that the federal government has supremacy, and for those listening, what that simply means is that that's an area outside the norm where the states and individuals ultimately control their conduct. The federal government maintains the authority over our borders and immigration. And they don't have any requirement from a federal standpoint to have a judicial warrant. And they are doing a job, a very important and valuable job. And they are taking criminals off of our streets that are harming American citizens. The political left in this country has tried to paint that as if it's something that it's not, that these folks are harassing people based on the color of their skin, or they're rounding up innocent civilians and sometimes citizens. And I'm not going to suggest that sometimes a incident occurs that is outside the normal policy, but that happens now with anything. You can have a local police officer make a mistake, but that's not the policy of this country. It's not the policy of this administration. The policy of this administration is to capture criminal aliens and protect Americans. And I'm very thankful that they are doing that, Mr. Chairman. And this bill, to me, is so unbelievably misguided that it will actually protect criminals. And I can't imagine why you would want to do that. I can't imagine why anyone would want to put legislation forth that creates a safe haven, effectively a criminal-free zone. It's appropriate that it goes with the second part of this bill, which is like creating a gun-free zone. People who are watching this, I guarantee you the same thing's running through their head that's running through mine right now. Because it seems to me like the only people who don't get it are some of the people in this building. Because when I talk to people on the street, no matter whether they identify as Republicans or Democrats, they have common sense. And they know that when government goes out of its way to create zones where people are not allowed to carry a gun, guess what? Those become victim zones. Those are places where criminals feel like they have free range to do what they wish. So this bill does two things. This bill creates a gun-free zone where a criminal intent on causing harm is going to know that the people that are within 250 feet of a polling location are unarmed and cannot defend themselves. All of these school shootings and massacres that people like to hold up as examples of the terrible tragedies that are attributable to guns, they're not attributable to guns, they're attributable to maniacs and the lack of guns in defense. That's what they're attributable to. Creating more gun-free zones is extremely dangerous and unwise. There's a reason why our Constitution creates a mechanism for people to be able to maintain their right to defend themselves. And that's because law enforcement can only do so much. Law enforcement is not going to show up at the polls to save people necessarily, especially since this legislature is passing laws to keep the law enforcement away. What a combination. Let's make sure there are no police at the polls to protect anyone, and let's make sure that citizens cannot arm themselves to protect themselves in case something happens. Let's do both of those things. Sounds like a recipe for disaster to me. This is one of the most misguided bills I've ever seen. Not only is it so utterly political and misguided and focused on whacking around the president or making some larger political statement that has nothing to do with reality, but it's also bad policy. It's dangerous. We had a great many people over the years come and testify in opposition to the second part of this bill because it's unworkable. I know that they've tried to include as many exceptions as they could possibly think in the language, but you didn't get them all. There's many other exceptions that could exist. What if there's a business that is within 250 feet of a polling location? And I guess, this is a much bigger deal today, for example, than it was in the past, because now you have early voting, right? That could extend the time frame that this is going on for. If they actually, by the way, implement early voting the right way, where it's not just the town halls in towns that are actually doing the early voting, and it was actually including the other polling locations to provide real access to voters in big cities that we've advocated for. If they actually started doing that, you'd have an even bigger problem. The danger here is that people are going to get caught up in this that don't deserve to. And you're very expressly denying the constitutional freedoms that are guaranteed by the federal government in our Constitution that apply to Connecticut citizens. So I appreciate the chairman trying to explain to me what federal laws apply and what we can do and this and that. Well, I got one for you. That is, the U.S. Constitution says you have a right to bear arms and to defend yourself and to carry a firearm to do so. And you shouldn't be willy-nilly denying people the ability to do so because you think it's inappropriate a certain number of feet from a certain activity. That's not a good enough reason. And I can start asking a lot of questions like, why 250 feet? Not why 100 feet? Why not 300 feet? There's no good answers to these questions because there are no answers. They're just arbitrary numbers that remind us of the majority's arrogance when they just simply tell us, we are going to do it this way because that's what we think. That's all. Is there any data, Mr. Chairman? Probably not. I strongly oppose this bill, and I strongly oppose it on policy grounds, but I got to tell you something, Mr. Chairman. I oppose it on other grounds, too. The fact that it's offensive, because it is just trying to make a political statement. You acknowledged right out of the gate that this has not happened in Connecticut. I doubt you actually think it's going to happen. I don't want to put words in your mouth. You can respond to that if you choose. But I don't think it's going to happen in Connecticut. So this is just out there for headlines. We had the press in here just now because it's going to get a reaction. They can put it on the news to talk about, oh boy, they were talking about Trump and ICE in the GAE committee. We ought to be talking about election integrity. and the previous bill, and we ought to be adapting policy that actually makes sense. But instead, you've created a dog and pony show distraction among the 50 some odd bills that are on this agenda. It's a waste of time, and it's an insult to those of us who actually came here to do work.
Thank you, Senator. Further question or comment from the committee? Representative Carpino.
Thank you, Mr. Chairman. I actually just have a few technical questions about intent. And just to confirm, another batch of JFS, I want to make sure I'm looking at the correct LCO 3500.
To you, that is correct.
Okay, so then I'd like to direct you to 61, line 61, sir. It refers to medically necessary or of religious significance when they're talking about the ability to wear a mask in a polling place. How will that be verified or documented, sir?
To you, Representative, that would be based on the representation of the individual wearing the mask or the obscuring covering.
Okay, so just so I understand for legislative intent, anybody who declares themselves to have a medical need or a religious need can wear a mask into a polling place?
To you, Representative, this bill does not actually, it doesn't affect any existing requirements of identifying oneself. So they would have to unmask at some point and when they're going into the polling place in order to be identified most likely. But, you know, there's not going to be a specific investigation of the individual's basis for wearing the mask or other covering. They're going to have to make a representation that it's medically necessary or religious significance. That may be verifiable based on just the presentation of the individual if there is something obviously not the case about that. Like, but other than that, this is a general prohibition subject to certain exceptions. And the ultimate indicator here is whether someone is asked to leave or asked to unmask and refuses to do so, as in the weather conditions exception. So ultimately, it's going to be based on a representation of the individual and whether an obvious investigation or a kind of prima facie investigation would disprove that representation to you.
And I appreciate that, but I want to be very, very clear, not to sort of give you a hard time, but, you know, our moderators and our poll workers work really hard to do the right thing and to get things right. And I want to make sure that everybody who walks in wearing a mask under this exception is treated fairly. And actually, to the contrary of what you indicated, I don't want people being judged on how they appear. I want there to be a simple, straightforward method so that poll workers in Cromwell or Cornwall treat everybody exactly the same. So if I walk in with a mask and decide that it's medically necessary, maybe I just don't feel well that day, does a poll worker have either the right or the obligation to ask me to unmask, and if so, when?
To you, Representative, they may be able to ask you to unmask in terms of identifying you sufficiently to vote. I don't think in practice that's how they would be empowered to do so. What would actually happen is if the person had some sort of situation that did not appear to be prima facie meeting the conditions, what they would do is they would call law enforcement, who could then verify that if necessary, and the interaction would go from there. In most cases, I imagine it would not be an issue to you.
And I thank you, but that's actually more troubling to me. So I show up, I'm wearing a mask, I just don't feel well. So I want to vote. They know who I am. They don't ask me any questions. Hi, Christy. You have your driver's license. Here you go. Street do you live on? I proceed. But somebody else who might appear differently, who might dress differently, have a different background, a different demographic, are they going to be asked for additional identification or put through additional paces because they're wearing a mask? That seems really unfair, sir. It seems like the very discrimination that this body really works hard to avoid in our day-to-day. Troubling to me. Moving down in this section, again, for legislative intent, and by no means to be difficult on our Friday night, Line 77 seems to indicate that an exception to that section is knowing that such person is not permitted by law to do so. And while I realize it may not be riveting language to the non-lawyers in this room, I've never seen ignorance of the law to be an excuse. Can you please explain that provision to me?
To you, Representative, this is accommodating some of the concerns we heard in public hearings, which is essentially people unknowingly being swept into this prohibition because they don't understand the implications of the law. Ultimately, we don't want to unknowingly or accidentally sweep lawful gun owners into this net. In practice, what would happen is the only way you could possibly prove that the person knew that they were not permitted to have a firearm in this zone would be if someone noticed that they were carrying and informed them, you're not allowed to be carrying here, please don't carry here, and then they refused to follow that direction. And so we wanted to make sure that no one was being accidentally swept into this and accidentally criminally charged just because they didn't think of the law, or didn't know where they were, if they didn't know they were within 250 feet. So this is a protection. We want to give the direction, don't carry within this zone, but you're not going to be subject to the criminal prohibition unless you actually know, and you can be proved to be known beyond a reasonable doubt that the law was in effect and that it affected you, to you.
And thank you, and I appreciate that. So I'm going to advise everybody, should this proposal pass and become into law, that the first thing they should say if questioned is, I didn't know. It is never advice I've ever given to a client when defending themselves from something. I guess we all learn new things here in this building. Never would I expect that scenario to be on the LSAT. My last question, again, very technical, but trying to understand the intent, is line 92. It starts with on private property. And again, we're talking about lawful possession of a gun owner, and it is, I just want to make sure how I understand, and again, I'm trying to protect innocent people from being swept up in overreaching legislation. Does this provision also include in private property? So in the event a gun is lawfully secured in private property, in the parking lot of a polling location, and somebody is aware of that, how would that be treated under this bill, sir?
To you, Representative, there's actually a specific, there is a specific provision for that condition, which is if it's being kept not loaded in a locked container or a locked rack in a motor vehicle. So that specific provision is in the bill. That's a protected condition in which the person would not be subject to the prohibition. And I will just say that these exceptions are imported from the federal Guns in Schools, or Gun-Free Schools Act of 1990. As many of us know, the vast majority of our polling places in Connecticut and across the country are in schools, and so firearms are already prohibited on those grounds and actually within 1,000 feet of those grounds. So this is actually a lesser prohibition that applies to the handful of election sites that are not already schools and therefore prohibited locations for firearms. But we have imported all of the federal exceptions to that law into the state law, or into this bill.
And I thank you for your answer, and I thank you for your patience. Had we not been handed this mix and match hours before the actual meeting, I would have had the ability to actually go through and cross-reference all of those. But these are just a few examples of items that are not going to be understood by our constituents as we're voting on these on a Friday night without really comprehensive explanations. So each one of these are important to the people who are going to be subjected to the will of this committee, and it is the will of this committee. It is, I agree with some of my colleagues, it is not an open and honest discussion about what is actually in the best interests of our constituents. So while I appreciate your explanations, the fact that they are not readily apparent to members of this committee should give us pause when we're seeking to impose them on 3+ million people. Thank you, sir.
Further questions or comment from the committee? Senator Sampson.
Thank you, Mr. Chairman. I apologize for going a second time. Following the conversation we just had with Representative Carpino, I wanted to just clarify something. I think that I heard the conversations went something along the lines of someone attempting to approach the polls wearing a mask. Basically, what would have to happen is the poll worker would end up having to contact law enforcement, I think you indicated, Mr. Chairman. And if that's the case, does that mean that somebody would have to have an obligation to share their medical records and history with law enforcement before being allowed to vote?
To you, Senator, no. They would have to share it with the moderator, who would then have to see it as an issue of sufficient import to share it with law enforcement, at which point, if law enforcement saw there being a reasonable suspicion that an unlawful action was happening, then they could arrive on the scene. I think, in all likelihood, virtually every interaction that would be entailed by this prohibition would be one where the person just says, I have a fear of this medical condition and I'm wearing a medical mask, or it's cold out, I'm wearing a scarf, and they would just be let go because there's no reasonable suspicion that they're committing a crime. And so it would have to be something very obvious indicating that they're not telling the truth. And I just can't imagine a circumstance except someone operating in obviously bad faith and doing something else that was disturbing or causing disorder or something like that, where this prohibition would come into play. To you.
I appreciate the answer, Mr. Chairman, but it's just as troubling suggesting that the moderator would be entitled to that information as a police officer. You're talking about someone's right to vote here. I can't even believe what I'm hearing. I mean, the conversation in this committee is about Republicans attempting to suppress the vote by wanting for voter identification. And yet the proposal from the chairs of this committee is that we should require people to declare their medical history to the moderator of an election to be able to vote. I asked a very straightforward question. I just heard the chairman say that he didn't say that, and I'm more than happy to give him an opportunity on the record. But I asked because I heard they need to call a police officer and explain it to them. And when I asked that question, you said no, they'd have to explain it to the moderator. And if the moderator wasn't satisfied, they'd have to explain it to a police officer. So do they have to explain it to the police officer or the moderator or both or who? I want to know whether you're going to restrict somebody's access to the polls to cast their vote, something they have a right to do as a citizen, unless they declare their medical history, and to whom?
To you, Senator, I was explaining the process by which someone would actually, this would actually become an issue that law enforcement would become involved in. As I indicated, they would not have to provide their medical history or any background information, because if they simply responded that they were wearing it for a medical reason, or because they were cold, or for a religious reason, there would be no reason to inquire further unless there were an obvious sign that they were misrepresenting that. And for everyone who is not causing a disturbance in a polling place, there is no evidence that they would be not telling the truth about that. And so there would be no basis for a police officer or anyone else to inquire further. So you would not need to go into your medical history. You would simply need to represent that either the mask is medically, or the covering is medically necessary, there's a weather-related reason, or it's an item of some religious significance. To you.
I appreciate the clarification, Mr. Chairman, but I still find it unbelievably disturbing. And I think it is an absolute mechanism that denies people the freedom to exercise their right to vote, and I'm offended by it. And I think that the addition of religious significance is also problematic. I mean, are you suggesting that some people, because their religion requires them to wear a face covering, are more entitled to be able to vote with a face covering than people are not? I mean, I don't understand any of this language. This is bureaucratic nonsense run amok, gone wild. I mean, it's like, this is just baffling. All these years we've been able to manage no problem, right? You know, I can't recall, having a disturbance at the polls because somebody was wearing a mask or not, as long as I've been alive. I don't recall ever hearing about it once. Okay, and now we got a bill. This bill that basically starts to put in these stupid stipulations. We're gonna make a bill about keeping federal agents away from the polls because we want to make Trump look bad. And by the way, we're gonna make sure that people of certain religions can vote with face coverings, but anybody else has to be questioned about their medical history. It's Looney Tunes. The comedic rundown writes itself. I'm a no on this bill. Thank you.
Thank you, Senator. Further question or comment from the committee? Seeing none, Mr. Clerk, would you please call the roll? Madam Clerk?
No
we now
worries.
have Madam Clerk.
No worries.
Madam Clerk, will you please call the roll?
This is a roll call vote on item number 5 of the agenda, House Bill number 5533, an act concerning protection of election administration processes, election sites, election workers, and electors, to be JFS to the floor with LCO number 3500. Senator Flexer?
Yes.
Representative Blumenthal?
Yes.
Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is no.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? No. Representative Fonsello?
No.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa?
Hoxa votes no.
Representative Johnson?
Representative Johnson votes yes.
Representative Menapace?
Yes.
Representative Rosario? Representative Santiago?
Yes.
Representative Shannon?
Yes.
And Senator Winfield?
Senator Winfield, in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 6, SB 463, an act concerning security of election administration processes, election sites, election workers, and electors. This is a JFS to the floor of LCO 3501. The chair will entertain a motion.
So moved. Second?
Moved by Senator Flexer, seconded by Representative Osborne. This bill is based on the JFS, identical to the previous bill we just did, HB 5533. And it's simply a Senate vehicle. Further question or comment on the bill? Representative Mas-Francesco.
Yeah, I just wanted to reiterate that this bill that we're doing right now is the same as the exact same one as we did before, and just to urge my colleagues to say no. That's it, Mr. Chairman.
Thank you, Representative. Further question or comment on the bill before us? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 6 of the agenda, Senate Bill number 463, an act concerning security of election administration processes, election sites, election workers, and electors, to be JFS to the floor with LCO number 3501. Senator Flexer?
Yes.
Representative Blumenthal?
Yes.
Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is no.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? No. Representative Fonsello?
No.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad is yes.
Representative Hoxa?
Hoxa's no.
Representative Johnson?
Representative Johnson votes yes.
Representative Menapace?
Yes.
Representative Rosario? Representative Santiago?
Yes.
Representative Shannon?
Yes.
And Senator Winfield?
Senator Winfield, in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 7, Senate Bill 393, an act concerning special elections to fill vacancies due to the death of an elected official. This is a JF to the floor. The chair will entertain a motion.
Second.
Moved by Senator Flexer, seconded by Representative Metapace. This bill simply says that when a vacancy in the legislature is due to the death of the representative or senator, that the date on which the governor issues the writ calling for a special election to fill vacancies will be delayed by 7 days. And this is simply to allow the family and friends of the member to grieve them or have a period to grieve them before the electioneering around their replacement begins. Further question or comment to the committee?
May I just add to that?
Yeah,
briefly?
Senator Flexer.
Thank you. I think many of us who've been lucky enough to serve in this legislature for some time, we've had, unfortunately, several of our colleagues have passed away. And I know in recent years, examples like, God rest their souls, Representative Linda Orange, Representative Q. Williams, and Representative Kevin Ryan. I know the circumstances that happened after their passing made it so that their friends and family, and oftentimes those of us who are lucky enough to do this work, oftentimes your friends and family are also the people who are involved politically at home. And many of those folks had to be involved in the machinations of the election process for filling those vacancies before they had much time to process the death of their loved one, our colleague, or had time to go to any sort of service or even know that those services were set up. So this is just an effort to try to recognize the humanity in the process that we all go through to get this job and to give some more space when there are vacancies that are due to death and death only, not other vacancies in the legislative office. Thank you, Mr. Chair.
Thank you, Madam Chair. Further question or comment from the committee? Seeing none. Oh, Representative Mastrofrancesco.
No, Mr. Chairman, I would agree with the good senator. I agree with you. Sometimes I see these unfortunate situations happen, and I have no words. So I get it. I certainly support this bill. Thank you.
Thank you, Representative. With that, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 7 of the agenda, Senate Bill 393, an act concerning special elections to fill vacancies due to the death of an elected official, to be JF to the floor. Senator Flexer?
Yes.
Representative Blumenthal?
Yes.
Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is yes.
Representative Mastrofrancesco?
Yes.
Representative Bronco? Yes. Representative Carpino? Yes. Representative Fonsello?
Yes.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa?
Hoxa votes yes.
Representative Johnson?
Representative Johnson votes yes.
Representative Metapace?
Yes.
Representative Rosario? Representative Santiago?
Yes.
Representative Shannon?
Yes.
And Senator Winfield?
Winfield in the affirmative.
All right, thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 8, SB 394, an act implementing the recommendations of the Risk Limiting Audits Working Group. This is a JFS to the floor of LCO 3497. The chair will entertain a motion. So moved by Senator Flexer, seconded by Representative Metapace. This is our annual bill to implement the recommendations of the Risk Limiting Audits Working Group. It has been bipartisanly supported in the past, and I'm very hopeful that we can get it across the finish line this year. Further question or comment from the committee? Representative Mastrofrancesco.
Thank you, Mr. Chairman. Just wanted to verify this is the same bill that we've been doing, for the past few years. No changes, nothing new in here. To you.
To you, Representative? Yes.
Thank you. This has been a bipartisan effort for this bill, and I certainly will support it today. Oh, did you say there was a change?
The only change is in the dates of implementation.
Yeah. Okay. Thank you.
Is there further question and comment from the committee? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 8 of the agenda, Senate Bill number 394, an act implementing the recommendations of the risk limiting audits working group with JFS number 3497. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Senator Honig,
Senator Honig votes yes.
Representative Morin-Bello,
Yes.
Representative Osborne,
Yes.
Senator Sampson, Representative Mastro Francesco,
Yes.
Representative Bronco, Representative Carpino, Representative Fonsello,
Yes.
Representative Gauthier,
Yes.
Representative Haddad,
Haddad votes yes.
Representative Hoxa,
Yes.
Representative Johnson,
Representative Johnson votes yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Yes.
Representative Shannon,
Yes.
and Senator Winfield.
Winfield in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 9, Senate Bill 395, an act studying efforts to increase voter participation and authorizing municipal pilot programs to promote such efforts. This is a JF to the floor. The chair will entertain a motion. So moved. Second. Moved by Senator Flexer, seconded by Representative Morin-Bello. Tie goes to the vice chair. This bill establishes a task force to study increasing voter participation and civic engagement. It will make a report to the legislature, and it authorizes municipal pilot programs seeking to achieve greater voter participation. Further question or comment from the committee? Representative Francesco.
Thank you, Mr. Chairman. So this here is a task force. If you can explain to me the difference, and I hear this all the time, I'm always confused, the difference between a task force and a study. Through you.
To you, Representative, I'm honestly not aware of one.
Okay, thank you. I thought the difference was a task force will make recommendations, will actually, and I could correct me if I'm wrong, I'm not really sure. The task force will make recommendations and bring them to the legislature, where the study is just kind of gathering information. Am I wrong on that to you?
Representative, I am honestly not sure if that terminology kind of matters. This provision, or this bill does direct that a report be provided to the legislature. So I am not aware of any legal significance to the use of task force as opposed to study language.
Okay.
But ultimately, for the purposes of this legislation, there will be a report to the legislature, to you.
Thank you. I think this bill is really not necessary, because is there any reason why? Well, one, why do we need to have a task force? Can't municipalities and do it on their own? Why do they need to have why do we need a task force to study how they're going to increase voter participation? Why do we have to have a law? Can't they just do it now, to you?
To you, Representative, I think municipalities could currently if they wanted to, but this would create a task force that's looking at a more statewide basis, to you.
Thank you. And this is what makes me nervous about this type of stuff. One, municipalities can do it right now. When you mention statewide, I see a mandate on a town that they need to increase voter participation when they can just do it now. Campaigns can do it now. In my mind, there's absolutely no need at all to have a task force, because that's where it starts, right? And then before you know it, it's a law, and then it's a mandate on a town. But the effort is to achieve 100% voter participation. I mean, it would be nice, but are you kidding me? Do we really think we can get 100 voter participation without it being forced or people fined? I mean, it's nearly impossible. It's not even reasonable. Maybe it's like that in other countries, because there's consequences if you don't vote. But I don't see that happening here. I don't have any other further questions. I just think this is not necessary. People can do this on their own. Towns can just increase voter participation. We don't need a law. We don't need a task force. Just my opinion. Thank you, Mr. Chairman.
Thank you, Representative. Further question or comment from the committee? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 9 of the agenda, Senate Bill number 395, an act studying efforts to increase voter participation and authorizing municipal pilot programs to promote such efforts to be JF to the floor. Senator Flexer?
Yes.
Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Mornbello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson's no.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? No. Representative Foncello?
No.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa?
No.
Representative Johnson?
Representative Johnson votes yes.
Representative Menapace?
Yes.
Representative Rosario? Representative Santiago?
Yes.
Representative Shannon?
Yes.
And Senator Winfield?
Senator Winfield in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 10, Senate Bill 458, an act designating various days and months. This is a JFS to the floor of LCO 3489. The chair will entertain a motion.
So moved.
Second.
Moved by Senator Flexer, seconded by Representative Menapace. This is our annual days, weeks, months bill, although it appears we don't have any weeks currently. The JFS language simply amends when Lobster Roll Day occurs and adds some additional history for Hiram Bingham the Fourth Day. Further question or comment on this item? Representative Menapace.
I just wanted to take a moment to thank you, Mr. Chair, and I had the opportunity to speak to David Bingham, Hiram's son, who I will just say is very proud to be at 86 years old, still playing ice hockey and still winning games and scoring goals, which I can tell you as a person who plays against him is a little frustrating at times. But he had asked for a very small change that we would acknowledge that Hiram was just one of many people who worked to save so many during this time. The Hiram Bingham IV is a very, very interesting guy, as well as his dad, and frankly, David, one of his 11 children, is also an extremely interesting person to be known. And I just wanted to thank the chairs for working so we can make that very small accommodation. Thank you.
Thank you, Representative. Further question or comment from the committee? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 10 of the agenda, Senate Bill number 458, an act designating various days and months. Senator Flexer? Oh wait, to be JFS to the floor with LCO number 3489. My apologies. Senator Flexer? That's okay. Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Mornbello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is yes.
Representative Mastro Francesco?
Yes.
Representative Bronco? Yes. Representative Carpino? Yes. Representative Foncello?
Yes.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa?
Yes.
Representative Johnson?
Rep. Johnson votes yes.
Representative Menapace?
Yes.
Representative Rosario? Representative Santiago? I don't believe we can hear you, Representative. Representative Shannon?
Yes.
Senator Winfield?
Senator Winfield in the affirmative.
And Representative Santiago?
Yes.
Thank you.
Thank you, Madam Clerk. Next up is item number 11 on our agenda, Senate Bill 459, an act concerning the Secretary of State's recommendations regarding the circulation of Actually, we're going to go to number 12 next. Come back. Item number 12, Senate Bill number 460, an act concerning a study of whether unclaimed gift certificates should be considered abandoned property. This is a JF to the floor. The chair will entertain a motion.
Second.
Moved by Senator Flexer, seconded by Representative Shannon. This bill requires the treasurer to study the benefits and advantages of allowing gift card balances to a sheet to the states as unclaimed property and report his findings to the GAE committee by January 1, 2027. Is there further question or comment on this bill? Senator Sampson.
Thank you very much, Mr. Chairman. Just trying to understand this. I get the fact that people often buy gift cards, and sometimes those gift card balances are unused, especially if there's a small amount. Somebody gets a $100 gift card and they use $98 of it, and there's $2 hanging around. I probably got a whole slew of those myself. I understand that there may be some desire in this bill to see that money find its way back to the individuals who actually own it, but I'm not sure that's what's going to happen based on what's here, because I think that this bill is designed to give the treasurer control and access of that money. Can you just talk me through how this came about and how this will work, and who, what the process is, and will consumers ultimately benefit through you?
To you, Senator, this is simply a study, so I don't think I could determine or tell you how exactly it would work, because I think that's the purpose of the study. And it may or may not work. The study would provide us information on that to you.
Yeah, thank you, Mr. Chairman. The only thing I would say about such a study is that it's the treasurer actually conducting the study. And I understand the treasurer's office is responsible for taking care of our unclaimed property account. But I don't know that it's in their interest to collect these gift card dollars. There's a whole debate here. This is kind of a complex conversation, because I think that the businesses that offer gift cards factor in the fact that there is a certain percentage of the money that will be unclaimed when they sell them. And some people might complain about that and say that that shouldn't excuse the money from disappearing, and I don't disagree, except it's a fact. And if that changes, then the gift card offers that exist will probably change as a direct result to that. And I don't know that people would be happy if that happened. I'm kind of just opposed of the treasurer doing the study. I don't have anything against the treasurer per se, but I think that this is something where we ought to have a disinterested third party look at how this process works, how our unclaimed property system works. We have an excellent constituent who contacts us regularly about the unclaimed property situation. I'd be really curious to hear what he has to say about this situation, since he's a veritable expert on the subject of the unclaimed property. What's the name of the website again? I always forget. The Big List. That's right. Yeah, he's an expert on the Big List, and I wish I knew half as much as my constituent does on this subject. So I'm going to be a no today. I understand it'll probably go forward. I would just recommend that maybe this study ought to include some other parties. It would be my suggestion. Thank you.
Thank you, Senator. Further question or comment from the committee? Representative Mastroianniello.
Thank you, Mr. Chairman. Yeah, I was just looking up. I concur with Senator Sampson. But yeah, it's ironic that the Treasurer's Department is actually doing this study, and there's no testimony from them at all. No comments, no testimony, nothing. So I don't even know if they even approve of this or where they stand on it. It would have been nice to hear from the Treasurer. So for those reasons, I'll be a no today. Thank you, Mr. Chairman.
Thank you, Representative. Further question or comment from the committee? Representative Carpino.
Thank you, Mr. Chairman. I thought I might be misremembering, so I just went to the DCP Commissioner's site, and it does confirm that for most gift cards, there's no expiration date. And again, for most gift certificates and gift cards, a business must already provide a cash refund upon request for cards with a balance of less than $5. So I actually don't understand how this could possibly work, because if I have a gift card, it's in my pocket. And the treasurer isn't going to have any idea what's out there. They're not going to know what was sold if I'm in the state of Connecticut or how much of it I've redeemed. So I'm not going to support this simply because I don't understand the fundamental goals and how they would be executed. It's a little quirky, sir.
Thank you, Representative. I don't know if there was a question there, but I'll swing it to Senator Flexer, and she, I think, will give a bit of explanation on that to you.
Thank you, Mr. Chair, and I appreciate the good representative's confusion. I think maybe there just needs to be some clarity on the problem we were trying to get at here, and I think there's just not a good label or terminology to use in our statute. So I will confess that I think we need to find maybe a better way to talk about this. So this idea came to us from a few members of the committee who had read about see, the problem, they're not really gift cards. They're not really gift certificates that we're talking about. We've read about how companies like Starbucks and others, they are some of the biggest banks in the country because we all load up cards on our apps on our phones, and they're holding on to money. And sometimes that money turns over when you update your phone, when you get a new phone, maybe you get a new account for that app and that money disappears, or it just automatically renews. Right? You spend down to a certain amount when you order your coffee in the morning, and then it automatically renews. Then Starbucks is holding on to that $25 for a long period of time. So this is just an effort to look at that, to see if there's a better way to capture consumers' money if money is being lost. So it's a little bit different than the things we've done in the past with regard to the guarantee that gift cards don't expire in Connecticut, that I think was done like 20 years ago, or the work that Senator Miller has done to give people refunds on the balances of their gift cards. This was looking at that somewhat newer technology. So I think maybe the use of the phrase gift certificates in here is something we should look at a little bit more critically as we work with the treasurer, potentially looking forward on this. But that's the goal, is to try to look at that more specific app-based issue. Through you, Mr. Chair.
Thank you, Senator. Representative?
Thank you. And I appreciate that adds a little more context. Because it is a bit wonky as of now, I'm going to vote no, but should language actually better capture what we're trying to get at, I'm happy to have conversations later. Thank you.
Thank you, Representative. Further question or comment from the committee? Seeing none. Madam Clerk, will you please call the roll?
This is a roll call vote on Senate Bill number 460, an act concerning a study of whether unclaimed gift certificates should be considered abandoned property. To be JF to the floor. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson's a no.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? No. Representative Fonsello?
No.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa?
Hoxa votes yes.
Representative Johnson?
Rep. Johnson votes yes.
Representative Menapace? Representative Rosario? Representative Santiago?
Yes.
Representative Shannon?
Yes.
And Senator Winfield?
Winfield, in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up is Next up on our agenda is item number 16, Senate Bill 468, an act concerning contracts with nonprofit human services providers. This is a JF to the floor. Chair will entertain a motion.
So moved.
Second.
Sorry, moved by Senator Flexer. I didn't catch the second. Who was that? Representative Gauthier. This is a bill that we've done before, has come very close to passage into law. This would require OPM to review certain nonprofit human services providers, provide reports. It would require them to consolidate certain reports that are overly burdensome or duplicative. And it would also require them to amend existing policies and procedures to generally require private provider organization to receive payment for any services under a purchase of service contract no more than 45 days after receiving a completed claim or service receipt, whichever is later. Further comment or question from the committee? Representative Carpino.
Thank you. I just want to thank the committee for continuing to try to move this ahead. I think all of us work with nonprofits. I've had the ability to actually serve on a nonprofit board for a number of years and actually see what the finances look internally. Our nonprofits across the state do such good work, often at a very cost-effective method. And when it is the entity that is asking them to help by caring for some of our most vulnerable, and we turn around and we can't figure out how to pay them, I think it is sad. I could use many other words, but on a Friday night, I'll stick with sad. It is discouraging. We ask them to do so much. The very least we could do is actually pay them in a reasonable amount of time. I don't know of businesses who operate in that method where, at least for a long period of time, because frankly, their business partners would probably seek to do business with others. The fact that we're also going to finally move ahead with our promise to get rid of just duplicative and essentially irrelevant documentation is another important piece, but the payment piece is important. There are nonprofit providers across this state. They know no political beliefs. They are there. They serve anybody we ask them to serve, and the very least we can do is actually pay them in a reasonable amount of time. So I just want to really share my strong support for this. Thank you.
Thank you, Representative. I would echo your comments. Further comment or question from the committee? Seeing none, Madam Clerk, would you please call the roll?
This is a roll call vote on Senate Bill number 468, an act concerning contracts with nonprofit human service providers. 2BJF to the floor. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson's yes, sorry.
Representative Mastro Francesco?
Yes.
Representative Bronco? Yes. Representative Carpino? Yes. Representative Fonsello?
Yes.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa?
Hoxa votes yes.
Representative Johnson?
Representative Johnson votes yes.
Representative Menapace? Representative Rosario? Representative Santiago?
Yes.
Representative Shannon?
Yes.
And Senator Winfield?
Winfield, in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 17, Senate Bill 469, an act implementing the recommendations of the State Contracting Standards Board. This is a JFS to the floor with LCO number 3496. The chair will entertain a motion.
Yes. Second. Oh, sorry.
Senator,
I'm sorry.
the chair understands that to be a motion. Senator Flexer has moved. Representative Shannon has seconded. This bill would clarify certain estimates for appropriations and allotments, require the state contracting standard boards to have at least 5 full-time employees. It requires certain notice of rights for various entities involved in the contracting processes. It would increase the threshold for waiving competitive bidding requirements to $25,000. Further question or comment on this bill? Representative Massa Francesco.
Thank you, Mr. Chairman. You mentioned something in here that believe that they have to have a minimum of 5 employees full-time? And I was just curious as to why.
I will direct your question to Senator Flexer.
Thank you, Mr. Chair. Representative, through you, Mr. Chair, Representative, this is a bill, as you probably remember, that we've had many times in the past, and the concern has been that in the long road to get the Contracting Standards Board fully up and running, one of the methods that people who ran the executive branch and various administrations used was to not fully staff the board. And so this seeks to make it a requirement that the board always be fully staffed so that whoever occupies the executive branch can't use understaffing this agency as a way to not have contracting under this level of scrutiny as prescribed by the statute that creates the board. Through you, Mr. Chair.
Okay.
Representative?
Thank you. Through you, Mr. Chairman. So before, it was they were able to have up to 5 employees. Now we're mandating it. We went from, on lines 15, we're going from a may to a shall. Is that correct?
Senator Flexer?
Through, thank you, Mr. Chair. I'm trying to remember how to properly speak through you. I apologize. Yes, we are changing it to shall, again, in an effort to shield this board, like other watchdog agencies, from the influence of those who don't want to be watched.
Thank you. There was a part in here, I don't know if it was this bill or not, excuse me, let me just look here, about the bidding process. Was there anything in this bill regarding increasing the amount to go out to bid, the bidding process? I'm not sure if it was this bill. I thought I saw it in here. Let me see. You have that? You'll cover, okay, yeah, I thought I saw that in here.
Senator Flexer?
Through you, Mr. Chair, the language before us today does remove some exceptions for purchases less than $10,000, if that's what the good representative is referring to.
Yeah, okay. Oh, yeah, here it is. I see it here, okay. I don't have any further questions. I think Senator Sampson has a couple. I'm good for now. Thank you, Madam Chair.
Thank you, Representative. Senator Sampson.
Thank you very much, Mr. Chairman, Madam Chairman. I appreciate the clarification on this this bill proposal. I'm sympathetic to the idea of making sure the State Contracting Standards Board is actually properly staffed and funded so they can do their job. So that part of the bill doesn't concern me so much, although, we do, have some references to fiscal notes and so forth earlier, and obviously that's going to be an expenditure. I presume this bill is being JF to the floor, but will end up going to appropriations through the natural cycle of things. Through you.
Senator Flexer?
Thank you, Mr. Chair. If this is helpful to the conversation today, so this is the agency is right now fully staffed, so the board is fully staffed. So if this bill were referred to the Appropriations Committee, it would not need to be scrutinized for additional appropriations because it is fully staffed right now. The idea here is to put it in statute so that it always stays staffed at the appropriate level for the board to fully function.
Thank you, sir. Senator Sampson?
Thank you for that clarification, Madam Chairman. I appreciate it. So I do want to say that I do agree with Representative Mastrofrancesco's concern over the waiving of certain competitive bidding on purchases. I see the increase from 10,000 to 25,000. I do like that there has been this additional language, which I haven't seen in past versions of similar legislation, that says that it would require documenting any waiver granted that is a purchase of 10,000 or less. I'm kind of undecided. As much as I recognize there's inflation and things continue to rise in cost, I still have a concern with allowing purchases beyond $10,000 to go without the proper documentation. Serving on the Government Oversight Committee this year, I will just say that, one thing I notice in many of the audit reports is asset protection concerns that the audit auditors mentioned about state assets, property, laptops, things like that. And, these are the kind of things that I'm talking about, because these types of purchases fall into this kind of category. The LOB decides to, purchase laptops for employees, something like that. That could be a purchase in that range. And I just hate to see things like that being less than idealistically, documented in a way that the taxpayers are looked out for. I'm not saying it's an unreasonable change. I've got to think about it. That's all the questions I have. Thank you.
Senator Flexer?
Thank you, Mr. Chair. If I know that the good senator didn't just ask a question, but I would offer, I think that the changes in lines 121 to 129 that you were just discussing were in an effort to, as you suggested, recognize rising costs, inflation, the impact of inflation, but also make sure that there was documentation when these waivers were issued. Now, I would offer, if it might earn the good senator's support, to maybe keep the 10, but put this waiver requirement in place as a friendly, really friendly amendment. Yeah. So if I can clarify, to make sure we do this properly for LCO. So we're talking about the JFS language, which is LCO number 3496, and my perhaps bipartisanly sponsored amendment would be in line 124 to keep the original 10. So that line 124 would read non-recurring or emergency purchases of 10,000. And then following in line 125, dollars or less in amount. Would there perhaps be a bipartisan second to that amendment?
Second.
I'm going to take that as a motion by
That is a
Senator
motion,
Flexer and a
yes.
second by Senator Sampson. Is there any objection to a voice vote? Is there any need for clarification from LCO? Seeing none, all in favor of the amendment may signify by saying aye.
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 All against nay. The ayes have it. The amendment is adopted. Is there further question or comment on
Uh-oh.
this bill?
Christie.
Oh, Representative Carpino.
Thank you. I just want to make sure I understand now that we've amended it. When will documentation be required to be posted, and has that changed?
Less than 10,000.
Senator Flexer says less than $10,000.
Just to be clear, for exceptions under $10,000, will there be documentation posted, and when? Ma'am, and I'm just trying to clarify.
Senator Flexer?
The JFS language with the amendment the committee just adopted would now require that any waiver that's issued, and waivers could only be issued for purchases less than $10,000, would have to be documented.
Thank you. That's what I was hoping the answer would be. Thank you, ma'am.
Thank you, Representative. Further question or comment on this bill? Senator Sampson?
Thank you, Mr. Chairman. I just want to thank your co-chair for the excellent, very, very friendly amendment. That's as friendly as it gets when the chair offers an amendment to the minority party. I think that makes the bill much better from my perspective, and I'm delighted to support it. Thank you.
Thank you, Senator. Further question or comment on this bill? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 17 of the agenda as amended. Senate Bill number 469, an act implementing the recommendations of the State Contracting Standards Board to be JFS to the floor with LCO number 3496. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is yes.
Representative Mastro Francesco?
Yes.
Representative Bronco? Yes. Representative Carpino?
Yes.
Representative Fonsello?
Yes.
Representative Gauthier? Representative Haddad?
Haddad votes yes.
Representative Hoxa,
Yes.
Representative Johnson,
Rep. Johnson votes yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Yes.
Representative Shannon,
Yes.
and Senator Winfield.
Winfield in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is Senate Bill 470, an act concerning the legislative commissioner's recommendations for technical and minor revisions to the government administration statutes. This is the JF to the floor. The chair will entertain a motion.
So moved.
Moved by Senator Flexer, seconded by Representative Morin-Bello. This is our annual tech revisor bill. Please make LCO happy and support this bill. Further question or comment from the committee? Representative Massafrancesco.
I just want to confirm that it is just technical. Their annual, correct? Thank you very much.
LCO is confirmed, just technical.
I'll support this bill. Thank you.
Further question or comment from the committee? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 18 of the agenda, Senate Bill number 470, an act concerning the legislative commissioner's recommendations for technical and minor revisions to the government administration statutes. To be JF to the floor, Senator Flexer. Yes. Representative Blumenthal. Yes. Senator Honig.
Senator Honig votes yes.
Representative Morin-Bello.
Yes.
Representative Osborne.
Yes.
Senator Sampson.
Yes.
Representative Mastro Francesco.
Yes.
Representative Bronco. Yes. Representative Carpino. Yes. Representative Fonsello.
Yes.
Representative Gauthier. Representative Haddad.
Haddad votes yes.
Representative Hoxa.
Yes.
Representative Johnson.
Rep. Johnson votes yes.
Representative Menapace.
Yes.
Representative Rosario. Representative Santiago.
Yes.
Representative Shannon.
Yes.
And Senator Winfield.
Senator Winfield in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 19, Senate Bill 471, an act concerning the use of apprentices on prevailing wage public works projects. This is a JFS to the floor of LCO 3494. The chair will entertain a motion.
So moved.
Moved by Senator Flexer, seconded by Representative Morin-Bello. This bill requires that apprentices who are paid an hourly wage and are directly employed by a contractor or subcontractor on certain public works projects valued at over $10 million must perform a minimum percentage of total on-site hours at a qualifying public works contract. It designates certain percentages. It authorizes DOL to grant limited waivers, and authorizes a civil penalty for violations. And is there further question or comment on this bill? Senator Sampson.
Thank you very much. Mr. Chairman, I appreciate the introduction on this bill. I'm a little puzzled why it's here. This is the exact type of policy that we would see in the Labor Committee. I serve as a ranking member there as well. It's very explicitly about prevailing wage. I understand that it may have come from the Department of Administrative Services, but this is still labor and public employees related. Can you just give me some insight as to why we're kind of going around the normal process for a bill like this through you?
To you, Senator, I can't speak to the normal process, but it's within our cognizance because its mechanism of action is directly through state contracting. To you.
Thank you very much. Mr. Chairman, can you describe to me what is happening here? I see the language that is in the bill has to do with apprentices and how they are going to be counted towards the total of the amount of the contract. In other words, their labor will be counted at the prevailing wage. Am I correct about that? And I'm trying to understand what the purpose behind making this change is through you.
To you, Senator, I believe you have stated it correctly. The purpose is to encourage the use of apprentices and more significant percentages of apprentices on state contracted projects. We talk a lot about how the trades are a great way to make a living. We talk a lot about how we need tradespeople, but then when it comes to actually putting apprentices on jobs, we don't really have the kind of policy that would ensure that they're actually placed in a position where they can get the work they need to become certified tradespeople. And so for all those reasons, this bill lays out a structure that would help do that to you.
I'm trying to understand exactly the purpose behind this. I am very aware that we have a shortage of apprentices on some of these job sites, but that is because a disincentive has already been created, which essentially says that apprentices are not compensated at the same rate that regular contractors are. And I understand what's happening here is it looks like some sort of scheduled mandate to start to increase the number of apprentices that have to participate in these jobs. I notice on lines 236, 237, and 238, it says 1 year after January 1st, 27, they'll have to have 5% apprentice participation. 2 years after, it'll be 10%. 3 years, it'll be 15%. I think it's very interesting that simultaneously with making these requirements, there's also a requirement that those apprentices will have to be compensated at the same rate as regular journeyman contractors. Am I correct about that, Madam Chairman?
Thank you, Senator. And actually, most of what you said was correct, except for the very end. So in the JFS, the language before us does not require that apprentices be compensated at the same wage rate as a journeyman. It just requires that the fringe be consistent for apprentices and journeymen. I know it's a little confusing. It actually took me some time to dig through this to understand that, but that's the feedback we heard at the public hearing, I think was a week ago today. And so that's what that change does.
Thank you very much, Madam Chairman. I appreciate that. I'm just trying to find it in the bill myself so that I can be confident that that is indeed the case. Not that I doubt your expertise in that area, but this is substitute language. It's another bill that was farther down the list of to-dos for me, looking at the 52 bill agenda, because I'm looking at all of the various underlined and bracketed sections, and I'm seeing where it says on 95-96, rate of wages on an hourly basis in accordance with the journeyman rate. And I believe that section refers back to apprentices. So I do want to make sure that that is indeed the case, because as you've described it, I could find my way to supporting it, even though I'm in kind of extreme objection to prevailing wage, generally speaking. But I do want to see more apprentice participation. But the way to do that actually is to allow for more apprentices in our ratio, which is something that we are way behind on, and something that we make an effort to get through the Labor Committee every year, and sadly are unsuccessful at that endeavor. So please, just if you can point that to me, where that reference that I mentioned in lines 95 and 96 refer to.
Senator, you're asking what the change in lines 95 and 96 refer to? Just for clarity. I think because I sincerely am trying to answer your question. I think that reference is only to that fringe rate that we talked about. I understand why when you read it, it looks like it's talking about the full wages, but it's actually just referring to the fringe rate, so that there's consistency across these positions with the fringe. That it comes directly from the testimony we heard last week. That was the one change that was asked for by a variety of stakeholders who support the bill, and so that's where that comes from.
Madam Chairman, I appreciate what you're saying, but this is a lengthy bill. I'm talking about line 96. The immediate reference before it says wages. Where such contract is performed, the Labor Commissioner shall adopt the rate of wages on an hourly basis in accordance with the provisions of this section and the amount at the journeyman rate of payment contributions and member benefits, and so on. And when I go back and I trace this sentence it starts on 89. That's for the purpose of predetermining the prevailing wage on an hourly basis.
If I may, Senator, I think
Sure.
this is a section that you want to read moving forward instead of moving backward. And I don't want to put our LCO attorneys on the spot on this, but I think the change to at the journeyman rate refers to the references after line 95 and 96, right? So at the journeyman rate for the payment, contributions, and member benefits, including health, pension, annuity, and apprenticeship funds. So that's the reference to the fringe rate and not the reference to the wage rate.
Understood. Okay, I understand what you're saying, Madam Chairman, that the reference to wages earlier has to do with the kind of structure of the entire way we determine the prevailing wage, but it is spelled out more clearly that it is only for the fringe there. I'll just say a quick word about this. I'm hesitant to advance a proposal like this, even though the stated goal seems very clear to me to try and encourage more apprentices on the job site, which is something I agree with. But what I'm concerned about is that the bidding process for these contracts has to do with determining the prevailing wage for the job. And I think what can happen here is you're going to end up having effectively different bids that are determined by the number of apprentices that are involved in each proposal. And I want to make sure that the quality of the job that is being performed is not being interfered with. Actually, Madam Chairman, maybe I'll reconsider. Maybe I will support this bill going forward. I do like the concept of it very much, and I apologize for seeming unprepared. But again, stack of paper today, and my initial reading of this seemed like we were going to end up paying apprentices at the full prevailing wage rate, which would have been a net negative for the contractors involved and for taxpayers as well. But if that's not the case, then this can be pretty reasonable, although it is a mandate on these contractors to be able to find apprentices and to employ them on the schedule provided. And I don't know that that's an easy thing to do. But I'm open to the conversation. I do think that this might need a little bit of adjustment. I really do think it's a labor bill. It should have come to the Labor Committee where we have conversations about prevailing wage and apprentices on a regular basis, and everybody in the room was familiar. Again, I will support it today as a work in progress, with understanding that I might have some concerns going forward that I hope the chairs will at least consider. Thank you.
Well, I can commit that I certainly will. Thank you, Senator. Are there further questions or comments on Senate Bill 471? Representative Mastro Francesco.
Thank you, Madam Chair. I was listening to the back and forth between you and Senator Sampson. Seeing that we just got this bill today and their substitute language, I really haven't had time to go through it. I'm going to vote no on this today until I fully understand it. I'm looking at the testimony, and it looked like there was some opposition, like from the CBIA and other organizations out there, and I'm not sure if their concerns were addressed in the substitute language. So I'm going to be a no today. We'll see what happens when it moves forward. Thank you, Madam Chair.
Thank you, Representative. Are there further questions or comments on Senate Bill 471? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item 19 of the agenda, Senate Bill number 471, an act concerning the use of apprentices on prevailing wage public works projects to be JFS to the floor with LCO number 3494. Senator Flexer?
Yes.
Representative Blumenthal?
Yes.
Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Did you call me? I'm sorry. Sampson,
Yes.
yes.
Representative Mastro Francesco?
No.
Representative Bronco?
Both. That's both.
To clarify, that was a no? Thank you. Representative Carpino? Representative Fonsello?
No.
Representative Gauthier? Representative Haddad?
Haddad votes yes.
Representative Hoxa?
Hoxa votes yes.
Representative Johnson?
Rep. Johnson votes yes.
Representative Menapace?
Yes.
Representative Rosario? Representative Santiago? Representative Shannon?
Yes.
Senator Winfield?
Senator Winfield, in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up is item number 20 on our agenda, Senate Bill 472, an act concerning the electronic surveillance of employees. This is the JFS to the floor of LCO 3486. Chair will entertain a motion.
So moved.
And a second? Moved by Senator Flexer, seconded by Representative Morin-Bello. This bill is pretty simple. It would just require public employers to electronically monitor, electronically monitor their employees to give prior written notice to those employees, informing them of where under the premises are being surveilled, and requires the posting of a conspicuous notice and a written notice of what activities are prohibited or may be monitored without prior written notice. And there is an exception in the JFS to airports for obvious reasons. Further question or comment from the committee? Representative, do you want to go first? Representative Carpino?
Thank you. I didn't mean to get in front of the ranking member. I was just hoping that you could and I realize we're looking at JFS language, but can you just explain how this is going to differ from current law and the posting requirements?
To you, to you, Representative, it will differ only slightly in that it requires more detailed explanation. It is currently required that some notice be provided, but there's been some situations where particularly municipal employers have refused to identify to their employees where they're being surveilled, whether it's in person by video or via electronic means over their computers or phones. To you.
Thank you for that. And just to confirm, so we're only talking about public employers in this bill? I thought that's what you said, sir, and if so, I didn't mean to put words in your mouth. I was a little confused.
Yeah. Representative, I think the intent of this was public employer, but that is not what it says. So, in the definition in lines 4 and 5.
And I appreciate the answer, and I appreciate you confirming there was a reason for my confusion. Is that going to be amended here and now, or will that be adjusted later, sir?
We can always think we may, yeah, I think we'll have, I think we do want to clarify this before we go forward, so we appreciate the question. I think Senator Flexer is going to retract her motion.
I retract my motion for JFS.
Okay.
I think.
Do we need to do anything else?
A second.
Do we need to retract the second as well? Yes. And Representative Morin-Bello retracts her second, and we'll hold this and clarify this. Appreciate the question. Next up on our agenda is item number 21, Senate Bill 485, an act concerning a technical change concerning government organization. This is a JFS. It is a JFS of LCO 3493, and I will explain what's happening with this bill. There was a bill that dealt with the Secretary's confidential address program for multiple groups of people. That bill is going to be separated. The groups of people covered are going to be separated. This is going to take the group which covers domestic violence survivors and victims. And so all the applicable provisions of that bill will be in here. So it allows victims of domestic violence to utilize the program. It allows them to take certain measures to shield their addresses with regard to their ownership interests, documents in real property, and it requires the town clerk to keep the participants' real property records confidential and to establish procedures. Further question or comment on this bill?
Oh, so
Oh.
moved.
The chair will entertain a motion.
So moved.
Moved by Senator Flexer, seconded by Representative Gauthier. I already explained the bill. Further question or comment?
Mr. Chairman, thank you very much for the explanation. Again, this is another substitute bill that we got early this morning, and obviously when we were looking at that stack of paperwork, we were focused on the election-related items because they were, in my view, the most critical things that we had to address. And frankly, the minority was not given enough time. I know you granted us a little more time, but we would have needed a week, not a couple hours to digest all this properly. In this bill, I understand what the good chairman just described, but if you're looking at the paper I'm looking at, boy, that's a mystery. It would take you a while to figure that out from this. This is a pretty, it's 9 pages long, but it is a lot of very confusing language, and it's very hard to follow. And, well, as much as I trust the chairman means well when he describes a bill, I don't know that I can rely on that as much as I like to rely on the language in the bill that's directly in front of me. I'll say that normally speaking, I've opposed all of these similar bills in the past that shield the addresses of public employees. But this is a little bit different since we're not talking about public employees. But I think that this bill is really focused about public employees and their addresses. So I'm confused how we got to domestic violence victims, and how it relates to another bill is an also confusing thing. What does this bill do on its own, Mr. Chairman?
Nothing. The original bill does nothing. 485, that's what he's asking about.
The original bill made only technical changes to a government organization statute. Yeah, the original, so it's language taken from 55555.
So, okay, and section 4 is the new part?
Well, the whole thing is new. It's just all, so we took out the technical change and put in the DV portion of 55555. Yeah, Gary makes a good point.
This was in the, well.
Someone want to go pick up the pizza I ordered?
At
Should
the
be out
front
front.
door.
Hi, where are you? We're going to recess briefly, subject to the call of the chair. Hereby reconvene. Well, I'll wait for the clerk confirmation. Hereby reconvene this meeting of the Government Administration and Elections Committee.
Yes,
We still have a
active motion, yes.
active motion pending on item number 21, Senate Bill 485. Was there further comment or question from the committee? Seeing none, Madam Clerk, would you please call the roll?
This is a call vote on item number 21 of the agenda, Senate Bill number 485, an act concerning a technical change concerning government organization to be JFS to the floor with LCO number 3493. Senator Flexer? Yes. Representative Blumenthal?
Yes.
Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is no.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? Representative Fonsello? Representative Gauthier?
Yes.
Representative Haddad?
Haddad is yes.
Representative Hoxa? Representative Johnson?
Rep. Johnson is yes.
Representative Menapace? Representative Rosario? Representative Santiago? Representative Shannon?
Yes.
Senator Winfield?
Senator Winfield in the affirmative.
Back to Representative Santiago. Okay. All right, thank you, Chair. Oh, yep, will do. All set, thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 22, Senate Bill 486, an act implementing the recommendations of the Department of Administrative Services concerning criminal background checks of employees with access to tax records. The chair will entertain a motion. This is a JF to the floor, by the way.
Yes, I mean, I'm so moved. I'm
Second.
so sorry.
Moved by Senator Flexer, seconded by Representative Gauthier. This bill would require DAS and any agency with custody of federal tax information to conduct background checks at least every 5 years for every applicant, transfer, or current state employees and contractors and subcontractors who have access to federal tax information. This is required by federal law. Any questions or comments from the committee? Seeing none, Madam Clerk, would you please call the roll?
This is a roll call vote on item number 22 of the agenda, Senate Bill number 486, an act implementing the recommendations of the Department of Administrative Services concerning criminal background checks of employees with access to tax records to be JF to the floor. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is yes.
Representative Mastro Francesco?
Yes.
Representative Bronco? Yes. Representative Carpino? Yes. Representative Fonsello? Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa? Representative Johnson?
Rep. Johnson is yes.
Representative Menapace?
Menapace is yes.
Representative Rosario? Representative Santiago? Representative Shannon?
Yes.
And Senator Winfield?
Winfield in the affirmative.
All right, thank you, Chair.
Thank you, Madam Clerk. Next up is on our agenda is item number 24, Senate Bill 488, an act implementing the Treasurer's recommendations for revisions to the Unclaimed Property Program and Second Injury Fund. The chair will entertain a motion.
Second.
Moved by Senator Flexer, seconded by Representative Gauthier. This bill follows on the work we've done in the past sessions on improving the administration access to the unclaimed property program, otherwise known as the big list and the little list. It amends certain definitions to expand access. It specifies how the fund will interact with certain insurance provisions and unclaimed property. How the certain insurance provisions and unclaimed property statutes will interact. It exempts personal information of unclaimed property owners. Treasurer has, unless otherwise by FOIA, and makes some changes related to how unclaimed military medals may be administered, how certain property of jewelers, watchmakers, silversmiths, or television and radio service dealers will be able to be sold if appropriate and designated under our laws. And broadens the Treasurer's authority to establish accounts within the second injury fund. Further questions or comments on this bill? Representative Carpino.
Thank you, sir. Could you just highlight in a little more detail the implications to the second injury fund?
So this bill, with regards to the second injury fund, will set a limit on paying retroactive benefits from the second injury fund. That's in Section 8, and it broadens the Treasurer's authority to establish accounts within the second injury fund. That's Section 9.
Thank you for that. Can you explain the rationale or the need for those changes?
Mr. Chair,
Yeah.
might I be of assistance?
Yes, you may.
Yes.
Mr.
My name is
Frame.
Matt Frame. I'm with Office of Legislative Research. So the two changes, the first in Section 8 is regarding retroactive benefits. So if a person, the second injury fund covers workers' compensation for certain types of employees who, one of them is if their employer does not have workers' compensation, but that's not really being affected here. What is being affected is if an employee works multiple jobs, but they get injured at one, that company where they got injured is responsible for paying workers' compensation claims, which might cover lost wages from these other companies that this person works for. So that insurer or that company, if they're self-insured, can go to the second injury fund and request reimbursement or these retroactive benefits for the amounts that they paid out to this employee that they weren't technically responsible for, because under law, the second injury funds will cover those extra the lost wages from these other companies, if that makes sense. So what this is doing is saying, under current law, they can only request this reimbursement for from 2 years from the date they paid out these benefits. However, it doesn't say that they only have to pay out benefits within that 2-year period. So, for example, if an employer or an insurer accidentally underpaid someone for 20-some years, if they recognize that, they may then pay that person what they're owed and then go to the second injury fund and saying, hey, we underpaid this person for 20 years. We would like to be reimbursed for that. So what this provision in Section 8 is saying is the second injury fund will only cover up to a 3-year period, and the insurer is going to have to then essentially eats the cost of underpaying this employee for the other 17 years, essentially.
If I may, sir, thank you. That was very helpful. To either of you, do we have any idea what the financial impact of the second injury fund is going to be?
So the purpose of this is to limit liability for the second injury fund. So in case there's other insurers or employers who accidentally or for some reason do something like fail to pay someone for 20 years, it limits the liability the second injury fund has for those potentially 20 years worth of payments. So it essentially puts the second injury fund in a better position, knowing that there's not potentially this huge liability out there in the future, so that they can plan better for like the budgetary implications.
Through you, Mr. Chairman, I really appreciate OLR's explaining that. The second injury fund isn't one I think anybody who hasn't done a little bit of workers' comp is familiar with. I appreciate that information. I'm still going to work through this one, but that is very helpful. Thank you.
Thank you, Representative, and thank you, Mr. Frame. Further questions or comments from the committee? Senator Sampson.
Thank you very much, Mr. Chairman. I noticed that there is a section of this bill that establishes the limit, the threshold for the automatic returning of unclaimed money to Connecticut residents who are on the big list. And it sets that limit at $50, which I think is kind of excessive. Is that a change from the current dollar amount for automatic returning of the money through you?
To you, Senator. I think it makes it consistent with other existing provisions. There's an existing provision in section 4, and I think it makes it accord with subsection F. Of section 6. So the only change yes, the bill does make that change to subsection F of section 6. You can still obviously obtain the property, but it's just not automatically transferred to.
I appreciate that response, Mr. Chairman. I think $50 is excessive, frankly. That amount is, I mean, first off, I don't understand why the big list doesn't automatically return more money and why they would set a limit at $50. I think that the amount that we should use should be, as some of our testimony suggests, the minimum amount that your average person would bother to go through the trouble to obtain. So it's been pointed out to me in the testimony that we actually, as a committee, passed a bill 3 years ago, Senate Bill 382, out of this committee unanimously, that set the limit at $10. And I don't know, it makes more sense to me. The testimony from someone I know is very involved in this process and knows a lot about the big list and how our unclaimed property fund works. He's suggesting that this is, indicative that the treasurer's office is less inclined to actually return this unclaimed money to the citizens of Connecticut than he should be, and points out that the state is holding on to $1.7 billion of unclaimed property, nearly $500 per person. And I've got to concur, not knowing any strong arguments to the contrary. I think that's very compelling testimony. I don't believe we should be setting this at $50. I think the number should be significantly lower. I'd really like to hear one of those friendly amendments. But barring that, I have concerns about this bill. Thank you.
Senator Flexer.
Thank you, Mr. Chair. In the good spirit of my friend, Senator Sampson, I would ask for the help of our wonderful attorneys in the Legislative Commissioner's Office to maybe make that friendly amendment to change the $50 to $10. Would you be able to direct me at exactly what lines we should make that change for that amendment?
I believe that's line 410.
Okay. All right, so I will make a motion to change the dollar amount in line 410 from $50 to $10.
Second.
The amendment is moved by Senator Flexer, seconded by Senator Sampson. Is there any objection to a voice vote? Is there any objection? Hearing none. All those in favor, please signify by saying aye.
Aye. Aye.
All those against, nay. The ayes have it. The amendment is adopted. Further question or comment on the bill? Senator Sampson.
Thank you very much, Mr. Chairman, and I certainly thank the co-chair for her friendly amendment. A new term we've coined today, the double friendly amendment, which is an amendment from the majority based on the suggestion of the minority. And I think it's great that we're working together on some of these items, proving that we can certainly find common ground and bipartisanship on some items, and I'm delighted when that happens. I wish it happened more often, but we'll keep working on it. We're what should be a pepper too. Thank you very much, and with that change, I will support this bill. Thank you.
Further question or comment on this bill? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 24 of the agenda, Senate Bill number 488, an act implementing the Treasurer's recommendations for revisions to the Unclaimed Property Program and Second Injury Fund as amended to be JF to the floor. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is yes.
Representative Mastro Francesco?
Yes.
Representative Bronco? Yes. Representative Carpino? Yes. Representative Fonsello?
Yes.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxha? Representative Johnson?
Johnson votes yes.
Representative Menapace?
Yes.
Representative Rosario? Representative Santiago? Representative Shannon?
Yes.
And Senator Winfield.
Winfield in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up is item number 25, Senate Bill 489, an act making technical changes to statutes concerning state contracting. The chair will this is a JF to the floor. The chair will entertain a motion.
So moved.
Second.
Moved by Senator Flexer, seconded by Representative Gauthier. This bill does exactly what it says. It makes technical change concerning state contracting. Questions or comment on the bill? Representative Francesco.
I just want to make sure that this truly is a technical change or not a placeholder. Would you know? Do we know?
What is,
LCO? Somebody?
that is a
Do we know?
ontological
I'm sorry, say that
difference,
again?
but I don't know.
We don't know. We don't know.
It is a philosophical difference,
Placeholder?
I think.
It
I mean,
could be a placeholder,
any
right?
bill could be a placeholder.
Any bill could be a placeholder, I get
But
it.
as it stands, as it is written, it only contains a technical change.
So the technical change is changing the term large state contract to large state contract. I would call this a placeholder, wouldn't you? I'm not going to support a placeholder today, but thank you.
Thank you, Representative. Further question or comment on the bill? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 25 of the agenda, Senate Bill number 489, an act making technical changes to statutes concerning state contracting to be JF to the floor. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is no.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? No. Representative Fonsello?
No.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxha? Representative Johnson?
Johnson votes yes.
Representative Menapace?
Yes.
Representative Rosario? Representative Santiago? Representative Shannon
Yes.
and Senator Winfield.
Winfield in the affirmative.
Thank you, Chair.
All right, next up on our agenda, we have Senate Bill 26, or excuse me, not Senate Bill 26, item number 26, Senate Bill 490, an act concerning online political donation platforms and limiting automatically recurring contributions. The chair, this is a JF to the floor. The chair will entertain a motion.
Second.
Moved by Senator Flexer, seconded by Representative Gauthier. This bill, as written, specifies that an online platform that collects contributions may not allow for automatically recurring contributions from a contributor without their affirmative consent, so no default being recurring contributions. And it amends the state campaign finance law's definition of contribution and expenditure to exclude certain voluntary payments made to certain online political donation platforms. Is further question or comment on this bill? Senator Sampson.
Thank you very much, Mr. Chairman. This bill has been before us in other, maybe similar forms, maybe even the exact same language. I'm not quite sure. But this proposal is what we are commonly referring to as the Act Blue bill, because it allows for certain activities that are, common to that donation platform, which is a Democratic platform, but there's also a Republican version called WinRed, and I think both of them are active in different parts of the country, and I believe that there's been a difficult prohibition in the state of Connecticut that they're attempting to overcome to operate here, and that is that our current statutory framework regarding these donation platforms prohibits certain types of behavior, and I think rightfully so. And the bill that is before us undermines those prohibitions. In one respect, it would allow the platform itself to insert itself into the transaction by collecting additional funds. Now, of course, that's still up to the donor, but the danger here is that someone could come to a website directed by a particular political candidate to support them, and they're going to be hit with an opportunity to donate to the platform itself. In previous years, we've had some very clever language about how the platform could use any proceeds, and I think it's quite obvious from the way we perceive Act Blue across the country and some of the investigations and the news that has been generated by their behavior that they're actively using those funds not just to grow their operation and be able to process more contribution payments, but because they engage in political endeavors themselves. And I think some of the arguments in the past have really been about how money is fungible, about whether or not they're using some proceeds that are for operations, for political purposes, and so forth. I think it gets very confusing if you start to break it down like that. But my concern over this really is that I think that the prohibition that exists in our current statute is justified, because I believe that people that are making a donation for a political contribution should be limited to that. We have very strict rules in the state of Connecticut. You know, we set up a citizens election program that has very strict parameters about how we can raise money. You have to raise money only from individuals. You can't raise it from corporations. We have to raise small donations from within our district and so forth. So we're following a set of very strict guidelines that are designed to level the playing field between candidates. And here you have what is really a big player, you know, entering into the same exact marketplace and will be in a position to influence electoral outcomes in a big way. I think it just goes against the concept of having CEP. It's kind of ironic because I'm a guy who doesn't really care for the Citizens Election Program and the limitations that currently exist as a result. But if you do believe in those things, then I find it hard to justify that we have this framework to go ahead and level the playing field for campaigns, keep people on equal terms, and then simultaneously have a policy that allows for the platform itself, which is a political animal, to use that opportunity to identify donors that favor certain political candidates by party, of course, and then find ways to raise more money, which will ultimately be used in the same exact political environment as independent expenditures, et cetera. It doesn't jive, for lack of a better term. Mr. Chairman, can you just describe for me what this bill hopes to achieve that benefits the election system in the state of Connecticut?
To you, Senator, so it does several things. One is that it prevents these automatically recurring contributions, which can be deceptive and lead to people making contributions that they didn't intend to do so in the first place. And it also reconciles a certain model of a platform that may accept tips related to where someone can pay for a tip to assist in organizational expenses but not political expenses, and allow that line to be enforced, and therefore allow the platform to operate under our election system and campaign finance law. To you.
Thank you very much, Mr. Chairman. I just want to clarify that I don't believe the bill prohibits automatic recurring payments. What it does is it prohibits the automatic recurring payments unless someone affirmatively checks the box asking for that. Can you just confirm that's correct?
Yes, it prevents automatically creating automatic payments, recurring payments, if that makes sense. I forgot an automatic, but double automatic. You have to affirmatively choose to make automatic recurring payments to you.
Understood. It cannot be automatic to have automatic payments. I think we're on the same page. I believe that provision of the bill is a positive one. I think people should be protected from having that box checked and then unwittingly, go forward with their contribution and then ultimately have that, the box being checked and they are subject to automatic recurring payments that they did not intend. The other explanation that the good chairman gave, I'm not going to say it's incorrect, but I would say it's inadequate, because I was hoping he would address the assertions that I made, which is that this system doesn't fit with our current scheme as far as the statutory framework for a taxpayer-funded level playing field, ease of entry for candidates to particularly state legislative office. Can the chairman basically describe to me what protections in place to make sure that the money that these providers, ActBlue, online platforms, technically speaking, what protects consumers, donors from having that money used for other political purposes? Through you.
To you, this provision would allow them only if the contribution, or allow them to participate only if the contribution is to a committee, and then whatever other voluntary payment is made by the contributor to the platform is in addition to the contribution, so separate from the contribution, and it is only used by the online platform to conduct its operations. To you.
Thank you very much, Mr. Chairman. So I guess the operative term there is its operations. Is that defined in the bill anywhere? Through you.
To you, it does not appear to be.
Thank you very much, Mr. Chairman. That's ironic, given some of the amendments that I had offered earlier today and the desired specificity that I was lacking. I'm just teasing. The fact is that this services definition that does not exist in the bill, excuse me, operations, it's operations. So if that online platform is in the business of making advertising for political purposes, would that be considered its operations through you?
To you, no.
Thank you very much. Mr. Chairman, can you point to where in the bill that would be prohibited?
To you, it is not specifically prohibited, but that is the entire intent of the word operations, which in the context of campaign finance, the entire point of it would be to separate it from anything that would be conceivably considered an expenditure to you.
Thank you, Mr. Chairman. I appreciate the response, and I should expect a quality answer from my very intelligent chairman who's got a legal background. But the fact of the matter is we failed to identify the definition of its operations with any type of clarity in this bill. So that would be something that would have to be argued at some point in court if someone took issue with the way this online platform was spending their money. Am I correct about that?
To you, SEEK could also issue regulations or guidance, but ultimately it would be up to the State Elections Enforcement Commission in terms of how it enforced this. If it were challenged, ultimately it might end up in court. But this definition was developed alongside the State Elections Enforcement Commission, and that is its understanding of the term. To you.
Thank you very much, Mr. Chairman. I appreciate that answer as well. Did SEEC provide any testimony for or against this bill?
To you, no.
Do you happen to know whether they have done that in the past, Mr. Chairman?
I don't know off the top of my head. Obviously, it's a different bill. We have had very similar language in the past, but as I sit here, I do not know. To you.
Mr. Chairman, you just said a moment ago that this language was developed alongside people at the SEC. I don't know exactly what that means. Did they have something to do with the language that is before us? Did they approve this language? Do you know how they feel about it through you?
To you, Senator, it was negotiated with SEEK, so it didn't interfere with what they viewed as the proper scope of the program. And I guess that's all I can say. And that's just a representation, since we don't have testimony sitting here today. I don't think I can speak to its feelings or people there's feelings. To you.
Thank you, Mr. Chairman. I'm just trying to get to the bottom of the situation because it's very confusing to me that in Connecticut, where the majority party has emphasized the value of our State Election Enforcement Commission and the Citizens Election Program. In fact, they highlight it constantly, particularly in this committee, that it is a success, that it has produced the opportunity for many, many folks who otherwise would never be in a position to run for office to actually be here serving with all of us as colleagues. And I can say personally, not that I'm even a fan of this program, but I doubt I would have run for office or qualified to run the very first time around if it had not been for the Citizens Election Program existing. It's one of those things where you don't have to agree with it ideologically to know that your competition is obviously using the same platform, so you are kind of stuck to do that. And that kind of leads me down the path of some of the concern here is that if you start allowing this type of activity in the state, you're not only going to get your Act Blue, you're going to get your Win Red, and you're going to get a new mechanism for independent expenditure type political campaigning. And I don't genuinely object to that. I'm just trying to understand the correlation or how it can be justified alongside the long-standing clear message that I've heard from the majority about the purity of our public financing program in the state of Connecticut. Because in my view, this is not very pure at all. Mr. Chairman, you mentioned that its operations, in your mind, clearly means that a political independent expenditure would have to be outside of that definition. But we did surmise that it would be maybe challenged bureaucratically and could end up in a courtroom at some point. But would the good chairman at least acknowledge that money is fungible, and that if they were to use certain resources that they otherwise would have spent on political advertising on their platform, or vice versa, that the money that is donated could offset the platform costs so that they could spend more money for political advertising through you?
To you, yes, money is fungible. I agree. I think that's true of any individual or campaign or business or anything. That's true. Yes.
Thank you very much, Mr. Chairman. So this is not a really complicated bill, so I don't know that there's a lot more I can say about it, other than I do think that it's ironic to see the GAE committee in the legislature, controlled by majority Democrats who created the CEP, effectively putting in a mechanism that circumvents the whole idea of CEP, which is a level playing field, and candidates that are operating with competing campaigns that are in the ballpark of having the same resources. This may very well change that framework and dynamic going forward. For me, I'm not opposed to the concept. In fact, I wouldn't put any limitations on political speech at all. I wouldn't put limitations on individual donors. I wouldn't put restrictions on candidates receiving certain limits. I would eliminate all of it, because in my view, money is speech in politics. And I also don't think that we should have restrictions on business and industry, much like there's very few limitations on organized labor engaging in political endeavors. To me, freedom is the answer for almost everything that I can think of, and that includes allowing people to engage in political First Amendment rights. So I'm going to oppose the bill, Mr. Chairman, because I don't think that this is a wise thing to do alongside our CEP program. I think it is utterly hypocritical to say you support the current scheme that we operate under and this at the same time, but that's up for other people to decide. So that's all I got.
Thank you, Senator. Further question or comment from the committee? Seeing none, Madam Clerk, would you please call the roll?
This is a roll call vote on item number 26 of the agenda, Senate Bill 490, an act concerning online political donation platforms and limiting automatically recurring contributions, to be JF to the floor. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson's no.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? No. Representative Fonsello?
No.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa? Representative Johnson?
Johnson votes yes.
Representative Menapace? Yes. Representative Rosario? Representative Santiago? Representative Shannon?
Yes.
Senator Winfield?
Winfield, in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda, item number 27, Senate Bill 491, an act concerning the Secretary of State's recommendations for the implementation of no-excuse absentee voting. This is JFS to the floor of LCO 3498. The chair will entertain a motion. Moved by Senator Flexer, seconded by Representative Morambello. This bill makes the Secretary of State's recommended changes for absentee voting, including the provisions that were added into 5001. The JFS removes provisions restricting who may distribute absentee ballot application, amends restrictions on the committees distributing them, and it amends the curing procedures and the verification requirements to align them with what is currently in 5001 so that they contain the same language. Further question or comment from the committee?
Thank you very much, Mr. Chairman. Yeah, this was another item with substitute language that we received earlier today. This one is 41 pages long. This is the, my understanding is the Secretary of State's recommended changes to implement no excuse absentee voting in the state. Can I just ask why we're doing this bill since we've already moved 5001 on our agenda?
To you, Senator, is a Senate vehicle for those provisions in the bill. To you.
Thank you very much for that answer and that honesty, Mr. Chairman. I can understand that. Can I just ask why this bill differs from 5001 at that, or like a better question? Did the House Bill 5001 that we passed earlier contain all of the provisions that are in this proposal, Senate Bill 491 substitute language that we're looking at through you?
To you, yes.
Thank you very much. So at this point, we've debated this item already as part of 5001?
To you, yes.
Thank you very much, Mr. Chairman. I think that folks will remember when we had that debate, which seems forever ago at this point, that debate was focused largely on just the concept of no excuse absentee voting. And for my part, I spent my time talking about the lack of security provisions that are included. And I will note that this bill is also deficient in that regard. There's nothing here that addresses that. I'd be hard pressed to go through this particular bill and pick out any of the provisions that are extraordinarily problematic on their face. It's not what's here. It's more about what's not here, which is that the majority intends to go forward with little regard for the minority's concerns on how to secure our election process. And what they are doing is effectively creating a House bill and a Senate bill that will have the same or similar language to achieve the same ends so that they can choose their proper or preferred path, I'd say, at a future date to get the bills through the legislature. Either way, it's going to have to go through the House and the Senate, whichever one goes first. I will point out to folks that are considering running the House bill that they're still going to get the Senate amendments when it gets there. So you might want to start in the Senate first, and I would encourage the chairs to take the amendments that I offered earlier to heart. They were offered in a spirit of protecting the people of Connecticut and reestablishing a level of confidence in our election process that I think is missing. And I really do believe they're good ideas. And I'm as amenable as any person you'd want to talk to about tweaking those ideas in a way that might be more workable for the majority. But I do think that we have to be very cautious about expanding our election process in ways that might create more problems. We've got to do the other part. We can't just expand access. We've got to expand access, and we have got to make sure that when we do, We protect the validity and the legitimacy of every vote. People around this table have expressed concerns about voter suppression, about access, about discriminatory practices, about limiting access to the right to vote. And I think we all share that. I think some of the bills that we've discussed today, how they relate to this bill and the House Bill 5001, I think are curious at best. You know, some of the items are in direct conflict. We haven't done it yet, but there's another bill that has to do with circulators, which I think is maybe a positive step that could have something to do with these two bills. But I noticed it wasn't incorporated in this language, even though there was an opportunity because it came out as substitute language this morning. And I noticed 5001 also, which became a mishmash of its underlying bill and this one. But again, the positive aspects of some of the items on the agenda didn't make it into that bill, and that's a shame. I think that they should have made it to that point. I don't want to beat a dead horse here. I just want to reiterate the concerns that we in the minority have, which is that we are in favor of access to voting. We are in favor of making it as easy as possible for people to cast their votes in Connecticut and become a part of our election process if they are not already. But at the same time, I think a key part of that is ensuring that those elections are above reproach, that people realize in Connecticut the election matters, that it's accurate, that you can trust the results. I remember growing up, and I don't think I recall anyone through my young life ever raising the tiniest level of doubt about the integrity of our elections in the entire country. I mean, I really do think that at one point we had elections that were above reproach. And what happened? What happened is you had politicians playing games with the process. And I think playing games with the process for political purposes. And those things have undermined the integrity of our elections. And the constant divisive rhetoric about, oh, if you are asking for ID, you're a hateful racist bigot, you don't want certain people to have access to vote. You know, there's going to be ICE agents at the polls terrorizing people. I mean, this is all crazy. That kind of stuff doesn't need to happen. We can stick to having conversations about policy. We can debate them honestly and openly. We can talk about the ramifications of each of these changes in an intelligent way. But I think one of the things that's missing is the public. We need more public input. I was very pleased to see, I think, more people come and testify in our committee this year than has happened in recent years. Maybe that's a sign that people are paying more attention. Maybe it's a sign that people are more upset about some of the things that are happening. I think both of those things are okay. If it takes people getting upset about what's happening to come out and get involved, I think that's a good thing. I just wish that the things that they're upset about weren't happening. I'm going to continue to speak up about what I believe our election process should look like in the state of Connecticut. It's something I'm passionate about. I spent a lot of time talking about it over the years. Occasionally, the press covers it fairly, which is good. I hope they do today, too. I hope that, you know, when this is recorded in the press, how me and some of my colleagues responded to some of these bills today, that they put our words in accurately. That we're like, look, we want to work with the majority on this process, but they're ignoring our pleas. And that's a shame, because I think the amendments I offered earlier, I think were definitely important. And, you know, we've been suggesting these same types of things year in and year out. And now it's upon us. Now we're not talking theoretically. We're not talking about what happens if the constitutional amendment passes, and what if the people of Connecticut vote for it, and what if. The what ifs are gone. We are here right now, and we are working on the actual policy that will implement no excuse voting in the state of Connecticut. I want to get it right. To me, that's what matters more than anything. I will be a no on this, Mr. Chairman, till further notice and till it contains the proper attention to election integrity as well as access. Thank you.
Thank you, Senator. Further question or comment on the bill? Seeing none, Madam Clerk, would you please call the roll?
This is a roll call vote on item number 27 of the agenda, Senate Bill number 491, an act concerning the Secretary of State's recommendations for the implementation of no excuse absentee voting, to be JFS to the floor with LCO number 3498. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is no.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? No. Representative Fonsello?
No.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa? Representative Johnson?
Johnson votes yes.
Representative Menapace? Yes. Representative Rosario? Representative Santiago? Representative Shannon?
Yes.
And Senator Winfield?
Winfield in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 28, Senate Bill 492, an act concerning the security of public officials and employees. Adds to the list of individuals covered by the limitation on, oh yeah, you're right, sorry, excuse me. I'll get a motion first. This is the JF to the floor. Moved by Senator Flexer, seconded by, who was it? Representative Gauthier. And never will we forget it. This bill adds to the list of individuals covered by FOIA's limitation on public agency non-disclosure of home addresses, including a number of statewide elected or statewide elected officers or officers-elect and other elected and other officers and public agency employees, except for those already excluded. Also allows candidates to make expenditures for personal security services for themselves, their family, and campaign staff, and establishes a legislative safety account for the safety, protection, and security of legislators and staff. Further questions or comment from the committee? Representative Mastrofrancesco.
Thank you, Mr. Chairman. So this bill's been around for a couple of years. It basically exempts everybody that's a state employee, paid anything by a taxpayer, whether it's a state or municipality, exempt for freedom of information. You even go as far here as to talk about your local board of education, your town council. It's crazy. I obviously oppose this bill every year. I believe in transparency. People have a right to know who their elected officials are, and they have a right to know how to get in touch with them, especially your local board of education and so forth. If they shouldn't have to go to their town. They should actually be able to get in touch with them pretty easily. So I'll be opposing this today. There was another section. What is the other new section on this bill about personal security services? So are you telling me that they are allowed to use what type of funding to have their own personal security? I mean, are we at that point in our in the lives of here in Connecticut that someone needs to have a personal security guard? I mean, have we had incidents through you, Mr. Chairman?
To you, Representative, it would be from campaign funds that they could hire personal security. I'm not aware of incidents where that, I guess we haven't allowed it previously, so it hasn't actually happened that people have hired security out of campaign funds. I don't know whether individual officials have hired security privately, or maybe they haven't because it might be viewed as a campaign expense. And I can't speak to anyone's perceptions of their personal security, but certainly, there is way too much political violence and threats of political violence going on across our country. To you.
Thank you. I'm just curious where this came from. Somebody must have had an encounter someone must have asked someone on this committee. It came from somewhere. It just didn't come from nowhere. I'm just curious where and what's the story behind it. Would you know, Mr. Chairman?
I will refer that question to Senator Flexer.
Thank you.
Thank you, Mr. Chair, and I thank the representative for a question. I think there's been a lot of conversations from members of the General Assembly about security concerns and the heightened, state of politics that we live in right now in our country, and just some concerns about how can we try to address that and give people the tools they need to help them feel safe as they're performing their role, or also give people the tools they might need in order to choose to be a public servant to begin with. And so some of this comes from things that other states are doing, things that they allow for in other states, and the provision around the safety account comes from an initiative from the National Conference of State Legislatures, where they are giving resources to every state, including the state of Connecticut, to set up what are right now relatively small accounts. But I know that our state capitol police are also working closely with NCSL to try to figure out, are there new things we can be doing to enhance the security that people who do our job can feel, while also, trying to find that balance that you referenced, where people are accessible and available to their constituents as well. Through you, Mr. Chair.
Representative?
Thank you. I don't have any further questions. I obviously I don't support this bill. I don't think people should be using campaign funds for bodyguards or private security. I think when people donate to your campaign, they're donating to you for you to get elected, to go to work. They're supporting you for, using it for personal security services. To me is crazy. And it's crazy that we even come to a point in time that someone has to even think that they need to have a personal security service. I mean, listen, we're elected officials. We're not like in Hollywood. I mean, do we really think we're that important that we need to have a personal security guard? I don't know.
I guess I just respond by saying I agree that it is ludicrous that state legislators are in a position having to fear for their lives, but certainly there have been state legislators across the country, not here in Connecticut, but state legislators across the country who have been violently attacked and killed. So
yeah, it's unfortunate. It really is that we've come to that part in our world. But anyway, for those reasons, and really because of the freedom of information, I'll be opposing this today. Thank you.
Thank you, Representative. Further questions or comments? Do you want to go first or last? Foncella also. Representative Foncella.
Thank you, Mr. Chair. I'm questioning who this applies to. I mean, in your local community, everybody knows where the first selectman or the mayor lives, and maybe your state rep and state senator. I can see people outside of your community not knowing where you live, who may be inquiring about it. So I can only see this as a non-local type of situation. I don't know how it would necessarily be enforced. If they called here and they said, what's your home address? I can see them not providing the address to them. But in your town, people would know. The other thing here about the expenditures for personal security services, you mentioned, I only have an abbreviation of this bill, but does it allow additional monies to the candidates for that, or you got to use the established limits you have? Question.
To you, Representative, you have to use the established limits. No,
Okay.
There's no additional money.
Okay. All right. Thank you. Thank you, Mr. Chair.
Thank you, Representative. Senator Sampson.
Thank you very much, Mr. Chairman. I'll speak to both aspects of the bill. I mean, the first part is about the FOIA exemptions for effectively elected politicians. I think this is dangerous policy. I think it is another step towards separating the elected class from the people. I have been very concerned in recent years watching certain legislation make it through this body, including the allowance made for exclusively remote meetings on a town level, I am really concerned about that. I was certainly supportive of the idea that gained traction during the pandemic of allowing more meetings and more participants through remote meeting software like Zoom or Google Teams or one of those platforms. I think those things are great, but not when they replace the ability for citizens to actually come before their lawmakers or their local representatives. That's inappropriate in my view. I think there's something about representative government that requires the ability for constituents to face their elected officials face to face in the same room, eye to eye, and to hold them accountable for their votes, their actions as elected officials. And this bill flies in the face of that. I think it's very ill-conceived, and it's just a bad idea overall, and I hope that folks will reconsider supporting something that elevates them above their constituents, because that's what this does. It reeks of placing oneself in a different class, a ruling class. And that's something that I really am concerned about. Our country is founded on the principle of no kings. A lot of people in this building like to use that reference also, but this looks like king-like behavior to me. So I'm not a fan of those FOIA exemptions in the least. As to the personal security services, I am somebody who's had my life threatened as an elected official. Have very publicly here in the Judiciary Committee a number of years when a bill was on the agenda about gun control, and I was serving on the committee, and I was questioning folks, who were there to testify in support and against the bill, and someone in the room was texting on a large platform iPad, and they wrote something to the effect, if I had a gun, I'd blow away that Sampson and the NRA and so forth, and somebody saw it and called attention to it, and it made national news. Now, I was never particularly concerned that that was an actual threat. I think that that person was just worked up and angry, but it was treated as significant, and maybe rightfully so. That said, I think the best thing that could happen is to allow lawmakers or people that are in political positions or people that actually go in and out of government buildings to have their Second Amendment freedoms restored in those institutions. I do not like the idea of gun-free zones. I think they are magnets for people that want to commit harm. I think that your right to defend yourself should exist wherever you are. You should be able to stand your ground wherever you are. It shouldn't just be when you're home, on your property. It should apply for when you're at work, you're in business, or you're standing in front of a town hall meeting. Because I can tell you, even if I had security outside the front door and some maniac came into a town hall forum and wanted to kill me, I would much rather be in charge of my own defense, frankly, at that point. Maybe that's an extreme position that not everybody can get behind, but I take our Second Amendment freedoms very, very seriously, just like our founders of this great country did. They recognized the value of being responsible for ourselves as individually sovereign individuals. That's why we have no kings, because we're all kings. And we have the rights to do things that kings can, like own property and make our own decisions, and that includes our own defense. And so that's why that's important to me. As far as how I feel about this language in the bill, I honestly don't care. We have even crazier things that are allowed expenditures under our current law. I can't remember. I mean, we certainly allow childcare, which I don't know that people donating to a campaign are expecting that that's something that the candidate would actually use their money for. So, I mean, as long as that exists, I mean, how can I say somebody shouldn't be able to hire security because they're doing some sort of event that might be in a provocative situation? So I'm less concerned with that. But the first section of the bill speaks of classism in a way that I don't think is appropriate for this body, and we should reject it out of hand. Thank you.
Representative Morinbillo, Madam Vice Chair.
Thank you, Mr. Chair. I just wanted to ask a question. I did receive a death threat after I attended a rally this past year. And when Capitol Police was informed of that, they said to us that if we're holding events in our community, we should let them know. And they suggested that we either have our local police or Capitol Police attend our events. So that's all well and good while we're serving in our official capacity, but once we become a candidate and not in your elected official capacity, you're no longer allowed to obviously use a local police department or Capitol Police to attend your events to offer some form of protection. So currently, can we use our campaign funds for that purpose?
Senator Flexner.
Thank you, Mr. Chair. Through you, Mr. Chair. Right now, perhaps, but this legislation would make it abundantly clear.
Thank you.
Thank you, Representative Morinbillo. Other Vice Chair, House Vice Chair, Madam Vice Chair, Representative Osborne.
Because two vice chairs are better than one. So I appreciate the good vice chair's comments, and you know, as somebody who has also received death threats in the context of my private employment, I've been geotagged, I've been threatened to be shot, I've been stalked, I've had people show up and stalk and break into my office, and as somebody who has also had particular interest paid to me in the political context in very uncomfortable ways, I think that we are all differently situated. And as much as I would love to see protections for the me who was in that threatened position in my position as a private actor, I don't think that we should be limiting the people we can protect simply because we don't happen to be one of them, or because we shouldn't be letting the perfect get in the way of the good. I think that this bill provides people who are in different positions than we might necessarily find ourselves with an opportunity for security and safety. And I hope that I don't need to take advantage of this in my role as a public official. But I certainly think that for people who do find themselves in an unfortunate position, that this is valuable peace of mind and hopefully a valuable measure of safety for them. Through you, Mr. Chair.
Thank you, Madam Vice Chair. Further question from the committee? Representative Carpino.
Thank you, Mr. Chairman. Of all the bills on this agenda, I find it really interesting that these two provisions are in the same vehicle. If somebody feels the need to spend campaign money on security services, so be it. That's their choice. That's not a choice I'm going to make. And I would support them making that choice. My bigger concern is on the first provision. I took this job because I wanted to be a representative of the people. I don't understand in what world we would want to intentionally separate ourselves along with what appears to be an unlimited number of other individuals in the state holding almost any office I can publicly think of. Being a representative of the people is actually being engaged in your community. Folks know where we live. To give a carte blanche to every elected official to hide their home address is so disingenuous to being involved in your communities. I don't understand why somebody would want to hide that information. It is very clear what the political environment is right now. It is upsetting, it is disgusting, it is politically charged beyond measure. And there are certain factions of this country that only add fuel to the fire. And it is unfortunate for the vast majority of elected individuals on both sides of the aisle who then have to survive in that politically charged environment. But we go into these jobs knowing that we are to represent the people. I don't understand how in good conscience anybody can vote to hide the information from the very people they represent. It's ludicrous. And then when you look, I thought perhaps I was missing something, but I'm not. I went to go look so I could better understand all of the people who testified in support of this bill. And sir, unless there is a technical difficulty in uploading testimony, I don't see any. And now there have been technical difficulties in this building in a variety of committees, but I see that FOI doesn't like it. I see that the ACLU doesn't like it. And I see that SEEK doesn't like it. And that is an unlikely grouping of three. And I don't see Board of Ed members asking for this. I don't see any chief elected officials. I don't see any of the probate court judges saying, please hide contact information for the folks I represent so they can't locate me. And I don't see any of our public employee groups asking to have their information hidden as well. So if we're really going to be representatives of the people, we go into this with open eyes. This is such a smack in the face to the people we represent. I'm actually disappointed in the committee. The fact that what is an important provision providing candidates the ability to protect themselves is added to this bill is unfortunate. I would hope that the good leadership of this committee finds a different and more bipartisan vehicle to put those campaign provisions in. Thank you, sir.
Thank you, Representative. Further question or comment from the committee?
Mr. Chair.
Oh, yes. Senator Winfield.
Yeah, I'll try to be brief. I don't know how I'm ultimately going to vote on this bill, but I struggle with the concept of this is just about hiding from your constituency. This is just about what's happening in politics now. I think some of the folks in the room know that I can't even count the number of death threats I've gotten. I've left my job and thought to myself, oh, I accidentally left the windows down in my car. It wasn't that I left the windows down, they were gone. I've been run off the road. I could sit here all night and tell you the things that have happened. I didn't go into politics with my eyes open, if that's what somebody means by your eyes open, because like I never thought the number of credible death threats and actual attempts on my life would be what I've experienced. And I'm not talking about in this era. I'm talking about prior to this era. And so while folks may not agree, and I tend to side with the FOI folks on most things, so that's why I don't know what I would ultimately do. I think this is a legitimate conversation. I think it's something to consider deeply, and this is not simply the kind of political divide that we have. This is the reality some of us have faced. I will tell you that my conversations with the police and the Capitol Police and even federal authorities have told me you don't take this seriously enough. It's not that I don't take it seriously, it's that it's happened so much. It's just a part of, at this point, life. But certainly I didn't join up for that to become my reality. So I would just hope as we talk about this, we think about people who've had experiences that aren't a single death threat or 10, but have had actual attempts on their lives. And that might be part of the reason why what's in front of us is in front of us. Thank you, Mr. Chair.
Thank you, Senator. Any further question or comment from the committee? Seeing none, Madam Clerk, would you please call the roll?
This is a roll call vote on item number 28 of the agenda, Senate Bill number 492, an act concerning security of public officials and employees to be JF to the floor. Senator Flexer?
Yes.
Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is no.
Representative Mastro Francesco,
No.
Representative Bronco, Representative Carpino, Representative Fonsello,
No.
Representative Gauthier,
Yes.
Representative Haddad,
Haddad votes yes.
Representative Hoxa, Representative Johnson,
Johnson votes yes.
oh, Representative Johnson, could you show your face again?
Johnson votes yes.
Thank you. Representative Menapace,
Yes.
Representative Rosario, Representative Santiago, Representative Shannon,
Yes.
Senator Winfield.
Winfield in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 29, Senate Bill 493, an act making technical changes concerning elections. This is a JF to the floor. The chair will entertain a motion.
Second.
Moved by Senator Flexer, seconded by Representative Gauthier. This bill does exactly what it says. It makes several technical changes to our election statutes. Representative Master Francesco.
Thank you, Mr. Chairman. This looks like a placeholder bill. All they're doing here is changing the wording. It says, of each town shall warn the electors therein to in such town. It's looks like a placeholder bill, so I'm going to vote no on this today. Thank you.
Thank you, Representative. Further comment or question from the committee? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 29 of the agenda, Senate Bill number 493, an act making technical changes concerning elections, to be JF to the floor. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Yeah, Sampson's no. Yeah.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? No. Representative Fonsello? No. Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa? Representative Johnson?
Rep. Johnson votes yes.
Representative Menapace?
Yes.
Representative Rosario? Representative Santiago?
Yes.
Representative Shannon?
Yes.
And Senator Winfield?
Winfield in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 30, House Bill 5220, an act increasing the membership and compensation of the State Properties Review Board. This is a JFS to the floor of LCO number 3495. The chair will entertain a motion. Moved by Senator Flexer and seconded by Representative Gauthier. This bill increases the daily per diem rate for SPRB members from $200 to $300. It also increases the annual maximum a member may receive by $15,000 to a new max of $45,000 for the chairperson, $40,000 for all other members. This brings those amounts up by inflation over a certain period of time. The JFS language removes the pre-existing provisions that were increasing the SPRB's membership. Those provisions were in a bill that we previously passed into law in the session. Question, Representative Master Francesco has a question to you.
Thank you, Mr. Chairman. Do we know if we're going here up to from $25,000 up to $40,000? Do we know if they have ever exceeded that $25,000?
To you, I do not know. As I sit here today, I would imagine that they have not, if they have not been allowed to.
And do we know why? I guess I'm curious why we're increasing the amount. Did this come from the State Properties Review Board as a bill?
To you, Representative, it did come from the SPRB, and my understanding is that it's to reflect essentially inflation.
That's a big inflation for them. I could tell you that. Okay, thank you. I don't have any further questions. I will not be supporting this today. This is a pretty big jump in my opinion. Thank you.
Thank you, Representative. Further questions or comment from the committee? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 30 of the agenda, House Bill number 5220, an act increasing the membership and compensation of the State Properties Review Board to be JFS to the floor with LCO number 3495. Senator Flexer? Yes. Representative Blumenthal?
Yes.
Senator Honig?
Senator Honig votes yes.
Representative Moore Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is no.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? No. Representative Fonsello? Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa? Representative Johnson?
Johnson is yes.
Johnson, do you mind just saying that one more
Yes.
time?
Johnson is yes.
Thank you. Representative Menapace?
Menapace is yes.
Representative Rosario? Representative Santiago?
Yes.
Representative Shannon?
Yes.
And Senator Winfield?
Winfield in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 31, House Bill 5342, an act concerning the use of artificial intelligence and other means to generate deceptive synthetic media and affect elections. This is a JSFS to the floor of LCO 3483. The chair will entertain a motion.
So moved. Second.
Moved by Senator Flexer, seconded by Representative Menapace. This bill addresses an issue we've seen develop in our elections, and in fact, unfortunately, flourish in real time in several elections that have been happening, or campaigns that have been happening so far, which is that deep fakes, which are extremely realistic fake media purporting to show or depict an individual, generally a candidate for office or an official, do something that never happened, they never did, saying something they never said, in order to affect an election. And while this bill does not directly reference or deal with artificial intelligence advances in recent years have made creating deepfakes that are highly convincing and can go viral and interfere with elections an increasing reality. And we've already seen them happen in several campaigns and elections. So this bill would prohibit the distribution or entering into a contract for the distribution of what is described as deceptive synthetic media, essentially a deepfake, within 90 days of an election or primary. It would make a number of exceptions to protect the First Amendment. It would accept satire and parody. It also creates an exemption if the media has a disclaimer, and the form of disclaimer is laid out in the bill. It exempts generally political advertising that is required to be played by law under federal law. It allows exemptions for real-time news, for bona fide newscasts or news, whatever the form. And it also allows for certain injunctive relief. The JFS language, injunctive and damages relief, if such a deepfake is distributed. The substitute language narrows the penal provisions and in particular confines them to natural persons rather than corporate persons, and also narrows all criminal offenses related to the bill to persons who have intended to distribute and actually distributed a deepfake to an audience of over 1,000 people. Further comment or question on the bill? Senator Sampson.
Thank you very much, Mr. Chairman. Even though we've been here for quite a long time today, I'm going to try and put some energy into talking about this bill because this is an important one. It's kind of like a mixture of feelings I have when we talk about this proposal, which has come before us a number of times in the past. I think the good chairman is the key proponent of it. I am sympathetic to the concern that is expressed in this bill, but this is an age-old debate that we have in this country about where the limitations of free speech begin and end, particularly when it comes to political speech. And I don't think this bill is going to pass constitutional muster if it's challenged, because similar types of restrictions have been attempted to be imposed in the past, and they've always failed because the Supreme Court, the law of the land, recognizes that even unpopular speech, in fact, maybe more importantly, unpopular speech, maybe even hateful or dishonest speech, needs to be protected possibly more than any other speech. And I got to tell you, I have a tough time with it too, Mr. Chairman, because as someone who is an elected state senator and someone who has to go through a campaign every other year, I am constantly bombarded by my opponents with false claims, outright lies, exaggerations, manipulations, photoshops, you name it. And I can't stand it. Drives me friggin' crazy that people lie. I never engage in any of that. In my own campaigns, I try and stick to policy and debate the issues honestly and fairly because I have the confidence that when people understand the different perspectives on each of these issues, that they'll come down on my side. Unfortunately, there's a lot of people that do politics a different way, and they maybe realize that they can't win with honesty, so they'll attempt to win with deception. The problem I have is that even though I share that concern, it's that I still believe that the First Amendment is so important and it is so key that we must maintain our protection of political speech at all costs. That I'm having a tough time with this bill, partly also because I think it's really written in a very lawyerly fashion. And when I say that, it is not a compliment. It is a observation that recognizes that everything that's in the whole bill, every other word, is purposely written in vague language, so it's subjective. It's just an opportunity for people to negotiate. Well, what did they really mean by the representation or substantially or other words that are sprinkled throughout this legislation that are up for debate? You know, that's how lawyers make their money, is debating what substantially means in this particular sentence in the statute when it comes to a particular claim. And the longer they can debate it out, the longer they're going to have billable hours and maybe come up with a settlement that benefits their client. And I think that, sadly, a lot of our laws are written that way, recognizing that the lawyers on both sides win if all the bills are written this way. So I have some questions. I guess the first thing would be, talk to me about the substitute language, Mr. Chairman. Why did you change this to only impact situations where someone distributes to more than 1,000 people? And what about somebody who distributes to 999 people? They get off scot-free?
To you, Senator, this change was meant to be protective of free speech and the First Amendment by ensuring that individuals who may have sent a deepfake to friends or to a private list, or say a college student who was not paid or involved in a campaign or vendor or anything like that, sends something, does something stupid, prevents them from being covered from the bill. So it provides a safe harbor to the individual for folks who may have made a mistake, but not the kind that we're really seeking to penalize. To you.
Thank you, Mr. Chairman. That's a spectacular answer that really makes me dislike this bill just even a little bit more than I did before. Your explanation to me is really surprising. You're suggesting that college students who do something stupid have more political speech rights than someone who engages in political speech for other means? I don't understand that. Isn't a key component of our system of laws and justice, the rule of law in America is all about equal protection. Shouldn't that apply to everyone equally, Mr. Chairman?
To you, Senator Sampson, the provision does not apply to any specific type of person or speaker. It simply is meant to be a safe harbor for individuals who have not violated the bill intentionally, so that they can have that that safe harbor to know that they will not be pursued by this bill. So it is protective of speech. It does not differentiate on the type of speech or the individual who is engaging it, but solely provides again a safe harbor from the criminal provisions of the bill. To you.
Thank you very much, Mr. Chairman, and I apologize for cross-examining you, but I'm just using what you said. I think it's interesting to refer to this as any type of protection of free speech when in fact the bill is an assault on free speech. It denies certain folks certain types of speech. There's no question about it. Whether or not that's a legitimate policy decision that we could make, that's a different question. But you can't say that this bill protects free speech in any way, shape, or form, nor any provision of it is protective of free speech. All of it is a assault on the ability to engage in political speech. I want to just ask very clearly, you just said this protects someone who did something accidentally or not intentionally. And I don't think that that distinction can be made by the number of people they distribute it to. Do you? Through you?
To you, the bill, it would not distinguish on the basis of intent. You are correct, but someone who does something accidentally or unthinkingly or without intent may still fear being put in jeopardy. And so this is meant to be protective, to provide a safe harbor, so that someone in that situation will not fear the application of any of the penal provisions of this bill. To you.
Thank you, Mr. Chairman. Someone in what position? I'm not understanding. I'm talking about somebody that has, does it protect people that did this unintentionally, or does it protect people that did it intentionally if they have less than 1,000 people they send it to?
To you, Senator, both.
So someone who does it intentionally, but they don't reach 1,000 people, they are protected?
To you, they are protected from the penal provisions of the statute, yes. They could still be subject to civil liability potentially. To you.
Understood. And somebody who does it unintentionally, but it succeeds 1,000 people, they are protected or they are not protected?
To you, they are protected.
Who makes the determination about whether the act was intentional or not? Through you.
A jury would ultimately make the determination, and it would have to be proved beyond a reasonable doubt.
Where is that standard determined? Is that in the bill?
To you, it is in the Fifth Amendment of the Constitution.
Can you just, for a layman, describe to me why that is the burden of proof in this particular case?
To you, it is the burden of proof for all criminal proceedings. To you, and as required by the U.S. Constitution.
Okay. I noticed there's so many questions I have. I mean, just like every sentence like generates another question. But let me just do this one since it's jumped out at me. I notice on lines 29 and 30 it says, referring to the distribution of such deceptive synthetic media distributed without the consent of such individual, and that it says such distribution is intended to injure a candidate or, and this is what I thought was really interesting, it says, or influence the result of such election or primary. Can I just, what if the point was to not injure a candidate, was to help a candidate, but obviously it was to influence the result of such election? Through you.
To you, that provision is meant to, first of all, address potentially multi-candidate or more than two candidate elections where you may wish to help one candidate at expense of another, but maybe you didn't intend to specifically injure one candidate. It would also affect deepfakes that are intended to misrepresent the nature of election. So for instance, again, this is just a hypothetical, is not specific. Say someone created a deep fake of the Secretary of the State saying, the election is canceled, and we're going to make it up on Wednesday. So show up to vote on Wednesday. And this was a hyper-realistic deepfake that no reasonable person could tell the difference between that and a video of the secretary actually doing it. The secretary never did it. So that isn't what would be captured. Those are the potential other scenarios that would be captured by those provisions. To you.
Mr. Chairman, the example that you just gave me is very interesting because my immediate reaction to it would be, is this the Babylon Bee? Is somebody making a skit? And what if the response was that that's the situation, that they didn't expect that anyone would reasonably believe that's accurate because it's so outrageous of a unbelievable statement that it was conceived to be satire. Through you.
To you, Senator, that would be protected as satire or parody, and also not applying under the substantive protection, or excuse me, the substantive provision of the bill, which defines what actually deceptive synthetic media is, which is it would have to be a reasonable person would have to believe that it actually happened. It was depicting reality and was not satirical. To you.
Thank you very much, Mr. Chairman. The reason why I brought it up in the way I did is because you described it in a way that would say that it was perfectly believable, and I just simply suggested that that would be the response from the person who created it, is that they intended it to be satire. How is that adjudicated through you?
Through you, it would be adjudicated through a court. To you.
Thank you very much. There's a lot of courts showing up in my Q&A here with the chairman. I mentioned lawyers from the beginning and how this bill is all about enriching the legal profession. I have to remember there's some colleagues that are attorneys around the table that might take offense to my taking the easiest sharp digs at my friends who serve in the legal profession, who I have great respect for. I just want to say, that this bill, I started, telling a little bit of a story at the beginning of my remarks, but I just want to bring this back full circle to a couple of things. So I was involved in a Supreme Court case regarding free speech, and it all resolved around the fact that I made a truthful statement about the then governor of the state of Connecticut in a campaign flyer, and I was advised by the SEC, the State Election Enforcement Commission, that I was not allowed to comment on anyone other than my direct opponent. And as a result of doing so, I was going to be punished and fined and so forth. And it took 9 long years and appealing several different lower court technical decisions to actually get our day in the Supreme Court. But at the end of the day, the Supreme Court recognized what I knew all along, which is that as a member of the legislature, which is a check on the governor's agenda, I can certainly express my opinions about the governor's policies to my constituents in an effort to promote my own candidacy. And I had a lot of other evidence to back up that that was my reason why. But even though the bureaucracy was so adamant that they had stated with absolute clear intent what the boundaries were of what could be done, I still knew that the First Amendment would prevail, and I was proven correct. And I want to understand, Mr. Chairman, why you think this bill would survive that level of scrutiny, because I just can't imagine a court, even the Connecticut Supreme Court, which I don't think is probably big fans of Rob Sampson, found in my favor in that particular case, because they knew that I was right, that the First Amendment is there to protect political speech, and even political speech that people don't like. And this right here is about political speech, and you're putting limitations on political speech with this bill, and I think in a very significant way, and in fact, I would say a chilling way, by creating vague language that is hard to interpret, where we could have a disagreement right here about the Secretary of State saying that election day is on Wednesday instead of Tuesday, and it can be seen entirely different, and we end up in a courtroom over it. I mean, that is a chilling effect. no question to someone out there who is about to put together a political campaign and conceive of a marketing plan. And I have grave concerns over that. So can you explain to me how you believe this is going to survive that legal scrutiny through you?
To you, Senator, so the First Amendment has never protected damaging lies about other people. That is as pure a constitutional holding and as repeated a constitutional holding as exists. It has been repeatedly held. Now, there are a number of protective doctrines that the Supreme Court has held up so that those with the power to speak back and clear up damaging lies about them do not have the ability to unfairly use their power or power of the government to hamstring others in speaking about them. And that is why the Supreme Court has created the actual malice test from New York Times versus Sullivan for public officials, and it was since extended to public figures. And what that means is that a public figure or a public official, in order to get a judgment for defamation, which is a damaging lie about you, has to prove by clear and convincing evidence to the court or to the jury, as the case may be, that the individual who made the statement made that statement, first of all, it was false, factually false. It was not a statement of opinion. Second of all, that they made it with reckless disregard to the truth. So they had very serious reasons to doubt the truth of what they were saying when they said this falsehood. There are also First Amendment protections for opinion as opposed to fact. The reason why this bill will survive constitutional scrutiny is because it incorporates, by reference, all the relevant First Amendment tests from the Supreme Court. And I've listed some of them here. But the bottom line is that the Constitution does not protect damaging lies about other people. It has erected certain tests and defenses that someone can use, especially when they're talking about a public figure or a public official. But those statements have always been subject to liability for defamation, false light, intentional infliction of emotional distress, negligent infliction of emotional distress, and other such torts and forms of liability. And we're talking here about deepfakes. This is not satire. This is not you make a jokey video of someone. This is literally, you appropriate the image and likeness and voice of someone else, and you use it to depict hyper-realistically, in a fashion that no one else can tell the difference, something that they never did, or them saying something they never said, or a situation that never happened. And the kind of basic foundation of our Supreme Court's First Amendment doctrine is the million idea of the marketplace of ideas. But that marketplace can only function if there is some way to combat the lie or the falsehood that's being spread. And we have entered a modern era, especially with the advent of artificial intelligence, where the very fabric of that reality can be twisted and misrepresented in a way that there can be no accountability or countering, especially when you look at elections that happen at the state and local level. We're talking about a presidential election, we're talking about a senatorial election, or maybe even a gubernatorial election. These campaigns have millions and millions of dollars to try to counter this sort of deepfake. But especially when you look at a state legislative election, a mayoral election, a town council election, someone can take your image, your voice, depict you doing something or saying something that never happened, something that could be severely damaging, something that would be subject to defamation liability, and then use it to damage a candidate or enhance another candidate or misrepresent the details of the election to the populace. And so there is no, I mean, I guess, the question would be, what possible positive use would anyone ever have to do the things that are prohibited in this bill? And I can't come up with one. And that's why 18 other states, red states, blue states, big states, small states across this country have enacted similar provisions. This bill in particular incorporates the rulings that have come from certain courts finding certain flaws with a couple of the bills that have previously been passed in other states. And it incorporates all the law, all the constitutional principles, all the rulings of the Supreme Court that are relevant so that it will pass constitutional muster. To you.
Thank you, Mr. Chairman. I appreciated your very lengthy soliloquy. I thank you for taking over to extend our meeting deep into the evening. I have a few concerns about some of your comments because I don't think that they accurately represent the bill. You talked extensively about damaging lies, and damaging lies are defamation. And defamation is already part of our existing legal structure. It's already a crime. It already can be used for civil liability in the sense that people can sue each other for engaging in that activity. You don't need a new law for that. And in fact, despite the fact that you pointed to this bill as having to do with damaging lies repeatedly in your comments, this bill has nothing to do with damaging lies. It doesn't say damaging lies in it anywhere. It purposely circumvents the notion of defamation. It says deceptive synthetic media means any image, audio, or video of an individual and any representation of such individual's speech or conduct that is substantially derived from any such image, audio, or video, which a reasonable person would believe depicts the speech or conduct of such individual when individual did in fact engage in such speech or conduct. There's nothing in there that says it has to be negative in any way. I mean, later on you do say that it applies when such person knows or reasonably should know that such thing acts with reckless disregard. That's still not damaging lies. That is intended to injure a candidate, but that doesn't even say damaging lies, or influence the result of an election. So influencing the result of an election with this is not damaging lies. It is not defamation. So your protections that you're referring to, the Supreme Court always upholding and protecting against defamation, do not apply here. And the Supreme Court has repeatedly protected harmful, hateful, the worst possible political speech that there is out of an interest of protecting political speech. They do not protect defamation. You are correct in that regard, sir. But your bill is not about defamation, and if it was, it wouldn't be needed because we already have defamation as policy in the state. What you're talking about here is a tool, not an act or a behavior. I just want to put this to the people that are listening. First off, this is an extremely broad definition because this is not just the description that the chairman described having to do with someone altering a video. It also includes audio. It also includes an image. It also would include a Photoshop of an image. If somebody decided to place someone in a spot that they weren't actually there, and that has an impact that could potentially injure a candidate, that would apply under this, correct, Mr. Chairman?
To you, it would have to be a depiction, whether through audio, photo, or video, that depicts the speech or conduct of an individual when such individual did not, in fact, engage in such speech or conduct. And a reasonable person would have to believe that it actually does depict that speech and conduct, and it could not be parody or satire, which are accepted from the bill.
Thank you very much, Mr. Chairman. Bringing up the parody and satire thing, that ends up having to be litigated to determine what's happening, and I would prefer if we just had our conversation about things we agree on, how we describe what they actually are, so that we can make a legitimate determination of how the bill would treat it and what our expectation of the courts might be in those circumstances. So you answered my question, but you didn't answer my question, which was, does it apply in the case where a photoshopped image is made of a political candidate, for example, being present at a particular event, or maybe you put a candidate at a KKK rally, for example. There you go. They were never there, but you make a false image and place them there for the purpose of using in a political campaign to suggest to voters that this person is associated with the KKK and therefore not worthy of voting, which obviously would be very effective. Would that apply under this language as deceptive synthetic media? Through you.
To you, Senator, if it were done with the requisite level of intent, yes.
Thank you very much, Mr. Chairman. I appreciate your answer so much because you are illustrating for me just my issue with this bill. Because everything that I ask you, there's no answer. It is always subject to interpretation. It is always subject to some lawyer's interpretations in a battle in a courtroom someday. And I got to tell you, there's provisions in our law that effectively prohibit us from making laws that are so vague that they have to be so subjective all the time. The danger of this, in my view, is that people lie. They do. I have my political opponents lie. In the last election, my opponent said that I was the chief defender of Eversource. And of course, I've never voted to defend Eversource that I'm aware of, other than maybe as part of legislation that protects a lot of businesses or industries. But I think he was trying to imply I was responsible for electric rates going up, and I'm certainly not. I voted against every provision that would have expanded an increase in electric rates since I've been here. And he knew that was a completely, utterly false statement, but he put it out there anyway, knowing that that's something that people are concerned with. People are upset about their electric bills. I'm just going to put it on my opponent, whether it's true or not. He recently put out a video, same guy, coming back several years later, and he's saying to people in his political campaigns that I live in my parents' basement, which is not true. It's just him saying it. So people lie. And if we're trying to get at people lying and distorting facts to injure other people for political purposes, that's great, except it's never worked before. Can you cite a situation where someone's ever been able to, Mr. Chairman, be able to claim defamation as a political candidate against another political candidate? Now, I know that you've got Donald J. Trump has collected from some news media sources, but do candidates, are they typically able to collect from one another for defamation through you?
To you, they certainly can. They would just have to prove by clear and convincing evidence that the statement was made with reckless disregard to the truth. And they would also have to prove that the statement was factual, and there's a test for that under Supreme Court precedent. And it says essentially that a statement of fact is something that did or could have happened in the world. It's not a statement of opinion, which covers almost everything else. So I hate to tell you, but the statement that someone is a chief defender of Eversource is almost certainly a protected statement of opinion under the First Amendment. The statement that someone lives in their basement, their parents' basement, however, is a statement of fact under the Supreme Court's principles and could be potentially actionable. To you.
Mr. Chairman, thank you. You're making my day. You might have a client. I have a feeling that before this political campaign season is over, I'm going to have a whole dossier of factual false statements that my opponent will utterly. Maybe he needs an education on exactly the definition of defamation. Look, I appreciate the intent of this bill. I really do. I know I'm playing devil's advocate in a big way here. I appreciate the intent. I don't see how this is different than the photoshopped image, that I described. I don't see how this is actually different than someone like putting out a campaign flyer that has a fake headline, that says, this is the Hartford Current, image at the top, and then it says a headline, Senator so-and-so has a DUI. So they're trying to imply that this is a real factual statement. To me, that's deceptive synthetic media, no?
To you, sorry, if the good senator could just repeat or affirm that I am recalling his example or hypothetical correctly. It would be a fake newspaper headline, not a false newspaper headline in a real newspaper, but a totally fake newspaper headline. Well, it would, if it had a picture that depicted the individual engaging in the DUI-related conduct that was fake and false, and a reasonable person would believe that it depicted them in the DUI-related conduct, yes. If it were just purely a headline, then it would not be covered by this bill, because it doesn't depict the individual themselves. It would depict a fake newspaper headline to you. It might still be actionable as defamation, and probably would be to you.
Thank you very much, Mr. Chairman. Is that because your definition of deceptive synthetic media requires that it is both an image, audio, or video of an individual and any representation of that individual's speech or conduct? Is that why you're suggesting that individual would have to there'd have to be more to it than just the headline through you?
To you, yes. It would have to be a picture or video depicting the individual, or audio, I guess, playing or portraying the person's voice. So not a statement about them, but representing that it is them doing something or them saying something in the original record, as if it's a recording of them doing it to you.
All right. Thank you very much, Mr. Chairman. Not to poke holes in this thing, but to get it right, I think it also, the language says deceptive synthetic media means any image, audio, or video, but image qualifies because it's or of an individual. So if you're including an image of the individual and you are including any representation of such individual's speech, the fake headline on the same piece, would that count as deceptive synthetic media?
It would have to be an image, audio, or video of the individual and any representation of their speech or conduct. So it would have to be an image of them, or audio of them, or video of them. So it wouldn't be image or audio or video of someone else talking about them, or a newspaper talking about them. It would have to be of them to you.
All right, thank you very much. Mr. Chairman, I would just caution that I think the language in this paragraph could be cleaned up a little bit, because I think that my suggestion of the individual being part of the piece and the individual's speech requirement is satisfied by the newspaper headline. So I do think that this might be Mr. Chairman, I'm just suggesting that I appreciate what you're saying, but it doesn't say that the image of the individual has to be them engaging in the conduct. It just says that there has to be an image and there has to be a representation of that individual's speech. So to me, that representation of the individual's speech is the newspaper headline claiming that they said they got a DUI, for example. I don't know. I don't want to take us down a rabbit hole, I just think that it's a little more wide open than the way you've described it. I'm sympathetic to the goal here. I don't want people lying. I wish we could find a way to make defamation cases easier. I wish that we had a mechanism for our state election enforcement commission to be able to crack down on candidates who lie about their opponents. And again, I don't want to limit their speech, but I want there to be some sort of mechanism for redress when people make absolutely false claims about one another in a political campaign that prevents it from happening, number one, by creating a deterrent, by making there some sort of penalty when people misbehave to the point of misleading voters and being dishonestly. But I am such a protector of our civil liberties and our constitutional rights that I am loath to start passing laws that are going to give some bureaucracy, the SEC, for example, the ability to start, charging people or fining people based on this behavior, partly because I've been the subject of that same exact nonsense and very unfairly targeted as a result. Mr. Chairman, where do you get these penalties from? Why a Class D felony, which is it's not the worst felony. That'd be a Class A felony, but a Class D felony is no joke. We have trouble putting people in jail for committing serious acts of violence. This is a Class D felony. I don't know what else. I wish I came prepared to point out that there's violent acts that qualifies Class D felonies. Why such a harsh penalty? Through you.
To you, that provision applies to essentially a repeat offender. So someone who has previously been convicted of an offense under this bill and then goes out and does the same thing and is convicted again of the same offense within 5 years. So it is a higher penalty to reflect the incorrigibility of the offender, which is something we often do in our penal law. To you.
Thank you very much, Mr. Chairman. I like that incorrigibility. That was good. That's a dollar word for today. The sections about the Attorney General. Why are we dragging the Attorney General into something that is a civil issue between parties litigating over the use of deceptive synthetic media, potential defamation, etc.? Why are we engaging the Attorney General, who doesn't, except for in recent years with similar bills like this, have a reason to get involved in this, what is otherwise a private matter? Through you.
To you, there may be some circumstances where the nature of the deepfake is a very public one and is interfering in a significant way with our election, and the individual who is affected may either not have the resources to handle it themselves, or it may be a situation where, as described previously, it's a deepfake that has to do, that doesn't depict an individual who's a candidate and a non-public person, but maybe an election official saying something false about the election that deceives people into either into not voting. So the Attorney General is brought in to be a party to enforce this sort of provision in situations where a private individual is either not directly affected or could not reasonably be expected to handle the matter themselves. Too.
Mr. Chairman, is it me, or is it seem a little odd to engage the Attorney General on the side of the plaintiff in such a circumstance, effectively adding weight to the scale and creating a presumption of guilt for the other party? Through you.
To you, I would disagree with the presumption of guilt, but I would say that this is this would be operative not for damages, but for equitable relief, so an injunction to prevent the further spreading of the deepfake. And I think in reality, the only way that this provision would be exercised would be if the deepfake were being circulated by a publisher rather than the creator. So it wouldn't be a campaign doing a deepfake against another campaign, but the deepfake had gone viral or something like that. And then the Attorney General could intervene for equitable relief to prevent the further spread of the deepfake to you.
Thank you very much, Mr. Chairman. I also noticed that you have a provision in here that'll allow certain parties who prevail to be awarded reasonable attorney's fees and costs. Isn't that an unusually significant or maybe even excessive award that's not common in most similar situations through you?
To you, Senator, it is not common in negligence torts, but this would be the equivalent of an intentional tort, and often attorney's fees may be awarded under such circumstances. To you.
Thank you very much, Mr. Chairman. I think I'm almost done. I'm going to come back to where I started, which to me I think is something that actually harmed your proposal today, which is the substitute language that adjusted this threshold about determining whether or not someone's responsible based on the number of people they are distributing to. I think that it undermines the whole premise of your proposal when we start to make determinations about people being more or less guilty than someone else based on how big their audience was, for example. And I also don't think that there's an easy mechanism to measure how many people are actually going to witness something. Does that mean if I distribute something to my 10 friends, but then they turn around and distribute it to 10 friends each, who's distributed to 10 friends each, will I have actually distributed it to over 1,000 people at the end of the day through you?
To you, Senator, you must. The bill requires that you have intended to distribute it to an audience of 1,000, of greater than 1,000. So it sounds like you would not have had that intent because you only distributed it to 10 people. So it sounds like the bill would not qualify based on that hypothetical, regardless of the number of people that the deepfake was actually shared to you.
Thank you very much, Mr. Chairman. Again, not being a lawyer myself, let's talk about whether we often make legislation that creates a crime in this particular case out of intent. Is that something that normally happens through you?
To you, yes. Almost all crimes require a certain level of intent, known as mens rea. Usually, under almost all circumstances, there are a few narrow exceptions, but almost always the state of mind that is required for a crime to have been committed is knowingly or greater. To you.
I appreciate that, Mr. Chairman, but I don't know that that is the same thing as intent. I know exactly what you're referring to. That means that you're aware or cognizant of what you're doing, but the intent, what if I share it with 10 people, but I intend to share it to thousands? I just don't have thousands of followers. I just wish I did. Does that intent get me anywhere through you?
Through you, Senator, specific intent is often a requirement in the criminal law. Depends on the crime, what the specific intent required is. But just keep in mind that any crime must be proved beyond a reasonable doubt. And that means that a prosecutor would have to prove beyond a reasonable doubt that you intended, despite the fact that you did not have the requisite number of followers, that you intended to distribute it to the requisite number of followers. And I think that would be very difficult to prove. And that's what the bill takes account of. To you.
Thank you very much, Mr. Chairman. All right, I appreciate the responses. I'll just wrap up and suggest that I appreciated the lively conversation and the legal education that I'm receiving here as a bonus along with my salary, such as it is as a state senator. So I'm appreciative of that. However, I haven't changed my mind about the bill, which is that I think from an intent standpoint, since we're talking about intent, I think that it has a laudable goal. Nobody wants to see this phony baloney, plastic banana, garbage lies about people in public office or public figures generally. I don't think it's right, and I don't think we should be engaging in that type of behavior. But I already expect that pretty much anything that could be covered with this bill is already subject to the notion of slander or defamation in some way. I don't think we're making something new here. I think that this type of behavior has existed since the dawn of time. There were probably in the original Stone Age political campaigns, people arranging sticks and rocks on the beach to defame one another. And then it became newspapers, the print media, photographs. People probably cut out images from newspapers and stuck them on other images and made copies of that to misrepresent the facts of people's behavior and whereabouts. And then there was Photoshop, and now there's AI. These are all tools. The thing is that I don't think the tool matters. The tool is just the tool. The behavior is what we're after, and the behavior is defamation. That is the behavior. That is what the goal of this legislation seems to be after. And if it's after something else, something other than the intent to actually textbook defame another party, then it's too broad. Then it's too broad. And I believe that the language is subjective as a result. And overall, I just think the bill's unnecessary, because if you engage in defamation, there's either a mechanism to resolve it or not through civil litigation. I do believe it is far too difficult for elected officials to protect themselves, especially at our level. I mean, if you're running for some significant office where you have a lot of media exposure and resources, you can probably defend yourself pretty well. But as a state lawmaker, I mean, somebody wants to invest some money to attack you and defame you and misrepresent you, and it can happen very easily. We still have political and independent political expenditures in Connecticut, and I know from experience they spend a lot of money sometimes. And once the earlier bill that we covered on this agenda today, if that becomes law, that's only going to worsen that scenario. So I'm not seeing a real benefit to this policy, even though it sounds good. I'll give you that. You know, when this is presented to me, I'm like, oh yeah, we got to stop these deep fakes and everything like that. But I believe we have First Amendment protections for most types of political speech on purpose. And the exception to that is defamation, which already exists. And to update our defamation statutes to make sure, which I know they already do, but to make sure that they included something like a deep fake or this synthetic media, I would have no objection to that, because I think that that makes sense. But this particular bill is broadly written. In fact, I believe that it opens the door for endless litigation. I believe that the addition of these thresholds of 20 and 1,000 people, I think, create a mechanism where there is an unequal treatment under the law. I think that trying to leave that up to a determination of intent in court, I think, is unwise. I think our laws should be drafted in clearer fashion, and there should be less ambiguity in what this bill actually says and does. And as a result, Mr. Chairman, I'm not going to vote for it today. I hope that some of the stuff that we talked about you take into consideration as far as maybe fine-tuning things a little bit, or addressing the real issue, which is to make sure that this proper assessment of how AI and other technology is used to unfairly defame participants, particularly in political elections, but in public life. I think it's important, and I think we should address it. I just don't know that this is the mechanism. So I'm going to be a no today. Thank you.
Thank you, Senator. I think we've probably provided a public service today, which is that if anyone watching was thinking of going to law school, they have now changed their mind. In any event, in all seriousness, I would be glad to continue to talk to you about this bill. I think that it is a vital measure to provide a protection against some of the most dangerous dangerous products of recent technology to our democracy across the board and to individuals. And so I'm hopeful that we can come to a solution on this. This bill deviates from other bills that have been passed in other legislatures by being more speech protective generally. So I'm hopeful we can come to a resolution on it, as I know we are all aware of the scope and the importance of the problem. So are there any further questions or comments? Representative Bronco?
Thank you, Mr. Chair. Admittedly, I am reluctant after 10 p.m. with over 20 bills left to debate to ask more questions after the amount of ground the good ranking member just covered. But I have a few more. And this bill I want to support. I'm inclined to want to support because I recognize the issues with deepfakes in particular and the problems that can arise from it. And it is and can be and has been a problem. And so I'm inclined to want to fix that problem. But I do just have some further concerns with this bill. And I'm not going to rehash, some of the free speech concerns when it comes to political speech and all. What I'm more hung up on is where the liability lies in this and around what we consider reasonable. So am I reading this correctly that you do not have to know something is fake? Is that correct?
To you, the relevant standard is that the person must be proven to have known or reasonably should have known that something was fake and depicted something that did not happen. So it would basically, it's almost impossible. You almost never have evidence to prove that a person actually knew something in a court of law. Usually you have to prove it by circumstantial evidence. And so this standard is one that basically describes a situation where any reasonable person would know that it was fake based on the information they had at the time. But obviously you can't prove the contents of someone's mind. So that's the purpose of this standard to you.
Thank you. And that's sort of where my concern lies, especially around deep fakes. Because if you've seen some things online, you see videos, and I like to consider myself a reasonable person. And sometimes there's videos I see that I thought were real before realizing, wait a minute, this is a deep fake. Now you go beyond that, and arguably maybe some of our younger generations are better at detecting some of this stuff, but I see some videos that I see that are like obviously a deep fake AI, and then you hop into the comments and you see what I would consider otherwise reasonable people, adults, believing it's real and being fooled by it. So how do you define what a reasonable person could or should believe to be a real video or not?
Well, you can't define it because it depends on what the actual factual situation is and what the person knew or should have known at the time based on the information that they had. And that's why, that's a standard that's used in various parts of the law to account for the fact that, you can't describe every situation. I will say that there's an additional protection in this bill. First of all, there's the safe harbor we discussed. But also there's protection in that for a public figure or a public official, so either someone who is employed by the public and is a public official or has inserted themselves into a situation of fame or controversy. If the deepfake is about one of those kinds of people, then it would have to be proven that the individual who shared the deepfake did so with reckless disregard to the truth. So they had a very serious reason to doubt that what they were doing that what they were sharing was accurate, and they did it anyway. So that adds additional protection. You can never truly prove what's the contents of someone else's mind are, but you'd have to prove they had really good information, really good information saying that that was false. And, generally that's only going to be someone who's doing it in a malicious context. That's not what the actual malice standard literally means legally. It means reckless disregard to the truth, but it is the spirit in which it is used and meant.
Thank you for that. I'm still hung up on the reasonable factor because I feel like with these deep fakes, it varies from person to person, generation to generation, and I don't know where you draw that line to determine where any malicious intent came from. I mean, if someone sees a video that they believe to be real and it's damaging to a candidate, and they share that video with the intent of spreading that message to hopefully discredit or bring negative press or whatever to that candidate, and they share this video, and they have 1,500 friends on their friend list. Do they now meet the threshold for what would be punishable by this bill? Because it could have reached over 1,000 people, and they shared it with the intent to damage the person in the video they believe to be real that the video is made.
Well, it would have to be proven that they either didn't believe that the video was real or the thing actually happened, or that they reasonably should have known that it was fake. Or if it's a public figure that's being depicted or a public official, it would have to be proved that they acted with reckless disregard for the truth, meaning essentially they really knew that it was fake. So that intent element is almost always the most difficult thing to prove when you're talking about any sort of whether it's a criminal offense or civil liability. And so that is the biggest protection for most people, is that it's a very high standard. It has to be proved by clear and convincing evidence, even for the civil case context. For a criminal case, it has to be proof beyond a reasonable doubt. So this is a very high standard. It would take pretty significant and compelling evidence that the person really pretty much knew that it was fake. So they either knew it was fake or really had a good idea that it was probably fake.
So can the bar for reasonable change from person to person? Say a younger person who's grown up with deep fakes and they kind of know, versus maybe someone from an older generation who is still deceived by these things. Can the level of reasonableness change?
To you, the reasonableness standard is one that's used in the law a lot. It is an objective standard, meaning that it is not aimed at any particular person, but it describes what a reasonable person in the individual's circumstance, so everything about them and their situation, what they would believe or how they would act. So it incorporates the entire factual situation to determine what a reasonable person is in that circumstance to you, and what they reasonably should have known.
Okay. Is everybody protected from satire?
To you, protected from liability for satire under the bill?
Yes.
To you, yes.
So if somebody made a video with maybe the malicious intent, they make this video, but they intend it as satire and would believe, a reasonable person would believe and understand this is satire, are they held accountable to this?
So the standard is not purely, it's not subjective. So what matters is not necessarily, it's not only what they believe, although that can get taken into account, but it's what a reasonable person would believe. So, if it is a hyper-realistic image that depicts something that, the average person would look at and say, that really happened, that's not parody, that's not satire, then it would not be protected under the satire and parody provisions. If it had elements that would make someone probably interpret it as parody and satire, then it would be protected. And this incorporates the satire and parody principles that have been developed by the courts, which are generally quite expansive in these circumstances.
And so if this person makes the deceptive video, intends it as satire, they post it to their feed, they only have 500 friends. So they're under the 1,000-person threshold, but it goes viral and gets shared massively. And now there's 10,000 views on his video. Is he now held to the 1,000-person, so he now falls victim to this penalty because over 1,000 people saw it, even though he didn't intend for more than 1,000 people to see it?
That's the purpose of the safe harbor that was put in through the S language. So it would require that it be proven that that person intended it to be shared with an audience of more than 1,000 people, in addition to it actually going to 1,000 people. So it would have to be the intent, and then it actually happened. So if one of those is missing, then they're not covered.
So if the person in this example has 1,000 friends in that same situation, he's then accountable.
Well, theoretically, it could be. It'd have to be proven that they intended for the video to be shared with all of those friends, which I think generally does not. First of all, it'd have to be shared with all those friends. It'd also have to be and prove that it was intended to be shown to all those friends, which I think is not generally how these social media sites work, but that would be a burden that was on the prosecutor to prove. And also, again, you'd have to prove that this person, first of all, that the audio or video was something a reasonable person would think was real, that it was about an individual, that it had the intent to damage a campaign or affect an election. And it would also have to be proven that they acted with, if it was a public figure or a public official, which any candidate would be, reckless disregard to the truth. So there are a number of kind of legal principle protections that are baked into how you get from A to B and actually get to liability under that principle to you.
Okay, thank you. So let's stick with our guy in this example, and he has, if by that logic he has 1,000 friends, but he didn't reasonably think all 1,000 would see it. Where if he had 3,000 friends, but he only thought maybe 500 of his friends would see it, so he didn't intend to distribute it to all. Like, where's the metric for? Okay, yes, he has 1,000 friends, but didn't mean for all of them to see it. Or if he has 5,000 friends, but only thought 500 would see it because he doesn't usually get more than 15 likes on a post. And he deceptively made this video to damage someone, or intended it as satire. But then the circumstances follows of, okay, I have 2,000 friends, but I usually get 200 views on my stuff. But then, so where is that line of where he's then held accountable, if not by the number of friends on the friend list?
So just keep in mind that a prosecutor would have the burden of proving his intent beyond a reasonable doubt. So that means they would have to have pretty compelling evidence of the state of that person's mind. And I think like just the number of your friends, if you shared it privately to your friends, I think it would be pretty difficult to prove that you intended to share it with over 1,000 people. There would have to be pretty compelling evidence that you expected it to do that and that was your intent. I think what this part of the bill would, essentially what it would end up capturing is people who usually are paid to distribute these sorts of things, or do so with the intent to distribute them to far more than 1,000 people, because you'd have to prove that baseline, and you'd have to do it by evidence other than just simply how many friends somebody has to you.
Thank you. And this is where this bill gets me, because I understand what we're trying to do and we're trying to avoid. So conceptually, I agree, because we know how damaging these deep fakes can be. I'm just concerned with, it seems to be a moving ball with the reasonableness, the where the liability falls. I mean, how far does the chain of liability go if a post starts getting shared multiple times? How far down the line, if you're the fifth or sixth person to share it, are you still liable if you meet all the other criteria? Where does that chain of liability end in this scenario?
It does not. I mean, anyone who distributes it could potentially have it applied to them. It would depend on their individual intent and what they actually did. I will say, just generally, one really good way to prove or to rebut or undermine the proof that you intended to share it to a certain number of people with a certain level of intent is that if at some point you receive evidence that it may be fake, you take it down. And I think it would be pretty difficult to prove that that person was intending to do all the things that are laid out in the bill if they did that. So that would be my answer. It doesn't depend on where you are in the chain. If you distributed it with the requisite level of intent throughout the bill, the requisite level of deep fakeness and realisticness, and you did it to a certain number of people yourself and intended to do it to a certain number of people yourself, that is what matters, not kind of which person you are in the chain to you.
Thank you. I think that generally answers my questions. I don't know if it assuages my concerns though, because again, I understand what we're trying to do with the bill. I just don't know how you really craft this in a way that can avoid some of these ancillary downfalls of who can get wrapped up in this. So I'm gonna vote no out of committee with the hopes we can continue discussions or just figure out how we might be able to address some of these concerns and maybe get to a place that we can support it, because the thing is, deep fakes and the stuff is only going to get better. So it's hard to determine where you draw that line without infringing on general free and political speech. So I hope we can get there. I hope we can figure it out to a place that I'd be comfortable with a yes. But I appreciate your answers, and I look forward to continued discussions. Thank you.
Thank you, Representative. Further question or comment from the committee? Seeing none, will the clerk please call the roll?
This is a roll call vote on item number 31 of the agenda, House Bill number 5342, an act concerning the use of artificial intelligence and other means to generate deceptive synthetic media and affect elections, to be JFS to the floor with LCO number 3483. Senator Flexer?
Yes.
Representative Blumenthal?
Yes.
Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is no.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? No. Representative Fonsello? Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa?
Yes.
Representative Johnson? Representative Menapace?
In the affirmative.
Representative Rosario? Representative Santiago?
Yes.
Representative Shannon?
Yes.
And Senator Winfield?
Winfield in the affirmative.
All right. One last check for Representative Johnson.
Apologies for the technical. Johnson is yes.
All right. Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 32, House Bill 5434, an act concerning statewide recognition of minor parties for purposes of nominating petitions to the JF to the floor. The chair will entertain a motion. So moved. Moved by Senator Flexer, seconded by Representative Menapace. This bill allows minor party candidates to petition for and receive ballot access in any state, district, or municipal race if one of its statewide candidates received at least 1% of the vote for that statewide office in the last election. And I believe it also requires that there be recognition in 25% of legislative districts. Further question or comment on this bill? Representative Master Francesco.
So, if I'm understanding this correctly, they need, what is the current percentage right now that they need to get to maintain status on the ballot? Do we know?
They have to if they don't already have, so they have to maintain it in every district in every election, essentially. And so if they didn't do it in the last election, they have to go out and petition. I don't know what the exact percentage is, but they would have to go out and do it every election in every district. This would allow someone to petition on to that ballot line if the minor party has demonstrated that it has sufficient purchase statewide to have gotten 1% of the actual vote in the election, in a statewide candidate election, and then also that it's been on the ballot in 25% of the legislative districts to you.
Okay, so it's 1% for the total of the votes that they got, correct? In all the towns combined would get them on the ballot, as opposed to now you need 1% in this town, 1% in another town to be able to maintain ballot access within that district or town. Am I understand that correctly?
Correct. If they've gotten a statewide candidate race, one of its statewide candidates has received 1% of the vote statewide in the previous election. Too.
And it would be the same for your state senate and state representative offices as well within that local district to you?
It would apply to those races as well. So basically, one moment, sorry. Yes, it would apply to all state legislative races if 1% of a statewide candidate were reached to you.
I don't think I have any more questions.
Or a statewide candidate reached 1% to you.
I don't have any more questions right now on this one. Thank you.
Senator Sampson.
Thank you, Mr. Chairman. So, you mentioned two thresholds in your responses to my colleague. The 1% I understood, but I don't see any reference to 25% of anything. Can you just clarify that, Mr. Chairman?
To you, you are correct, actually. I'm looking at the language of the bill, and it's not there. So it is just the 1% statewide candidate threshold to you.
Thank you very much, Mr. Chairman. It's a mirage. This is a very, very low threshold in my mind. Can I just ask a question? How long does this last for? So if this 1%, which I presume, well, confirm this for me, someone could achieve this by being cross-endorsed by such a minor party? Does it require the candidate to receive at least 1% on the cross-endorsed line, though? 3.
To you, my understanding is that it would require them to receive 1% on the cross-endorsed line. It would last I guess it would last 4 years because it would be from the last statewide election.
Thank you very much, Mr. Chairman. I'm just trying to think about this because I think all of us have been around, at least the leadership of this committee. We've all been involved in politics for long enough to have some experience with the Independent Party of Connecticut. And I recall back in, I don't know exactly what year it was, 2011 or 2012, I was involved, like a lot of Republicans, in helping the Independent Party actually get on the ballot by going out and collecting petition signatures in my district and in other ones to give them ballot access, because the current law says that you've got to petition for each legislative district. Is that correct, in order to get on the ballot through you?
To you, yes.
Thank you very much, Mr. Chairman. And how long does it last under current law? So if I am going ahead and petitioning to get on the ballot, that would last for a state legislative cycle or a statewide legislative cycle?
To you, I believe it would last 2 years because they'd have to nominate someone. They don't have to petition the following 2 years, but they'd have to nominate someone for in that seat or in that race for that seat in the next biennial election. To you.
All right, thank you very much, Mr. Chairman. Yes, I remember doing that. And then there was a big dust up because there were different competing factions of the Independent Party in the state of Connecticut, and it was some question about who was going to be in charge. And I happen to represent the 16th Senate District, which is touches Waterbury, and Waterbury had a very prominent and vocal Independent Party, but that was not the same as the Danbury Independent Party, and there was kind of a competition for what was going on there. And even though I think in one election cycle, the Danbury faction of the Independent Party controlled the nominations in most cases, but in Waterbury we had to have a convention primary. So I remember going through a lot of trouble to go out and find independent voters and encourage them to support me and actually get them to show up at a convention and compete against my opponents. And I did that for a number of cycles. And I remember that vividly. But that I was pleased to do it. I was proud to help the Independent Party get ballot access and to serve as a candidate on both the Republican and Independent lines. And I was proud to serve in the legislature as an independent. And then there was a change, which occurred coinciding with the pandemic, of leadership in the Independent Party, and they suddenly decided they didn't like some candidates, including myself, so they decided to abandon their own rules, and they decided not to have a caucus or convention process to choose their candidates that year, because ultimately that would have meant that certain candidates, including myself, would likely have prevailed. So they just forewent their entire bylaws and rules and decided to just let their leadership team choose who their candidates were. I tell this story because I want people to understand that, giving political parties access is important, but it's also somewhat dangerous because today the Independent Party of Connecticut doesn't match any of the principles and values that it did 10 years ago when I was on the ballot as an independent. Today it's a very, very progressive political party, and the leadership is no longer interested in recognizing the interests of the actual independent voters in the state of Connecticut. They just ignore them entirely. So if you're a registered independent, you should know your leadership's not listening to you. They're making their own choices. But the fact of the matter is, if we make this change, are we empowering a minor party ballot access in excess of their meritorious achievement? In other words, does that make sense? I guess what I'm afraid of is that if you create this circumstance, can statewide candidates simply cross-endorse as any particular candidate? They could even come up with creating their own political parties and cross-endorse themselves and create a political party that other candidates can use that matches their their name or background. I think we're making it too easy to become recognized as a significant political party in the state. I want to recognize the political candidates, and I want to recognize the ability to create a political party, but I think it also ought to mean something. There ought to be representation of individuals in the state that have placed authority in that party to speak on their behalf. I think they ought to live under their own bylaws. And one concern I have is that we allow in the state numerous party endorsements on our ballots, where candidates are allowed to show up multiple times based on the parties that have cross-endorsed them. I've never liked this policy. I put a bill in every year to get rid of it. I think that if you're a candidate for public office and you're endorsed by more than one political party, you have to choose. You should say, I'm going to be on the ballot as a Republican. I'm going to be on the ballot as a Democrat. I'm going to be on the ballot as an independent, whatever. But pick one. And it's fine. I'm not saying you can't be cross-endorsed by another party, but you should pick one. The days of having one candidate on the ballot 3 times and the other candidates on the ballot 1 time, for one thing, it's confusing. I am asked about it every election cycle because people don't find it logical. I would encourage this committee to take up that discussion one of these days, because I think it's a good discussion for us to have. But I'm also concerned that that confusion leads to people filling out their ballots incorrectly, and I don't want to see people's votes not count as a direct result of that. So I feel like I probably have a lot of questions about this, but I can't seem to think of any off the top of my head. It just seems like a pretty straightforward policy that I think is ill-conceived. Can I ask where this came from, Mr. Chairman? Is there a political party asking for this recognition? I mean, who's promoting this through you?
To you, I believe the independent party has supported it. To you.
Okay, Mr. Chairman, I suppose that makes sense. Under the current law, the independent party could have ballot access if they achieve the same 1% threshold, but that would limit their access only for statewide offices. Is that correct through you?
To you, yes.
So the change that's happening here is that not only would they have access for the race that they actually achieved a level of support, we would be providing them access to a ballot line in every other race in the whole state as a direct result. Is that correct?
Yeah, just to you, just state offices to you, so not municipal offices.
But by state offices, we do mean our constitutional offices and all state lawmakers, representatives, and senators. That's correct?
To you, yes.
All right. Thank you very much, Mr. Chairman. I don't think I have any more questions. I think that this is an interesting proposal. I don't know that I'm inclined to support such a significant change in what has been a long-standing policy for as long as I can remember in the state of Connecticut. And if anything, I think that the threshold ought to be achieved. And I think the current 1% requirement, or the petition requirement is satisfactory. I know because I did it. I did it for the independent party. And I would gladly do it again if the independent party shared my views. Thank you.
Thank you, Senator. Further questions or comment from the committee? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote for item number 32 of the agenda, House Bill number 5434, an act concerning statewide recognition of minor parties for purposes of nominating petitions. To be JF to the floor. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne? Yes. Senator Sampson?
Sampson is no.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? No. Representative Fonsello? Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxha?
No.
Representative Johnson?
Johnson votes yes. Johnson votes yes.
Awesome, thank you. Representative Menapese?
Menapace in the affirmative.
Representative Rosario? Representative Santiago?
Yes.
No, I saw her. I saw her. Representative Shannon?
Yes.
Senator Winfield?
Winfield in the affirmative.
Representative Johnson, do you mind just stating your vote again?
Apologies, must be the internet connection. Johnson votes yes.
Awesome, thank you. What was Santiago? Santiago, do you mind also stating your vote again one more time?
Yes. Yes.
Thank you, Representative. All set, thank you, Chair.
Thank you, Madam Clerk. Next up is number 33, House Bill 552. Oh, excuse me. Item number 34, which is House Bill 5529, an act concerning poll books for the checking of electors at elections, primaries, and referenda. This is the JFS to the floor of LCO 3477. The chair will entertain a motion.
So moved. Second.
Moved by Senator Flexer, seconded by Representative Morin-Bello. Representative Morin-Bello, Madam Vice Chair.
Thank you, Mr. Chair. This bill requires the registrar of voters to notify political parties, candidates on the ballot, or political committees formed for a referendum if the electronic poll book is being used or only the official paper checklist, and it imposes a fine for failure to notify the groups. This gives interested parties notice of how the polling operations will be run on Election Day.
Thank you, Madam Vice Chair. Further questions or comment from the committee? Representative Carpino?
Just a couple of clarifying questions for the good proponent. Is it a single fine of $50 or $50 for each group that the individual failed to notify?
That is a good question. I don't know that the answer is in the bill.
Fair enough. And my second question is, who will actually pay the fine? Will it be the individual or will it be the town on their behalf?
Representative?
And I think that would be what the process is for other fines for the registrars and election officials.
Thank you. And thank you for those answers. I hope we can get some more detail before it gets to the floor of the House.
Thanks.
Further question or comment from the committee? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 34 of the agenda, House Bill number 5529, an act concerning poll books for the checking of electors and at elections, primaries, and referenda. This is JFS to the floor with LCO number 3477. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Moore and Bello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sampson's yes.
Representative Mastro Francesco, Representative Mastro Francesco,
Yes. I had to look to see what bill we were on. Yes.
thank you. Representative Bronco, Representative Carpino, Representative Fonsello,
Yes.
thank you.
Can you hear me?
Yep.
Okay, thank you.
Representative Gauthier,
Yes.
Representative Haddad,
Haddad votes yes.
Representative Hoxa,
Yes.
Representative Johnson,
Representative Johnson votes yes.
thank you. Representative Menapace, Representative Rosario, Representative Santiago,
yes,
Representative Shannon,
Yes.
and Senator Winfield.
Winfield, in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 35, House Bill 5530, an act concerning a study of absentee ballot acts in unconsolidated cities and boroughs within a town. This is JF to the floor. Moved by Senator Flexer, seconded by Representative Shannon. Senator Flexer?
Yes, thank you, Mr. Chair. Mr. Chair, this bill will create a task force to study the use of absentee ballot or the limited use of absentee ballots and try to figure out what the obstacles are for voters in unconsolidated cities and boroughs. Thank you, Mr. Chair.
Thank you, Madam Chair. Further question or comment from the committee? Representative Massa Francesco.
Thank you. Just for clarification, can you elaborate a little bit more on this? So they are now, currently you want them to apply for an absentee ballot through the online application system because they currently right now are not going to their town or they can't call in? How are they working currently right now and how will this differ?
Senator, to you, generally, yes. Currently, you cannot apply for an absentee ballot for a submunicipal election through the electronic system, and some submunicipal elections do not offer absentee balloting. So this would be a study to figure out how to get better access to absentee balloting and perhaps get the application process into the electronic process for those elections to you.
Okay, thank you. And if I remember the testimony correctly, they did say that their town is not listed online. Is that correct? Through you?
Yeah, I do.
I think the answer is yes to you.
That's what I thought.
No, it's okay. I was just gonna.
Okay, thank you. I have no further questions. This is fine. Thank you.
Further question or comment on the bill? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote for item number 35 of the agenda, House Bill number 5530, an act concerning a study of absentee ballot access in unconsolidated cities and boroughs within a town, to be JF to the floor. Senator Flexer?
Yes.
Representative Blumenthal? Senator Honig?
Senator Honig votes yes.
Representative Moore and Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson's yes.
Representative Mastro Francesco? Yes. Representative Bronco? Yes. Representative Carpino? Yes. Representative Fonsello?
Yes.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Because you got the challenge before they punch out for me, he chose not to. I believe it went off of Caravan. They were going to award the ball from him. Did it? Yes. All right, Chief. Thank you. So the ball gets his own miss.
Representative Hoxa?
Yes.
No doubt, a lot of coaches.
Representative Johnson?
Representative Johnson votes yes.
Representative Menapace?
Yes.
Representative Rosario? Representative Santiago?
yes,
Representative Shannon?
Yes.
And Senator Winfield?
Winfield, in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up is item number 36, House Bill 5531, an act concerning faithful presidential electors. This is a JFS to the floor of LCO number 3470. The chair will entertain a motion.
So moved. Second.
Moved by Senator Flexer, seconded by Representative Morin-Bello. This bill would establish a procedure for removing and replacing presidential electors who do not vote for the candidate that they were pledged to vote for. Question or comment from the committee? Senator Sampson?
Thank you, Mr. Chairman. I appreciate this this bill. We've had similar bills that were titled "Faithless Presidential Electors." I noticed the change. I appreciate faithful electors, I guess. And I understand the concept here, which is a desire to make certain that electors for each of the political parties do what they were effectively appointed to do, which is to execute their votes in keeping with their commitment. The bill contemplates a couple of different scenarios. The unfortunate demise, potential maybe, of a candidate, and what should happen as a direct result of that. And I think it's pretty easy to follow Section 1. I have to admit that I've been reading through Section 2, and there is a great deal of underlined language. And I'm hoping that the good chairman can explain this to me, because I'm not certain I'm following what's happening in Section 2 of the bill. Maybe you could just give me a summary, Mr. Chairman?
To you, so this adds to the existing presidential elector appointment language. Some of it is conforming changes and technical changes. Starting in subsection B2, it adds several provisions. First of all, providing that in order to be eligible to be chosen to fill a vacancy in the presidential electors of the state, a person has to execute a pledge that they agree to serve and mark their electoral college ballots consistent with the pledge of the presidential elector who they're replacing. There's then the procedure of the Secretary of State providing that each presidential elector the ballots for president and vice president. The presidential elector completes the ballots and then affixes their signature and legibly printed name to such ballots. The bill next indicates that the elector completes their ballot and presents the ballots to the Secretary of the State, who examines the ballot and accepts as cast each such ballot marked consistent with the pledge. If there is a ballot that is not cast in accordance with the pledge, or the elector refuses to comply with these provisions, then the vote is forfeit. The office of presidential elector is forfeit for that person, and that causes a vacancy in the office of that presidential elector for the state, and it's filled in accordance with the previous provisions. And each time they are filled, the process is repeated until all electoral college ballots for all presidential electors of the state have been accepted. And then it lays out the formalities of the presentment of the certificate of ascertainment of the presidential electors and the transmission, and it provides that any presidential elector who refuses to sign any of the certificates of votes, so those certificate of ascertainments, will forfeit the office of presidential elector and cause a vacancy in the presidential electors of the state, which again will be filled in accordance with the previous provisions. And then it designates what happens after all the electoral ballots have been cast and accepted, and the certificates have been signed and accepted, and the Secretary prepares a list, and it designates what certificates of ascertainment and appointment the Secretary should prepare, issue, and transmit in the most expeditious method available to the certificate of the Archivist of the United States. And then there's a provision indicating that a presidential elector, again, who fails to mark their ballot in accordance with the pledge will be ineligible for that office of presidential elector. and there's certain other details about how the certificate has to be presented in section 3. To you.
Thank you very much, Mr. Chairman. I appreciate the detailed explanation. That's very, very helpful. I'd like to know if you could just tell me how this differs from the current law of Connecticut. What is changing exactly? My understanding is that this is pretty much the same situation, or do we not have any protection against faithless electors?
To you, the sole protection we currently have is just the pledge process. So we don't have designated what will happen if someone betrays their pledge, essentially, and becomes a faithless elector. So this would create essentially a recursive process where the office is the electors are replaced until the office is filled with someone who completes the ballot in accordance with their pledge, at which point the process moves forward. To you.
Thank you very much, Mr. Chairman. I don't mean to take up the time of the committee, especially at this this late hour, but I struggle with this a little bit because I have to ask myself, what conceivable reason must have existed for electors to exist to begin with? I mean, we could just as easily suggest that the results of the election dictate the way the electoral votes are determined. Why actually have people as electors? And the second question of that is why have them if you're going to obligate them in every circumstance whatsoever? In my view, I believe that they were there as a constitutional protection against something going wrong or haywire, a constitutional crisis, an unfit candidate being chosen to succeed another candidate, something like that. I get the desire, and I know that there's precedent that says that the federal government, under our Constitution, does allow the states to set up a mechanism to require electors to fulfill their duty, and they can even be penalized if they don't. I get that, but I don't know that it's a good idea. Is there some compelling reason, Mr. Chairman, why we want to make our requirements so strict that they don't allow any potential reason that might be legitimate for an elector to exercise their judgment? Through you.
To you, Senator, I think there's probably a couple reasons. One that I can identify that's philosophical, which is after an entire nation has voted, it would be undemocratic for someone to functionally have, in order to occupy this office, they have to pledge to vote in the way that the party that designated them for the candidate of the party that they were designated for. So if they get into that position and then they're not going to comply with that pledge, they functionally committed fraud to get into that position. And it would be anti-democratic for a handful of people to maybe sway the result of a presidential election where millions of Americans have voted and indicated their preferences. For someone to countermand that preference of that state and take it into their own hands, I think would be fundamentally anti-democratic. We have a very different system, obviously, now of presidential elections than we did then. And I think also one of the concerns that exists now that maybe didn't necessarily in the past is, again, just the specter of political violence and what that could mean for a presidential elector in very specific situations. It could make, if there's an election comes down to a state and the result was clear in that state and no one disputes the result in that state, and then all of a sudden a handful of people who have this power theoretically to change the result of the presidential election away from what their state voted for. There's a handful of people, they're publicly identified. All of a sudden you have an entire nation of people who could be targeting them and trying to use violence to sway their vote and therefore sway who the president is. So I think there's multiple purposes here. One is to try to prevent there being from any incentive to political violence in that regard. Two, to protect the electors from the specter of political violence. And three, to allow such people to volunteer themselves without that fear. So, it's obviously not a complete fail-safe, but it would remove the incentive for individuals interested in engaging in that sort of abhorrent behavior to essentially try to take control of the country through anti-democratic means from doing so. To you.
Are you suggesting, Mr. Chairman, that there could be no legitimate reason why someone might need to alter their intent to vote for the candidate, especially in a circumstance where we're talking about not the actual original candidate, or maybe it's a replacement candidate, where I believe our policy that is before us creates new law for Connecticut that would say that the electors are required to follow through even on a replacement candidate, which doesn't currently exist. Is your suggestion that there's no legitimate reason that that person could ever be acting in the will of the people through you?
To you, I think in the case of a replacement candidate, it could be that they may find themselves in a situation that they didn't reasonably anticipate. But I think if they end up in that situation, having taken a pledge to vote for the candidate of the party that they were appointed for, I think the proper thing to do if they find themselves unable to vote for that person is to remove themselves from the office, not to contravene their previous pledge to you.
Thank you very much, Mr. Chairman. You make a very compelling argument, but let me just throw a few devil's advocate points out there for you, which is that, things happen in the world that may not be anticipated. There is a period of time between Election Day and the date that the electors actually file their electoral votes. And there are things that could happen. You could have a disputed election. You could have an election that's disputed to the point where it's proven that the wrong candidate actually won the election. You could have a situation where there is some evidence of foreign control or blackmail against the candidate that won the election or was the replacement candidate, for example. You could have that candidate or replacement candidate become severely incapacitated, where they were not fit to serve in office. You could have any number of circumstances that I think the people that created our electoral college system anticipated might require a further check. And I am very sympathetic to the chairman's argument that, you make a promise, you keep it. If you make a pledge to a political party to follow through to elect their candidate. But I can also see that these are all legitimate circumstances. You could have the entire body politic of the entire country flip on a dime overnight if certain information was revealed about the winner of a presidential election that might preclude and endanger the elector for actually following through on their promise to cast their vote in favor of that individual. So I'm not convinced that that's the best solution. I think that the reason why the electoral college exists in the fashion it does, where there actually are human being electors, and it's not just a matter of process that the electoral votes are awarded based on the election. They actually put people in there that presumably the advantage of having a human being serve as an elector is that they have the ability to discern and make intelligent decisions to uphold the will of their the voters. So let me just move on to Section 3, because I really want to understand the references to the national popular vote. This is something we debated in heated fashion because I think it's maybe one of the worst things ever passed in this legislature. It completely diminishes the value of the individual voter. It also negates the will of the people of Connecticut as voters. So how does the national popular vote factor into this electoral question?
To you, Senator, it doesn't. The language referring to the national popular vote in this bill is meant purely to say that it does not change the current law with regard to the national popular vote, regardless of your position on the wisdom and correctness of that being the law to you.
Thank you very much, Mr. Chairman. And I just want to make sure that that also would apply to the National Popular Vote Compact, of which Connecticut is a part, through you.
To you, this bill makes no change to the National Popular Vote process or the National Vote Compact or Connecticut's participation in the National Popular Vote Compact. To you.
Thank you very much, Mr. Chairman. I will take your word for that. I think that that is all my questions on this proposal. I really do appreciate the dialogue. I do think that the points that you made are important and worthy of consideration. I think I could find myself easily being swayed to suggest that, look, the electoral vote's got to follow their pledge. But I can't help but thinking that people smarter than me created our system, and they put people in those roles as electors. And they did it for the unforeseen circumstance that we cannot predict. And they were smart enough to realize that those unforeseen circumstances actually do happen. So I'm going to oppose it today, give it much more thought if it proceeds to the floor. Thank you.
Thank you, Senator. Any further questions or comments? Representative Bronco.
Thank you, Mr. Chair. I'm just curious, are there any other states that do this, and how many?
To you, yes. And there's also model legislation. I don't know how many. To you.
Okay, I'd be interested to know if it's, a couple other states, or if kind of the majority of the states are doing this, we're behind the trend, or where we are in that process. But we could follow with that information. Thank you.
Thank you. And Google just informed me that 38 states and the District of Columbia have such laws, with 15 states having mechanisms to remove or penalize faithless electors, too. So we can continue to discuss, obviously, but that's what I've got right now.
The Google's good. Thank you.
Thank you, Representative. Further questions or comments? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote for item number 36 of the agenda, House Bill number 5531, an act concerning faithful presidential electors, to be JFS to the floor with LCO number 3470. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is no.
Representative Mastro Francesco?
No.
Representative Bronco? No. Representative Carpino? Representative Fonsello?
Yes.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa?
Hoxa votes yes.
Representative Johnson?
Representative Johnson votes yes.
Representative Menapace? Yes. Representative Rosario? Representative Santiago?
yes,
Representative Shannon?
Yes.
And Senator Winfield?
Winfield, in the affirmative.
Thank you, Chair.
Next up on our agenda is item number 37, House Bill 5532, an act implementing the recommendations of the Office of State Ethics for revisions to the state codes of ethics and increasing various monetary thresholds in said codes. This is the JF to the floor. The chair will entertain a motion.
So moved.
Second.
Moved by Senator Flexer, and I believe the Representative Osborne was first on that one with a second. This bill would do what it says. It makes several changes to the state code of ethics for public officials, including modifying when a public official has a substantial or potential conflict of interest, adjusting certain disclosure requirements, raising the code's financial thresholds to accord with inflation, and reducing the quorum requirement for the Citizens Ethics Advisory Board. Further questions or comments on the bill? Sorry, Representative Massafrancesco.
See how well we're trained even at 11:15 at night. Don't speak until you're recognized. Thank you, Mr. Chairman. This is a big bill. This is for the Office of State Ethics, which is a really good agency. I believe they do a really good job. It seems that most of it is technical. The part at the end where you said they increased the threshold, is that for lobbyist donations, gifts that they may give to a legislator? I know one time it was $50 and you had reported it. They actually brought it up to $100. Is that what that section addresses to you?
To you, yes. It's the gift section. It raises the threshold. It's something we have attempted to pass in the past.
Okay, thank you. Thank you. And I agree with that. This bill seems mostly technical in nature with a couple of changes like we discussed, and I'll be voting yes on this. Thank you, Mr. Chairman.
Thank you, Representative. Further question or comment from the committee? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 37 of the agenda, House Bill number 5532, an act implementing the recommendations of the Office of State Ethics for revisions to the state codes of ethics and increasing various monetary thresholds in said codes. 2BJF to the floor. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is yes.
Representative Mastro Francesco? Yes. Representative Bronco? Yes. Representative Carpino? Yes. Representative Fonsello?
Fonsello votes yes.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa? Representative Johnson?
Representative Johnson votes yes.
Representative Menapace? Yes. Representative Rosario? Representative Santiago?
Yes. Yes.
Representative Shannon?
Yes.
And Senator Winfield?
Winfield, in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 38, House Bill number 5534, an act designating the state as the birthplace of the Boys and Girls Clubs of America, the state amphibian. The town of Enfield is the gateway to Connecticut and the state rock. JFS LCO 3487. The chair will entertain a motion. Moved by Senator Flexer, seconded by Representative Shannon. The JFS removes the Enfield provision. Otherwise, the bill is unchanged. Or actually, there's a slight rephrasing of the Boys and Girls Club history. Otherwise unchanged. To you.
Thank you very much, Mr. Chairman. I'm going to vote in support of this legislation, although I got to tell you, adding that onto this agenda and having us voting on it at 11:15 on a Friday night, it's a little disturbing. It brings back, I think, probably like 7 or 8 years ago, I remember being in the House, and it was like 2 in the morning, and we were sitting around waiting for the majority to come up with some bill that they were going to bring out, but it wasn't ready, quote unquote. And they were bringing out, I think we made the state medal was titanium or something that night. And I remember talking about it at like 1 or 2 in the morning. I hope that's not what this bill becomes, the distraction to keep people busy late some future evening. Just tonight. Yeah, maybe just tonight. Anyway, I will support this legislation, even though I am a little more biased towards the leopard frog than the spring peeper, but I'm gonna roll with it just the same. Thank you.
Thank you, Senator. You'll have to fight it out with Senator Berthel. Further questions or comments on the bill? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 38 of the agenda, House Bill number 5534, an act designating the state as the birthplace of the Boys and Girls Club of America, the state amphibian, the town of Enfield as the gateway to Connecticut, and the state rock. This is JFS to the floor with LCO number 3487. Senator Flexer?
Yes.
Representative Blumenthal?
Yes.
Senator Honig?
Senator Honig votes yes.
Representative Morin Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is yes.
Representative Mastro Francesco?
Yes.
Representative Bronco?
Yes.
Representative Carpino? Representative Fonsello?
Monticello votes yes.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa? Representative Johnson?
Representative Johnson votes yes.
Representative Menapace?
Yes.
Representative Rosario? Representative Santiago?
yes,
Representative Shannon?
Yes.
And Senator Winfield.
Winfield in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next item on our agenda is item number 39, House Bill 5543, an act concerning certain revisions to the aggregate and individual contribution amounts under the Citizens Election Program. This is a JF to the floor. The chair will entertain a motion. Moved by Senator Flexer, seconded by Representative Osborne. This bill amends the inflationary adjustments, or amends the timing for when the inflationary adjustment for CEP qualifying contributions must be done. To eliminate a gap that currently exists and eliminates inflationary adjustments for aggregate funding raising amounts and sets new base and amounts and levels. Any further questions or comment? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 39 of the agenda, House Bill number 5543, an act concerning certain revisions to aggregate and individual contribution amounts under the Citizens Election Program. To be JF to the floor. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson? Representative Mastro Francesco? Yes. Representative Bronco? Yes. Representative Carpino? Yes. Representative Fonsello?
Monticello votes yes.
Representative Gauthier?
No.
Representative Haddad?
Haddad votes yes. Haddad votes yes. There we go.
Thank you. Representative Hoxa? Representative Johnson?
Representative Johnson votes yes.
Representative Menapace?
Menapace in the negative.
Representative Rosario?
Representative Rosario in the negative.
Representative Santiago?
yes,
Do you mind repeating that, Representative?
yes,
Thank you. Representative Shannon?
Yes.
And Senator Winfield.
Winfield in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next on our agenda is item number 40, House Bill 5544, an act allowing municipalities to hold municipal elections in conjunction with state elections. This is a JF to the floor. The chair will entertain a motion. Moved by Senator Flexer, seconded by Representative Morin Bello. This would allow towns to hold municipal elections on the even years if they so wished. All right. Seeing no further comments or questions, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 40 of the agenda, House Bill number 5544, an act allowing municipalities to hold municipal elections in conjunction with state elections. To BJF to the floor, Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson? Representative Mastro Francesco? Yes. Representative Bronco? Yes. Representative Carpino? Yes. Representative Fonsello?
Monticello votes yes.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa? Representative Johnson?
Representative Johnson votes yes.
Representative Menapace?
Representative Menapace also votes yes.
Representative Rosario? Representative Santiago,
yes,
Representative Shannon,
Yes.
and Senator Winfield.
Sorry, I couldn't get my mic on. Senator Winfield, in the affirmative.
Thank you, Chair.
Rosario in the affirmative.
Oh, we got it. Thank you.
Thank you, Madam Clerk. Next up is House Bill 5545, an act making a technical change concerning a campaign contribution limit. Chair will entertain a motion.
Second.
Moved by Senator Flexer, moved by Representative Osborne. This bill does what it says. It makes a technical change concerning campaign contribution limits.
Thank
President
you.
Mastrofrancesco.
Thank you, Mr. Chairman. Yeah, just as a for reference for our side of the aisle here, that the only technical change in this bill, it takes the word "that" out and replaces it with "such." And those are placeholder bills that you can spot a mile away. So I'll be a no on that today. Thank you, Mr. Chairman.
Thank you, Representative. Further question or comment from the committee? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 41 of the agenda, House Bill number 5545, an act making a technical change concerning a campaign contribution limit. To be JF to the floor, Senator Flexer. Yes. Representative Blumenthal. Yes. Senator Honig.
Senator Honig votes yes.
Representative Morin-Bello.
Yes.
Representative Osborne.
Yes.
Senator Sampson. Representative Mastro-Francesco. No. Representative Bronco. No. Representative Carpino. No. Representative Fonsello.
Moncello votes no.
Representative Gauthier.
Yes.
Representative Haddad.
Haddad votes yes.
Representative Hoxha. Representative Johnson.
Representative Johnson votes yes.
Representative Menapace. Yes. Representative Rosario.
Representative Rosario in the affirmative.
Representative Santiago.
yes,
Do you mind repeating that, Representative?
yes,
Thank you. Representative Shannon
Yes.
and Senator Winfield.
Winfield, in the affirmative.
Thank you, Chair.
Thank you, Madam Clerk. Next up on our agenda is item number 42, House Bill 5546, an act concerning campaign finance laws, statutorily recognize indigenous tribes and security for candidates, their families, and their campaign staffs. This is JF to the floor. The chair will entertain a motion.
Second.
Moved by Senator Flexer and is that Representative Gauthier with the second. This bill redefines state contractor under our campaign finance law to account for the fact that certain tribes have roles and agreements with the state largely to affect certain DSS or DCF functions within the tribal areas that under the current definition could be interpreted as a state contractor, and that it is obviously not the intent of the campaign finance law to capture those contracts under the state contractor definition. Also would allow candidates to make expenditures for personal security services for themselves and their family. And that is the bill. Questions or comments on this bill? Representative Mastrofrancesco.
Thank you, Mr. Chairman. So currently, right now, the tribes cannot donate to a political campaign. Is that correct?
To you, I think it would be more accurate to say it is not clear whether they can, and they are wary to do so. Or, yes, to you.
It's not clear if they can. Well, have they? I mean, this had to come from somewhere. I'm a little confused to you.
I'll refer you to Senator Flexer will give you a little background.
Thank you, Mr. Chair. To the good representative, you may remember that last year a tribe came to us and said that they had their leaders were not were designated as state contractors by the State Elections Enforcement Commission, and they came to us asking that their elected leaders be treated like a chief elected official for a municipality, right? So the municipalities sometimes have contracts with the state of Connecticut. The tribes sometimes have contracts with the state of Connecticut. They want their chiefs essentially to be treated the same way a chief elected official is in a city or a town.
Okay.
So the same way that my mayor can give me a campaign contribution and not be called a state contractor, they want a tribal leader to be able to make a contribution and not be considered a state contractor.
Okay, got it. So, but they are getting funding from the state of Connecticut. Is that correct? They have to be getting some type of funding, whether they do work or, I would say
Well,
they're not getting anything.
I think it goes both ways,
No,
particularly with the tribes. Whereas
Totally.
the municipalities, they just get money from the state of Connecticut, which is wholly appropriate, don't get me wrong.
Right. So they are getting contract, as opposed to just a family member, somebody, a friend of yours, maybe has their spouse works for a company that is a contractor for the state of Connecticut, and they cannot contribute.
That's actually not quite accurate. If they own the company, if they're the principal of the state contractor, then they can't contribute. But if they just work for a company that happens to have a contract with the state of Connecticut, they certainly can contribute.
Right. Okay, and then there was another section to this bill, Mr. Chairman, you were talking about.
Yes, this is actually very similar to another bill we passed earlier, which it allows campaign expenditure for security services for a candidate or their family or campaign
for
staff.
our candidates, or does this have anything to do with the tribes?
No.
So it's the language is in there in that bill. It's duplicated in this bill for the purpose of if one passes, maybe the other one won't pass.
To you, yes.
Yeah. Okay. Okay. I'm not satisfied with this bill today, especially with the contributions from the tribes, and its duplication of the security for a candidate is duplicated in this bill, which we already did. So I'll be a no on that today. Thank you, Mr. Chairman.
Thank you, Representative. Further questions or comments from the committee? Seeing none. Madam Clerk, will you please call the roll?
This is a roll call vote on House Bill number 5546, an act concerning campaign finance laws statutorily recognize indigenous tribes in security for candidates, their families, and their campaign staffs. This is to be JF to the floor. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is no.
Representative Mastro Francesco? No. Representative Bronco? Yes. Representative Carpino? Yes. Representative Foncello?
Moncello votes no.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa? Representative Johnson?
Representative Johnson votes yes.
Representative Menapace? Yes. Representative Rosario?
Representative Rosario in the affirmative.
Representative Santiago?
Yes. Yes.
Thank you. Representative Shannon?
Yes.
And Senator Winfield.
Winfield in the affirmative.
All right, thank you, Chair.
Thank you, Madam Clerk. Next on our agenda will be item number 47, House Bill 5555, an act expanding the address confidentiality program of the Secretary of the State. There's a JFS to the floor of LCO number 3492. The Chair will entertain a motion.
So moved.
Second.
Moved by Senator Flexer, seconded by Representative Gauthier. This bill expands the address confidentiality program of the state, of the Secretary of the State, to allow certain reproductive rights providers to apply. Further question or comment on the bill? Representative Master-Francesco? Who was it? Senator Sampson.
Thank you very much. Mr. Chairman, can you just repeat what you just said and explain for us in layman's terms who's being protected under this proposed legislation through you?
To you, certain healthcare providers who provide reproductive healthcare services in the state would be allowed to apply to the address confidentiality program of the Secretary of the State. They would be added to the categories of people allowed to you. No, we're not on that bill.
Thank you very much, Mr. Chairman. We have so many similar bills that address address confidentiality this year. I remember back in the good old days a couple of years ago where we just have the Attorney General's office would come and maybe we'd get one that says we should remove teachers' addresses from FOIA. And now we have this plethora of people like signing up. Where do I go? How can I get on the list? Please hide my address from the public as well. And this one is a very interesting one because this one is hiding the addresses of gender-affirming healthcare services professionals. I appreciate the chairman using the very loose term healthcare provider, since I don't think anyone that's involved in gender-affirming healthcare services could be classified as a healthcare provider. And I think that the folks that are engaging in that activity, many of them ought to be convicted of crimes, frankly, for some of the procedures that they perform on minors. The idea that somehow we would aid and abet those activities by creating a policy that hides their addresses, to me, is an absurdity, and I have no interest in that. Is there something else in this bill, Mr. Chairman, about our university system, or is that a different bill I'm thinking of? Through you.
To you, that's a different bill.
Okay, Mr. Chairman, I guess that's all I have to say on this particular bill. And thank you very much. I'll be definitely voting no. Thank you.
Thank you. Senator, Representative Carpino.
Thank you. I just have some technical questions, Mr. Chairman. To you, in the definitions of this bill, would this include any healthcare provider providing any type of reproductive health services? And I can be more specific. So would that include any general practice physician, any family care physician, any pediatrician who's offering birth control or providing exams to young women? I'm just trying to understand the population of healthcare providers we're talking about. To you, sir.
To you, Representative, the answer is yes. Anyone who fits under the definition of reproductive healthcare services would qualify. Massachusetts passed a similar bill recently, and they had fewer than a dozen apply. So okay. The uptake is relatively low, but it does cover the entire definition to you.
Thank you. So if I look through the Commonwealth's legislation, I'll be able to find an expansive list of every healthcare provider so I can better understand it's covered?
Yes. Yes, the Massachusetts legislation has similar definitions to you.
Thank you. My concern is not the type of care that's being provided, but simply just another very large group of individuals that we're looking to shield. So I'm going to object on that mindset. Thank you, sir.
Thank you, Representative. Further question or comment from the committee? Seeing none, Madam Clerk, will you please call the roll?
This is a roll call vote on item number 47 of the agenda, House Bill number 5555, An act expanding the address confidentiality program of the Secretary of the State. This is a JFS to the floor with LCO number 3492. Senator Flexer? Yes. Representative Blumenthal? Yes. Senator Honig?
Senator Honig votes yes.
Representative Morin-Bello?
Yes.
Representative Osborne?
Yes.
Senator Sampson?
Sampson is a no.
Representative Mastro Francesco? Representative Bronco? Representative Carpino? Representative Moncello?
Moncello votes no.
Representative Gauthier?
Yes.
Representative Haddad?
Haddad votes yes.
Representative Hoxa? Representative Johnson?
Representative Johnson votes yes.
Representative Menapace?
Menapace in the affirmative.
Representative Rosario?
Representative Rosario in the affirmative.
Representative Santiago?
Santiago, yes.
Representative Shannon?
Yes.
And Senator Winfield.
Winfield in the affirmative.
Thank you, Chair.
All right, and that will complete our agenda for this evening. We had mercy on you, just barely. And Senator Flexer?
Thank you, Mr. Chair. If it's appropriate, I will advise members that we'll be together again on Monday at noon. Hopefully, most language for bills that we will have on an agenda for Monday will be things you already have, and there's only a few other outstanding things, so hopefully we won't have as much. We'll have plenty of time to read language. And the other thing I wanted to say was happy almost birthday to Representative Haddad.
Happy birthday.
Can we sing, Madam Chair?
I
Yeah.
think we could, yes.
Happy birthday to you. Happy birthday to you.
Happy birthday.
Dear Representative Haddad. Happy birthday to you. And many more.
That's very kind of you, but don't think it makes up for this meeting.
Touche.
Thank you,
All
Mr.
right.
Chair.
Thanks, everyone.
We gotta hold votes open.
Oh, we got to hold votes open until, we're going to hold votes open till midnight or until the votes are taken, because it's going to take a little while, I think, for people to catch up. So, till at least midnight or until the votes have been, the continuous votes have been collected. I think, so, thank you, everyone.
Think
Votes
so.
are open,
But give me
as
1
previously indicated, and everyone have a good night.
Easier to sit over here, Abby?
Yeah.
I'll go clean while you sit over here.
Yeah, yeah. Yeah, I'm gonna sit here. Okay, the rest were the. You're all set. All set. All right. For those of you online, I'm just gonna go and. Oh, I'm gonna record one person that's in person, and then I'll just go in the order that's on Zoom. Oh, all right. We'll start with Representative Rosario.
Yes, I'm ready.
and I'm gonna go in backwards order just because the way this is set up.
No
So I
problem.
have you for item 47. I have you for item 42 and 41. 40. All right. So for item 38, how do you vote?
In the affirmative.
All right. Item 37.
In the affirmative.
Item 36.
In the affirmative.
Item 35.
In the affirmative.
Item 34.
In the affirmative.
Item 32.
In the affirmative.
Item 31.
Yes.
Item 30.
Yes.
29.
Yes.
28.
Yes.
27.
Yes.
26.
Yes.
25.
Yes.
24.
Yes.
22.
Yes.
21.
Yes.
19.
Yes.
18.
Yes.
17.
Yes.
16.
Yes.
12.
Yes.
10.
Yes.
9.
Yes.
8.
Yes.
7.
Yes.
5. Or sorry.
Yes. Oh,
Sorry. 6.
yes.
And then 5.
Yes.
All right. Give me 1 second. Amendment. Oh, House Bill 5001, I believe that's item 4.
Uh, yes.
Or
Only
sorry,
to get,
5001. Yeah.
voting yes, only to get it out of committee.
Okay.
I have some concerns on it. But
All right. Amendments. And then SJ 37, so item 1.
yes.
And that is it. Thank you.
Thank you for your patience. Thank you.
Of course.
Have a good night.
All right. Next I see Representative Johnson. Can you hear me?
Yes, I think Rep. Santiago was first. So
okay.
I'll throw to her. Yeah. Thank you.
No problem.
Thank you, Dominique.
All right.
Gotta see which one.
I'm gonna start at the, from the back.
You hear what Rosario had doubts about?
I think it was item 4, 5001.
Okay.
That,
Oh, I think,
Right.
never mind, I know what that's about.
he said just to get it out of committee.
Yeah, I think he thought there was something in there that's not. Because we had it.
Yeah, but you'll let him.
We'll talk.
Yes.
All right, Representative Santiago, how do you vote on item 28,
Yes,
item 27,
yes,
item 26,
yes,
item 25,
yes,
item 24,
yes,
item 22,
yes,
item 21,
yes,
item 19,
yes,
item 18,
yes.
for that one, so
She was on all the other ones, I believe.
let's double check while she's here. There has to be a. All right, Representative, you are all set. Thank you.
That was it?
Yep. You are here for the rest.
Okay, thank you. Have a
No
good
problem.
night.
You too.
Sorry about my voice.
No worries. Feel better.
Thank you.
Thanks, Aldo.
Thank you.
Of course.
What else we have?
All right,
All right.
thank you.
Thank you.
Of course.
Did you leave papers here?
I
Those
know,
are,
not anticipated, and not how you
You
anticipate.
can have them.
So,
You want
I
one?
appreciate
What are you looking for?
Of course. Anytime.
Oh, I didn't take any over there, but what did you have, an agenda?
Yeah.
You want another?
Right,
agenda?
Representative Johnson?
Not yours. I
Yep.
have one.
Do you
Thank you.
do you happen to remember which ones you missed? I'm gonna go through quickly though.
I think I just missed item number 1, but I'm not 100% sure on that.
Okay,
Maybe didn't Michael Shannon didn't pick it up, right?
All right. Thank you. Thank you all.
Thank you.
Thank you.
Drive safe.
drive safe.
You had notes? Did you have a bag?
I just had an agenda. Not yet. I said I would provide it if I work. I have to have it.
Let's make sure.
Sometime. No, you're good. Thank you.
Yep, so number 1, SJ 37. How do you vote?
In the affirmative, please.
All right, you are all set. Thank you.
That's it? Okay,
Yep.
thanks. Have a good weekend. Thanks, Claire.
You too.
Bye.
Bye. All right, next I see Representative Foncello.
Hi,
Hello.
how are you?
Good, how are you?
Good, good.
So I know you left us, were you here for the whole meeting before you left us?
Yeah, I think I ended up on 28, but just check that one.
Oh, that's good. All right, looks like first one I don't have you for is item 31.
Do you have me for 29 and 30? I'm not sure I was there for those.
Yeah, so I'm sorry, my apologies. My list is backwards. So the last one is 31 here, but I don't have you for 30 and 29 as well.
Okay, then we can check 32 and 33 also, just to make sure.
Yep.
So 29 to 33. I was running out, so I must be close.
Oh, so we put a hold, there was a hold on 33.
So no votes on that one?
Yep, but I do have you for 34. So the latest one I don't have you for is 32.
Okay. You ready?
Yep.
Okay, that's 32, no.
Yep.
31,
Yep.
no. 30,
Yep.
no. 29,
I have you for that one, but I have you in as a no for that.
yes. And you have 28 also then, I guess.
As a no on 28?
Yep, yep.
All
Okay,
right.
that may be all of them.
Yep.
Okay, thank you.
Thank you.
Have a good night.
You too. Hello, Senator Winfield.
Good evening, well, morning.
How are you?
I'm all right. How are you?
Good, tired, but we're almost there.
Yeah, it's part of how this works,
Oh,
unfortunately.
yeah. We live close, so we're the sacrificial lambs here.
Okay, good.
All right. Do you happen to remember which one you didn't vote for?
Mine were in the beginning. I just don't remember how many in the beginning I didn't do.
So there were a string of amendments. Okay, so it looks like I just don't have you for number 1, SJ 37.
That's a yes.
And then let me just double check real quick. Yeah, so I've got you for some of the amendments for 5,001. So it looks like you
Yeah,
are all set.
I never left after that. Yeah. All right. Have a great evening, morning.
You too.
All right. Bye-bye.
Bye.